Good morning, Excellencies, distinguished participants. Good morning. Apologies for the delay. We're waiting for His Excellency, the Minister of the Republic of Senegal, this country. We're just going to give him a few more minutes. He's stuck in traffic. We understand, but he'll be here shortly. We apologize for the delay. Thank you very much for your understanding. Thank you. Good morning again, Excellencies, distinguished participants. Shall we please rise for the anthem of the African Union, followed by the national anthem of Senegal? Let's remain standing, African Union, please. Your Excellency, Biam Souleye Diop, Minister of Energy, Petroleum and Mines of the Republic of Senegal, the host country for this event. Honorable Idrissa Sow, Chairperson of the African Commission on Human and People's Rights. Your Excellency, Ambassador Willie Nyamitwe, Chairperson of Representatives Union and Chairperson of the PRC Subcommittee on Human Rights, Democracy and Governance. Honorable Sultana Leadership and Chairperson of the Group on Extractive Industries, Environment and Human Rights Violations in Africa, the convener of this forum. Honorable Liz Musimi, member of the and Vice Chairperson of Extractive Industries, Environment and Human Rights Violations in Africa. Ms. Denise Gere, representative Society Foundation. IT, can you please help me with the Mr. Dennis Gere, representative of Open Society Foundation, the development partner supporting this event. Excellencies, representatives of AU organs, Excellencies ambassadors, Excellencies representing various international organizations here, distinguished representatives of civil society, national human rights institutions, the academia, and diverse stakeholders in this room. Good morning to you all, and welcome to the land of Teranga. My name is Abiola Idowu, and I'll be moderating the opening ceremony for this forum. I warmly welcome you all to this 5th edition of the Continental Forum on Extractive Industries, Environment, Business, and Human Rights in Africa. Conceived in 2018 by the Working Group on Extractive Industries of the African Commission on Human and People's Rights under the leadership of Honorable Commissioner Solomon Ayele Derso, Chairperson of the Working Group, and inaugurated at the 73rd Ordinary Session of the ACHPR in October 2022, This forum has taken place over the years within the framework of the sessions, the statutory sessions of the African Commission on Human and People's Rights. Today, the forum and the fifth edition is being convened as a standalone and expansive platform as it was conceived and as it should be, with support from Open Society Foundation, which is acknowledged with gratitude. Today's convening format allows for the time, the depth of conversation, and the diversity of stakeholders required for a forum of this nature, one that aims to serve as a continental platform of peer learning and knowledge exchange towards advancing a human rights and people-centered approach to the exploration of natural resources, trade exchanges, business operations, and economic processes in Africa at large. This forum and fifth edition is being convened under the theme, Advancing Responsible Extractive Governance in Africa in the context of the global rush for critical minerals, insights from 40 years of promotion of the African Charter. It is both an honor and a privilege to serve as your moderator for this opening ceremony as we gather here in Dakar at a defining moment, one that calls for reflection, but more importantly, decisive action. This forum is being held within the broader commemoration of the 40th anniversary of the African Charter on Human and People's Rights, a cornerstone instrument affirming the rights of peoples over their natural resources and to a satisfactory environment. The African Charter was adopted 45 years ago in Nairobi, and 40 years ago in 1986, the Charter became a living instrument with the 15th ratification. And today, as we reflect on the commemorative events that I've referenced, and as Africa continues to navigate the opportunities and pressures arising from global demand for critical minerals, the need to anchor extractive governance in human rights principles has never been more urgent. I will now turn to my responsibility of moderating this event and inviting the key speakers who have been designated to speak at this ceremony. Your Excellencies, it is my distinct honor to invite Honorable Commissioner Solomon Ayele Derso, member of the African Commission on Human and People's Rights and chairperson of the Working Group on Extractive Industries, Human Rights, and the Environment in Africa, and the convener of this forum, to deliver his welcome remarks. You have the floor, Commissioner Derso.
Bonjour. Good morning. I'm very delighted to stand before you to welcome each and every one of you to this fifth Continental Forum on Extractive Industries, Business, Environment, and Human Rights in Africa. Let me start off by expressing gratitude. In my culture, one of the things that we need to do is really to express gratitude. So I would like to start off by thanking the members of the Secretariat of the African Commission on Human and People's Rights, led by the Secretary of the Commission, Madame Abiola, for the stewardship that made the convening of this forum possible. I'm deeply grateful to you personally, Abiola, as someone who has been there along with me in the work that we have been doing with respect to the extractive industries. So I wish to thank everyone in the Secretariat. Let me go to the formal speech. Distinguished representatives of the states parties to the African Charter on Human and People's Rights present here, Your Excellency, Brian Diop, the Minister of Energy, Petroleum Mines, and representative of the government of Senegal. I wish to acknowledge your kind presence here with us as an expression of your confidence, but also the confidence of the government of Senegal in the importance of the subject matter of this forum for Africa at this particular point in time. And thank you for being with us. I wish also to acknowledge with appreciation the chairperson of the African Commission on Human and People's Rights, Commissioner Idris Hasso, who at this point in time is chairing our commission as the commission marks its 40th anniversary. And we do hope that this 40th anniversary would provide us much more opportunity in order to really demonstrate and highlight the distinguished work carried out by the African Commission. Your Excellency Ambassador Willy Niamitwe, the permanent representative of the Republic of Burundi to the African Union, and the chairperson of the Permanent Representatives Committee of the African Union for 2026, and interim chairperson of the PRC Subcommittee on Human Rights, Democracy, and Governance. We are very delighted for your presence here as chair of the PRC. And indeed, Ambassador Willy, this forum, we don't want it to end here in Dakar. We would like you to carry the message of this forum to the African Union, to the policy organs of the African Union, and as Abiola mentioned earlier on, we would like actions being taken. And therefore, your presence here is also not just a privilege, but also a responsibility that I know personally you are capable of discharging. Thank you for your presence, Ambassador. I would like to also acknowledge the Vice Chairperson of our working group, Commissioner Lita Musiami Ogana. Commissioner, you are welcome. Mr. Dennis Gary, representative of our partner, the Open Society Foundations, which made the convening of this 5th anniversary of the forum, importantly with a particular focus on critical minerals possible. So we thank you, Dennis, for your presence. Please convey our deep gratitude and thanks to all your colleagues at Open Society Foundations and distinguished representatives of African Union organs and institutions. Here I would like to acknowledge our distinguished sister, Justice Stella, from the African Court on Human and People's Rights. Thank you for your presence, Justice. She was on the other side of the aisle. She knows this file very well, representing Nigeria. And we are happy that she is here representing the African Court on Human and People's Rights. I wish to acknowledge the representative of also the African Committee of Experts on the Rights and Welfare of the Child present here, and all others present here. Ladies and gentlemen, I think it's important to acknowledge that we are in a particularly historic moment. I would imagine that when the history of this decade, the 2020s, is written, it would be written as a time when centuries changed, literally. It's not in 2000 that the century changed. It's now, during this decade, because this is a decade into which many profound global events have happened and packed. And the African Commission has been there with the COVID-19 pandemic. Once in a century event, we were there at the African Commission. We were the first international human rights body to take action and to make a pronouncement, even before the WHO actually made a pronouncement on it in February 2020. As the world speedily shifts towards new source of energy, new technology, we are now witnessing another major shift that brought the continent at the center of one of the fiercest geopolitical contestation. And that is the rush for sourcing, controlling the source, marketing, and supply chain of critical minerals. And Africa, once again, is at the center of this geopolitical contestation. And we need to ask difficult questions. We have heard for a long time that Africa contributes nothing to global trade. And I often ask myself, if Africa contributes nothing to global trade, why not let hands off Africa? And then let's see if the world survives without Africa. And we know for sure that no one would let hands off Africa because this is the continent that powers the global economy through the resources that it supplies. And just ask yourself how big the resource industry is in the world. And then ask yourself how much of that is actually from this continent. It's only that kind of analysis that would enable you to understand the special place that Africa occupies in the world. And I think we are now in a moment when some of these are being really documented as part of the mainstream knowledge production. And we came to see this with the publication of recently a book called Born in Blackness, how Africa actually is the place that gives birth to modernity as we know it. And it's here, through resources, that this process started actually. Here in West Africa, for that matter, in the encounter between Africa and Western powers, who came to this part of Africa looking for gold. The rush for gold evolved into the rush for what? The scramble for Africans. Before the scramble for Africa, there was the scramble for Africans, the slave trade, and the scramble for Africa itself, its total control, all of which is associated with and premised on the recognition that this is the continent where there is a lot of richness. I think part of the point I'm making is that this is a continent of such incredible richness, but paradoxically, this is a continent that's not enjoying the benefit of this richness. Why? Because of the kind of extractive relationship and system that has been put in place. So we have a lot of issues that we need to discuss in the course of this, that I'm happy all of you are here. And part of what we need to do, honestly, is to ask difficult questions and make a determination of how we go from here. There are problems of relationship. If you look at the African Charter on Human and People's Rights, one of the things that I really find, I mean, you may call me that I am biased towards the charter because it is ours, but one of the things that makes this charter distinctly unique is its recognition of the fact that human rights, people's rights, cannot be accessed and enjoyed and exercised in a vacuum. That they can be accessed, enjoyed, and exercised only in a particular historical, political, and economic conditions and circumstances. It is this embeddedness in history, in economic, political, and social context that makes it distinctly unique. And one of the things that it does is basically recognizing that natural resources is profoundly at the heart of shaping the destiny, the well-being, and indeed, ultimately, the dignity of people on the African continent. Now, I invite you, and I can go to speak about this with a passion for a long time, but I'll invite you to do one thing. Read through the African Charter on Human and People's Rights. And one of the things that you will find is basically that this article, that is Article 21 of the Charter, is the longest article of the provisions of the Charter, with 5 sub-provisions. Now ask yourself, why would the authors of this Charter, and Senegalese are responsible for it, because it was Judge Kebambai, who was at the heart of the drafting of this thing. Why did he deem, and why did they deem it necessary to give these extensive coverage to the right of what they call all peoples to freely dispose of their wealth and natural resources? Why did they deem it to give such an expansive coverage to this one? And we have to appreciate their understanding of history as it relates to this continent, but also their foresight about the future that is associated exactly with natural resources. So resources turned into not blessings that they are supposed to be on the African continent. More often than not, they turned into a curse. In the current context of the rush to critical minerals, the question we ask is, are we going to experience once again, quote unquote, critical minerals? We have to ask, for who are they critical, right? So-called critical minerals, we have to ask, once again, are they going to be the source of curse rather than the blessing that they are supposed to be? And what responsibility do we, this generation of people, bear to make that not happen? Because our forebears, because we are celebrating 40 years, I have to mention this. President Senghor of Senegal, Judge Mbaye, and others, they delivered their side of the responsibility. And I will quote here Fanon. Each generation has to find its own purpose. And I think our purpose is to change this equation, this paradox. Africa is rich, but its people live a life that is stripped of dignity, despite the richness of the continent. How can we change this around and have better future, if not for us, at least for the generation that follows, at least for our sons and daughters? With that, I would like to once again thank each and every one of you for your kind presence, and I look forward for the rich exchange that we will have, including not just in terms of diagnosing the problem. I think the most important thing that Abiola said is in terms of actions and solutions. All right? And there we need to do a lot of work. One of which is to ensure that there are actually legal and institutional mechanisms at the national level that fulfill compliance with the standards of the Charter. But we also need legal and institutional mechanisms at the continental level that would provide additional layer for states, other shield that they use in their negotiations with these powerful actors. These companies that operate in the extractive industries are incredibly powerful. Their resources is much wider and deeper than the capacity and resources of our individual states. That's why we need the collective action of states. And I think it's important in this time and age. That is where I will end. Yesterday, we saw a report from Zambia where the Minister of Foreign Affairs of Zambia is quoted as saying, Zambia has rejected and stopped negotiation with the United States of America on financing. They were negotiating on health financing by the United States of America, about a couple of billions, because the United States required that the financing on health is coupled with a negotiation on critical minerals. Now, it's not the fact that there is a coupling that's the problem. If you read the terms of the negotiation on critical minerals, it is being signed in many countries, among which is the DRC, one of the richest on the continent, as you know. What does it require? It requires that these countries provide preference to companies from the United States. Basically, they narrow the scope of sovereign authority for countries. Countries cannot choose the best. They choose only from where? From a narrow. And then what else does it say? If for some reason a company from that country is not chosen, to whom? They can only give to companies from allied countries. What is it that we are living in? And we need to do an audit, Chairperson, Minister, an audit of these agreements, because these agreements are actually contrary to Article 21, subparagraph 1 of the African Charter. Because Article 21.1 says, all people shall freely dispose of their wealth and natural resources. This right, it says, shall be exercised in the exclusive interest of the people. In no case shall a people be deprived of it. And the implication of this is very clear. It's not the state that is the sovereign authority over natural resources. It is the people. It is the people. What that means is basically we need to engage in auditing the kind of agreements that are being signed, basically surrendering sovereign control over natural resources that belongs to the people. And that should be part and parcel of the conversation that we need to have. And we also need to discuss the kind of legal regime that needs to be established on the African continent. Because part of what's happening is that our states' hands are being tied. And when disputes arise on these matters, guess what? It's not to national courts that these disputes are taken. Where are they taken? To places outside of the continent. The price of our resources are not determined here on the continent. They are being determined elsewhere. So, ladies and gentlemen, we have a lot to discuss, and I'm very delighted to have you all here. And I do hope, as Abiola mentioned, that ours will not just be one of complaint and diagnosis and appreciation of the beauty of the problem, but one of really action. Thank you all very much again for your kind attention.
Thank you very much, Honorable Commissioner Solomon Ayele Derso, for your highly insightful, welcome remarks about a subject that you're so very passionate about. It is now my honor to invite Mr. Dennis Gir, representing Open Society Foundations, to make his statement on behalf of Open Society Foundation. You're welcome, Mr. Dennis.
Thank you very much. Good morning, Your Excellencies, the Honorable Minister, and all the existing protocols that have already been established. I would just stand on that to give a few remarks. As others have already indicated, this forum really comes at a very pivotal moment for Africa. And for us at the Open Society Foundations, and in particular, what we call the resources futures in Africa, which is looking at this issue of critical minerals. It is of particular importance because of the accelerating global rush that we are seeing and that Ambassador Solomon has already spoken about, and which I will not belabor. But crucially, it is a test of the continuous relevance and responsiveness of the African human rights system for us, and in particular the Charter, in governing contemporary forms of extraction and global value chains, including the competition that we are seeing across the world and some of the bilateral for us, which are deals that are really swinging the hands of Africans for our resources. And it's against this backdrop that it could not be more consequential or even timely to have these kinds of interactions as we are looking at strengthening regional instruments on business and human rights, advancing continental jurisdictions for accountability and dispute resolution involving multilaterals, and elaborate the general comment on the right to a healthy environment under Article 21, which Ambassador has already spoken about. We believe that this theme is really timely. From our perspective at the Open Society Foundations, our engagement on human rights and critical minerals has consistently surfaced a set of recurring and pressing concerns, and I'll just highlight a couple of them to help frame the discussions. For us, critical minerals has a potential to heighten the risks of human rights violations in very unique ways, and I'll highlight a couple of those. You know, the mining and processing of these minerals, most of which are hard rocks, really involve large-scale surface mining. And by surface mining, it means that the mining and processing of these hard rock metals, including bauxite, manganese, lithium, iron ore, you know, and all of those, will really produce, very varied implications. So for instance, if you even look at just the land considerations, some 6 tons of bauxite is required to produce just a ton of aluminum. And mining of bauxite, those 6 tons of bauxite will take place over a large parcel of land. As I indicated, this is surface mining. This often implies encroaching on fertile agricultural land, which is essential for food security and livelihoods. And sometimes it involves destruction of ecologically sensitive zones and even culturally sensitive areas. They are also chemically heavy, usually involving the use of cyanide in the processing, or sulfuric acid and other explosives and chemicals, which are also environmentally destructive and pose serious health risks, particularly if not properly disposed. And all of these are risks. But we have heard across the continent the need for Africa to add value to its resources. Again, we must be mindful that value addition comes with its own additional risk. Again, I'll highlight a couple of them. The refining of most of these minerals involve vast quantities of water. And as you may know, the Charter emphasizes the use of water in particular, but also energy and infrastructure. And these are resources that are equally central to the realization of economic and social rights, which are also protected under the Charter. For instance, in my previous life, I did a bit of work around lithium refining. And for a 20,000-ton lithium refinery, you would need about 800 million liters of water annually to be able to refine this lithium into concentrate and into battery. And this 800 million liters of water is the amount of water required by a community of 90,000 people to survive for that 1 year. And so adding value comes with additional risk, as I indicated. But it's not just water. On power, the average, again, on lithium refining facilities that we are seeing, both planned and existing refineries, require an average of 110 megawatts of power for a plant to operate efficiently. And this power, again, could provide sustainable energy for 40,000 people in a community. We know that over 600 million people are living without electricity, which again is a human rights issue. I could go on and on. If you look at infrastructure like rails and roads, for 3 different bauxite concessions, probably 200 kilometers apart, you require over 400 kilometers of railway and road network to be able to convey this bauxite to a refinery, a central point where you can process, smelt, and do all of the things and get your aluminum out of it. And so, and when we talk about roads, we are talking about transport networks, we are talking about rail, and this is an access issue for many people who depend on these transport channels to undertake economic activity and be empowered to survive. And so all of these issues are human rights issues. So these competing demands for me highlights a fundamental tension, which is that without safeguards, without monitoring, without proper planning of infrastructure that benefits both critical mineral value chains and the survival of citizens and people, we might end up diverting scarce public goods away from communities and undermining the very development rights that this charter seems to want to protect. And that, for me, is the first point I wanted to make. My second point is taking us further down the value chain. And so when you process your minerals, we will see a lot more investment in technology, laptops, data centers, all kinds of technological revolution that we are seeing on the continent. And again, I would like to highlight that these, again, pose another extra layer of human rights concerns. Many of us may think that these data centers are located in Europe, America, and elsewhere. But we are beginning to see the proliferation of data centers across the African continent. In South Africa alone, Honorable Minister, we have over 60 data centers existing at the moment. Why are these data centers important? The technological revolution, particularly artificial intelligence and cloud computing, is creating a new layer of demand for critical minerals because most of these depend on critical minerals, which have to be mined. But again, the operation of these facilities require a lot of energy, a lot of water, a lot of emissions, a lot of impacts that will impact communities at the end of the day. And so data centers, for instance, heavily rely on African extracted minerals, whether they are located in America or Europe or on the African continent. And expanding access across the continent and beyond will be crucial going forward. Some of these data centers consume up to 400 megawatts of power. I just cited the example of a lithium refinery consuming an average of 110 megawatts. Data centers will triple that, essentially. And so we are seeing another layer of impact on that front. Equally concerning is the water footprint. Large data centers can consume up to 5 million gallons of potable water, not seawater, not wastewater. It is the water that we need, fresh water, that these data centers also need because they need to be cooled. And to be cooled, you cannot use just any water. You'd have to use fresh water that has the capacity to cool facilities. And this 5 million, gallons of water I mentioned is enough to supply a town of 50,000 people again. And I like to center these around human lives. And so you hear me comparing to how many people can benefit from these streams. And so all of these developments, whether it's technology or critical minerals, is actually exacerbating an already stressed situation of, amenities, whether it's transport, energy, or water. And in a continent where access to, safely managed water remains uneven, and we've seen the UN Economic Commission for Africa report, which highlights that 44% access to actually freshly managed water is currently the case in Africa, in the urban sectors, but actually precariously lower in the rural areas of about 20%. And so this creates a new form of competition between human needs and technological needs. And we need to balance these. And it raises a profound equity and environmental justice concern, particularly when only 3% of water on Earth is fresh, and 1% of that 3% is actually drinkable. And so what do we do? I heard Ambassador Solomon speak about solutions, and so we have to be a bit focused on solutions, and I intend to do exactly that in the last 2 points. So responsible extraction and governance is actually not obtainable without the private sector. And that is where I believe that the Charter's recognition of business and human rights is important. But of course, there are other instruments that will further build these provisions out. And so placing the private sector at the center is important, particularly in the context of mining. And when we talk about the private sector, most of the time we tend to talk about the big multinationals. But in the mining sector, small-scale operators are also significant components of the private sector and also have the capacity to perpetrate, or if actually they are not already perpetrating, some of the injustices and human rights violations that we see. We can talk about Galamsey in Ghana, which is, polluting a number of water bodies and actually taking over forest reserves, even though we know there are efforts to deal with that. But corporate actors, whether small or big, will not always voluntarily act in the interests of the people because they are after profit. And so we see a bit of a vacuum there. And I'm happy you already recognize that vacuum in the law. And justice is here. The court has also quite recognized this vacuum in many cases. And so the cases of corporate recklessness, particularly in the extractive sector, is resulting in pollution, health risks, and sometimes even death. And we see all of these replete on the continent, from Point Noir in Congo to Kabwe in Zambia, Zamfara in Nigeria, Mombasa in Kenya. We have seen cases of lead poisoning and all kinds of poisoning associated with mining and extraction in the continent. And so while the pursuit of corporate accountability remains far from being achieved, it is also important to recognize progress and some positive solutions that we are seeing. And I'll cite the African Court on Human and People's Rights September 2023 judgment on Trafigura. And for those of us who know Trafigura, this is one of the biggest traders. And somehow it operates across both the oil sector and the mining sector. And so it's quite present in the extractive sector, not just on the continent, but elsewhere. And so this case of waste dumping off the coast of Cote d'Ivoire represents a significant milestone in advancing accountability for corporate human rights violations. And we have to commend the court for that brilliant work that they did. But advancing responsible business conduct in line with regional and international human rights standards is therefore not optional. It is essential to ensuring that economic activity aligns with the norms and obligations enshrined in the African Charter and emerging African instruments on business and human rights. But one point I'll highlight before I take my seat is the issue of accountability. We still have a big gap, and that is where the solutions lie. The governance of critical minerals, for instance, demands enhanced accountability. Of course, we know that the emphasis has been primarily on the states as the enforcer of human rights. But increasingly, we are seeing pronouncements that show and that support the role of corporate actors. And not just corporate actors, but citizens and actually national courts to support the state in executing and ensuring the adherence to these rights. But we also know that states do not always act in the interest of the people, just like corporates. And we have to be bold to call out states when they do not act right. In fact, in some cases, we have seen states becoming facilitators and deploying political, legal, and military power to protect corporates. And it's important to tackle this issue as well. And therefore, effective accountability mechanisms, including the courts, regional institutions, emerging continental dispute resolution frameworks, are all essential to closing the gap between normative commitments and lived realities. Accountability must go beyond investigations and even beyond rulings, which are important, by the way, to responsibility, remedy, and actually holding actors accountable. And in the ruling of the court and other, mechanisms, including soft law mechanisms, which we'll be discussing later, we are seeing culpability at the personal level, duty of care, and such mechanisms, which all require that accountability moves beyond just holding people culpable and saying that they have violated to actually remedies that touch the lives of people who have been violated. And so as we close, I want to reflect and commend you for a decade of implementation of the Charter. But this forum challenges us that its principles remain not only relevant, but decisive in shaping Africa's future. And the rush for critical minerals must not come at the cost of dignity, equity, and justice. Rather, it must be governed in ways that affirm Africa's sovereignty, protect its people, and sustain its environment. And I think we have highlighted that. And so I'll conclude again with also quoting a section of the Charter, particularly the preamble, that emphasizes freedom, equality, justice, and dignity as essential objectives for the achievement of legitimate aspirations of the African people. Our task over the next 2 days is to translate these enduring values into concrete tools and institutions and practices that are capable of governing not just the extractive sector realities of the 21st century, but guaranteeing the rights of our people on the continent. And so I congratulate all of you for a 40-year run with such immense impact on the continent, but also to wish us very fruitful deliberations over the next 2 years. Thank you very much.
Thank you very much, Mr. Dennis, for your very insightful remarks, highlighting, among others, the cross-cutting human rights issues implicated in natural resource exploration, especially in the mining of critical minerals and related value chain processes, and your important recommendations, among others, about responsible extraction and closing the gap between the normative frameworks and human rights protection in relation to the actions of businesses. And this is what the Commission is doing. Commissioner Deso will be speaking about the Kilwa case, the interventions of the Commission under his leadership of the working group, as well as the guidelines on Articles 21 and 24 of the Charter. And this is also what is sought to be deepened and strengthened with the collaborations that will be fostered through platforms such as this. It is now my pleasure to invite His Excellency Ambassador Willie Nyamitwe in his dual capacities as the chairperson of the Permanent Representatives Committee of the African Union, as well as the interim chair of the committee, the subcommittee on human rights, democracy, and governance of the PRC. You're most welcome, Your Excellency. Thank you for always supporting us.
Excellence, Monsieur Birame Souleye Diop, ministre de l'Énergie, du Pétrole et des Mines, honorable commissaire Idrissa Sow, président de la Commission africaine des droits de l'homme et des peuples, honorable commissaire Solomon Ayele Derso et Dr Lita Musimi au Ghana, membre de la Commission africaine des droits de l'homme et des peuples, Monsieur Denis Mingpeng Gueyir, représentant de la Fondation Open Society, Mesdames et Messieurs les représentants des États membres de l'Union africaine, Mesdames et Messieurs les représentants des organisations internationales, Mesdames et Messieurs les représentants des institutions nationales des droits de l'homme, Mesdames et Messieurs les représentants des organisations non gouvernementales, chers invités, Mesdames et Messieurs, en vos rangs, grades et qualités, tout protocole observé, bonjour. Bonjour. Je suis le premier à parler français depuis ce matin, donc il fallait que je me... Hein? Vous savez, l'Afrique est souvent décrite comme un continent immensément riche, très riche en ressources naturelles. Oui, en effet, c'est vrai. Le seul problème est que nos ressources naturelles voyagent beaucoup, peut-être même plus que certains de nos citoyens. Elles ont toujours voyagé. Durant la période de l'esclavage, nos ressources naturelles voyageaient. Pendant la colonisation, nos ressources minières voyageaient. Et ces ressources empruntent toujours le même itinéraire. Quittent nos terres, on les amène vers le port et traversent l'océan. Et ces ressources s'en vont alimenter des industries et ces ressources vont contribuer à bâtir des villes modernes ailleurs. Pendant ce temps, chez nous, cette richesse s'extrait parfois au prix fort. Des vies perdues, des blessés, des violations des droits de l'homme et des communautés entières laissées en marge des bénéfices qu'elles contribuent pourtant à créer. Et l'ironie de l'histoire, c'est que nos jeunes, à leur tour, prennent la mer, souvent au péril de leur vie, pour rejoindre ces horizons façonnés en partie ou en grande partie grâce à nos propres ressources. Peut-être est-il temps que cette richesse qui connaît si bien le chemin du départ apprenne enfin à rester, à transformer, à profiter pleinement à ceux et à celles à qui elle appartient, dans le respect de leurs droits les plus fondamentaux, le droit à la vie, la dignité humaine, un environnement sain, la santé, la sécurité, ainsi qu'au droit des peuples à disposer librement de leurs ressources naturelles et à bénéficier équitablement des richesses qu'elles génèrent. C'est pour moi, et j'aurais dû commencer par là, un honneur renouvelé et un réel privilège de prendre part à ce forum régional de haute importance, consacré aux industries extractives, aux entreprises, aux droits de l'homme et à l'environnement en Afrique. Je me réjouis particulièrement que ces assises se tiennent dans cette prestigieuse ville de Dakar, République du Sénégal, grâce à l'engagement constant de la Commission africaine des droits de l'homme et des peuples à travers son groupe de travail sur les industries extractives, l'environnement et les violations des droits de l'homme en Afrique. Permettez-moi d'exprimer ma profonde gratitude aux autorités de la République du Sénégal pour l'accueil chaleureux et l'hospitalité exemplaire qui nous sont réservés. Le Sénégal, justement, le pays surnommé pays de la Teranga, incarne avec authenticité et cet esprit d'hospitalité, de générosité et de convivialité si profondément enraciné dans la culture Wolof est partagé à travers toute la région. Ce forum offre un espace essentiel pour réfléchir ensemble, échanger nos expériences et renforcer cette concertation. Excellences, Mesdames et Messieurs, l'année 2026 marque une étape significative pour notre continent, puisqu'elle commémore 45 années depuis l'adoption de la Charte africaine des droits de l'homme et des peuples et 45 années depuis sa mise en œuvre. La Charte africaine demeure une pierre angulaire du cadre normatif continental, affirmant notamment le droit des peuples à disposer librement de leurs richesses et ressources naturelles, ainsi que le droit à un environnement satisfaisant et propice à leur développement. Ces dispositions ne constituent pas seulement des garanties juridiques, mais des fondements essentiels pour une paix durable, la sécurité et le développement à l'échelle du continent. L'Union africaine souligne que la gouvernance des ressources naturelles, en particulier dans le secteur des industries extractives, est intrinsèquement liée au maintien de la paix et de la sécurité en Afrique. Si ce secteur demeure un moteur critique de croissance économique et de développement, sa mauvaise gestion a, dans plusieurs contextes, contribué à l'instabilité, au conflit et à la fragilité socio-économique. La persistance de déficits de gouvernance dans le secteur extractif, notamment le manque de transparence, l'insuffisance dans la mise en œuvre des réglementations, le partage inéquitable des bénéfices, la participation communautaire insuffisante continue d'alimenter des frustrations légitimes au sein des populations concernées. Et lorsque ces préoccupations ne sont ni entendues ni prises en compte de manière adéquate, elles peuvent évoluer en tensions localisées, en troubles civils, voire en défis plutôt sécuritaires d'une ampleur plus significative. Ainsi, ce que d'aucuns appellent malédiction des ressources demeure une réalité vécue dans certaines régions du continent. Excellences, Mesdames et Messieurs, l'Union africaine n'a cessé de souligner l'évolution rapide du contexte mondial marqué par une demande croissante en minéraux critiques, portée par la transition énergétique et les avancées technologiques. Si cette dynamique offre à l'Afrique des perspectives considérables pour accélérer son industrialisation et sa transformation économique, elle comporte également des risques accrus en matière de gouvernance, de durabilité et d'équité dans la gestion des ressources. Conscient de ces enjeux, et là, je veux répondre à mon frère, honorable docteur Solomon Ayele, président du groupe de travail, que le comité des représentants permanents, le COREP, que j'ai l'honneur de représenter ici, et le sous-comité du COREP aux droits de l'homme entendent s'approprier pleinement cette dynamique et l'intégrer de manière structurée dans leur programme de travail. À cet effet, j'ai l'honneur de vous informer que le groupe de travail sur les industries extractives, l'environnement et les violations des droits de l'homme en Afrique sera invité à faire un briefing à tous les membres du comité des représentants permanents de l'Union africaine afin d'éclairer les décisions et d'orienter les actions de manière concertée et stratégique. Excellencies, ladies and gentlemen, as highlighted at the outset of my remarks, the convening of this regional forum constitutes a valuable opportunity to strengthen The dialogue promotes mutual learning and share best practices among member states, national human rights institutions, civil society organizations, and other stakeholders. It provides a conducive framework for developing coherent human rights-based approaches to natural resource governance, thereby contributing to sustainable development as well as to peace and security across the continent. The African Union reaffirms that the management of natural resources must serve the collective interests of African peoples in line with the aspirations of Agenda 2063 by ensuring that the wealth that they generate supports inclusive growth, environment sustainability, and social cohesion. In this regard, the African Union calls upon member states and all relevant stakeholders to make full use of this regional forum to advance concrete commitments aimed at strengthening governance, ensuring the effective respect of human and people's rights, and reinforcing the link between natural resource management, peace, and security. I remain confident that the quality of our deliberations will not only deepen reflection on the challenges related to extractive industries, the environment, and human rights, but also enhance our understanding of the implications of the global rush for critical minerals for Africa. I thank you for your kind attention and look forward to the constructive outcomes that will emerge from our discussions. Merci. Thank you, Jerejeff.
Thank you very much, Your Excellency, Ambassador Yamitwe, for your valuable reflections on this topic and for the commitment of the PRC Subcommittee on Human Rights, Democracy, and Governance to integrate this issue of critical minerals and natural resource governance into your work and to collaborate with the Working Group on Extractive Industries, the Environment, and Human Rights in this regard. This is a significant step for mainstreaming and highlighting issue within the AU governance architecture. It is now my honor to invite Honorable Commissioner Idrissa Sow, Chairperson of the African Commission on Human and People's Rights, to deliver his welcome address to this meeting. Honorable Chairperson, vous avez la parole.
I want to first greet all of you and wish you a warm welcome to Senegal, land of Teranga. Now allow me to be the second who will speak in French after Ambassador William. Excellence, Monsieur le ministre Biram Souleye Diop, ministre de l'Énergie, du Pétrole et des Mines. Excellence, Monsieur l'ambassadeur Willy Nyamindoué, président du comité des représentants permanents de l'Union africaine. Honorable commissaire Salomon Ayele Derso, président du groupe de travail les industries extractives, l'environnement et les droits de l'homme de la Commission africaine des droits de l'homme et des peuples, chers collègues. Honorable commissaire Lita Moussini Ogana, vice-présidente du groupe de travail. Honorable Lady Justice Stella Anuka, I want to recognize your presence here and tell you welcome to Senegal. Mesdames et messieurs, les représentants des États membres, des institutions nationales des droits de l'homme et des organisations de la société civile, mesdames et messieurs, en vos rangs et grades respectifs. C'est avec un réel plaisir que je prends la parole pour partager quelques propos introductifs et vous souhaiter la cordiale bienvenue au Sénégal, pays de la Teranga, à l'occasion de l'ouverture du Forum régional sur les industries extractives,
les entreprises, les droits de l'homme, organisé sous l'égide de la Commission africaine des droits de l'homme et des peuples que j'ai l'honneur de présider. Je voudrais, à l'entame de mon propos, exprimer ma profonde gratitude aux plus hautes autorités du pays hôte, le Sénégal, ici représenté par l'honorable ministre de l'Énergie, du Pétrole et des Mines, pour avoir donné leur assentiment à l'organisation de ce forum à Dakar, mais surtout pour l'attention constante qu'elle porte au mandat de promotion et de protection des droits de l'homme confié à notre commission en vertu de la Charte africaine des droits de l'homme et des peuples dont nous célébrons cette année les 40 ans de l'entrée en vigueur. Permettez-moi d'adresser mes vives félicitations à l'honorable commissaire Aélé Derso et au groupe de travail sur les industries extractives pour avoir convié des experts et professionnels issus de divers secteurs autour d'une conversation de haut niveau sur les problématiques essentielles liées à la protection des droits de l'homme dans le cadre de l'exploitation des ressources naturelles sur notre continent. Mesdames et messieurs, le forum qui nous réunit a pour objectif principal d'asseoir les contours théoriques qui doivent guider nos actions pour une gouvernance responsable des industries extractives dans un contexte marqué par une frénésie concurrentielle et une ruée mondiale vers les minéraux critiques et les ressources naturelles. Le constat est établi que dans de nombreux pays africains, la coopération avec des sociétés transnationales constitue une source de revenus représentant une part substantielle des investissements directs étrangers qui, je précise bien, s'ils sont gérés de manière viable, durable et transparente, dans le respect des droits énoncés par la Charte, peuvent contribuer au développement socio-économique de nos pays. Cependant, nous savons tous que la situation sur notre continent laisse apparaître une réalité complexe dans laquelle les activités extractives, qui jouent un rôle essentiel dans la croissance économique, sont également associées à des défis persistants, notamment en termes de dégradation de l'environnement, dépossession des terres, flux financiers illicites et parfois violation des droits des communautés et des défenseurs des droits environnementaux. Il est manifestement admis que ces défis ne sont pas nouveaux, mais ils évoluent graduellement en fonction des variations sans cesse croissantes de l'intérêt porté vers les minéraux critiques et des positionnements stratégiques sur les ressources naturelles dont regorge le continent. C'est précisément en réponse à ces réalités que la Commission africaine a créé son groupe de travail sur les industries extractives, l'environnement et les droits de l'homme. Par son action, la Commission a cherché à approfondir la compréhension, à développer des normes et à promouvoir la responsabilité des États en tant qu'acteurs économiques. L'adoption de la résolution 550 sur les entreprises et les droits de l'homme a d'ailleurs réaffirmé notre engagement à promouvoir une approche du développement économique fondée sur les droits humains et à créer des plateformes telles que ce forum dédié au dialogue et à la réflexion sur ces questions qui, en aucun cas, ne peuvent être déconnectés des enjeux de développement auxquels nos États sont confrontés. Ma conviction profonde est que c'est par l'établissement d'espaces comme celui-ci, où se rencontrent des voix diverses, gouvernements, institutions nationales des droits de l'homme, communautés locales et sociétés civiles, que nous parviendrons à adresser efficacement les questions difficiles identifiées en la matière et à aligner les politiques et programmes au niveau national et régional sur les meilleures stratégies devant nous permettre d'atteindre le point d'équilibre entre la nécessité d'exploiter nos ressources pour financer le développement et l'impératif de préserver les droits des personnes et des communautés susceptibles d'être affectées ou impactées. Dès lors, la question fondamentale qui nous interpelle est celle de savoir comment l'Afrique peut-elle exploiter ses ressources naturelles, non pas comme source de conflits ou d'inégalités, mais comme moteur d'un développement inclusif et durable. Au cours des 2 prochains jours, l'objectif sera de répondre à cette problématique centrale en posant le curseur sur des interrogations sous-jacentes qui seront déclinées dans différents panels. Il s'agira ainsi de voir de façon concrète comment renforcer les mécanismes de responsabilité et les cadres réglementaires, comment garantir une participation communautaire significative et un partage équitable des bénéfices, et comment aligner les systèmes nationaux sur les lignes directrices de la Commission, notamment sur ses préconisations en faveur d'une gouvernance transparente, responsable et durable. Mesdames et messieurs, je voudrais conclure sur une note optimiste en constatant avec vous que l'Afrique se trouve à la croisée des chemins, en ce sens que ses ressources naturelles font l'objet d'une convoitise sans précédent. Si ces ressources sont bien gouvernées, et j'insiste là-dessus, il sera possible, sans aucun doute, d'accélérer nos ambitions de croissance déclinées dans l'agenda 2063, qui constitue le cadre de convergence de nos visions communes en matière de développement. Je saisis l'occasion pour réaffirmer la disponibilité de notre commission à poursuivre ses engagements avec les États parties, les INDH et les organisations de la société civile, afin que les ressources naturelles soient exploitées de manière vertueuse, de sorte à promouvoir le bien-être des populations, à protéger leur environnement et à garantir leur avenir. Je vous remercie pour votre aimable attention.
Thank you very much, Honorable Chairperson of the African Commission on Human and People's Rights, for your insightful statement and for your leadership overall of the work of the African Commission on Human and People's Rights in the promotion and protection of human rights under the African Charter. We now come to the highlight of the opening. It is my pleasure to introduce His Excellency, the representative of the host country in which this event is taking place, and also the government will be hosting the 89th ordinary session of the Commission in October this year. We thank you very much for your support, Your Excellency Biram Souleye Diop, the Minister of Energy, Petroleum and Mines of the Republic of Senegal, to deliver the statement of the host country and also to declare this forum officially open. Excellence, vous avez la parole. Bienvenue. Thank you, Excellency.
Mesdames, Messieurs les représentants des États partis à la Charte africaine des droits de l'homme et des peuples, Excellence l'ambassadeur Willy Nyamitwe, représentant permanent de la République du Burundi auprès de l'Union africaine et président intérimaire du sous-comité des comités des représentants permanents sur les droits de l'homme, la démocratie et la gouvernance. J'espère que je n'ai pas écorché le nom, Nyamitwe. Monsieur le Président et honorable membre de la Commission africaine des droits de l'homme et des peuples, le doyen, vous avez tous nos respects. Solomon, vous êtes mon homonyme parce que Soleil means Solomon. Yeah. Vous êtes mon homonyme donc. Mesdames, Messieurs les représentants des institutions nationales des droits de l'homme et des organisations non gouvernementales, chers invités en vos rangs et grades respectifs, Mesdames et Messieurs, j'ai l'insigne honneur, au nom du gouvernement de la République du Sénégal, de vous souhaiter la bienvenue à la 5e édition du Forum régional sur les industries extractives, les entreprises, les droits de l'homme et l'environnement en Afrique, organisé en terre sénégalaise sous les auspices de la Commission africaine des droits de l'homme et des peuples. Le thème choisi est parlant. Et je vois devant moi Monsieur le Président de l'ITIE bienvenue, qui est très intéressé par le souci et qui en fait sa préoccupation au quotidien. Monsieur le Président, promouvoir une gouvernance responsable des industries extractives en Afrique dans le contexte de la ruée mondiale vers les minéraux critiques. Enseignement tiré de 40 années de promotion de la Charte africaine. Permettez-moi, à l'entame de mon propos, de rendre un vibrant hommage à la Commission africaine pour l'organisation de ce dialogue d'importance majeure, conduit par son groupe de travail sur les industries extractives, l'environnement et la violation des droits de l'homme en Afrique. Ceux qui nous ont précédés à ce présidium, donc à ce pupitre, ont déjà affirmé une vérité universelle. L'Afrique recèle une part substantielle des gisements mondiaux de ressources naturelles, notamment les ressources non renouvelables telles que le pétrole, le gaz naturel, le phosphate, le zircon et les métaux tels que l'or, le fer, le cuivre, l'argent et bien d'autres. Et vous l'avez dit aussi, face à cette abondance, il importe de veiller à ce que la protection des droits de l'homme soit pleinement intégrée dans le développement et l'exploitation de ces ressources. La réponse à cette exigence réside, et sans conteste, dans la promotion d'approches fondées sur les droits de l'homme dans la gouvernance des ressources naturelles. Mesdames et messieurs, je peux noter avec fierté que les efforts déployés pour assurer l'articulation entre les droits de l'homme et les objectifs de développement durable dans le droit international ont favorisé l'essor rapide d'approches qui mettent l'accent sur la nécessité de prévenir et d'atténuer les atteintes aux droits de l'homme susceptibles de provenir des projets de développement des ressources, en veillant à ce que les politiques ou initiatives visant à promouvoir leur exploitation ne génèrent pas de conséquences préjudiciables et ainsi garantir le respect au droit à un environnement sain. Ce principe global posé me permet d'ouvrir une vision synoptique que nous devons avoir sur les enjeux liés aux préoccupations du thème qui est choisi, et thème d'enjeux stratégiques et géopolitiques. Vous l'avez dit, nos ressources sont toujours sorties du continent. Et je vais citer le Premier ministre du Sénégal, M. Ousmane Sonko, qui dit « Les peuples ne font que suivre leurs ressources. » Ils ont pris les ressources, ils les ont amenées. On prend le bateau pour suivre nos ressources. Et après, ils nous disent « Rentrez chez vous, rendez-nous nos ressources, on rentrera tranquillement. » Et cela pose le cadre global de l'analyse que nous devons avoir. Vous savez, tout ce qui se dessine aujourd'hui dans le monde connaît une description globale dans ces enjeux d'appropriation des ressources. Tout le monde sait que toutes les guerres, depuis la fin de la Deuxième Guerre mondiale, toutes les guerres ont été une guerre d'accès aux ressources. Toutes les guerres. L'Irak 1, Irak 2, Iran, Irak, c'était pour l'accès aux ressources. Tout le monde le sait maintenant. Aujourd'hui, tout ce que les gens sont en train de dire pour justifier une guerre contre l'Iran, c'est l'accès aux ressources. On nous parle des enjeux de la politique migratoire aux États-Unis et du cadre que doit constituer l'Afrique. Accueillir les migrants irréguliers aux États-Unis en Afrique, la stratégie, en contrepartie, c'est l'accès à nos ressources. La guerre en RDC, l'accès aux ressources. Ce qui se passe ici au Mali avec Kidal, c'est l'accès à l'or, tout le monde le sait. Ce qui s'est passé avec Elf au Gabon, c'était l'accès au pétrole. Aujourd'hui, dites-moi, quel est le contentieux mondial qui n'a pas comme question sous-jacente l'accès aux ressources? Ici, c'est les ressources fossiles, pétrole et gaz. Là, ce sont les ressources extractives, or, uranium, lithium, zircon, etc. Et la grande particularité, c'est que l'Afrique est au cœur de ce contentieux, parce qu'en réalité, la quasi-totalité des grandes ressources, les réserves les plus respectables se trouvent en terre africaine. Et quand on nous parle aujourd'hui des minéraux critiques, il est également intéressant que l'on pose l'analyse dans la perspective d'une définition et qu'on s'accorde sur la compréhension qu'on doit avoir des notions. Parce que la notion de criticité s'apprécie, en tout cas je parle de ceux qui ont fait des études en économie, la criticité s'analyse par rapport à la rareté de la ressource. Alors moi, si je détiens de l'uranium, que tout le monde recherche de l'uranium, qu'ils n'en ont pas chez eux et qu'ils soient obligés de venir chez moi le chercher, que j'en ai une réserve d'envergure internationale, est-ce que c'est critique pour moi? Non, c'est stratégique pour moi. C'est critique pour ceux qui viennent. Et pour ceux-là qui viennent, c'est effectivement critique. Et moi, j'ai 50 interlocuteurs. Je dois discuter pour préserver tous les enjeux économiques, les enjeux humains, les enjeux environnementaux, les enjeux juridiques, les enjeux. Donc, pour moi, c'est stratégique. Pour eux, c'est critique. Parce qu'ils ont une capacité de produire. Et vous l'avez dit aujourd'hui, vous l'avez dit dans vos propos. Le développement des data centers demande une consommation en énergie que l'on ne peut pas produire aujourd'hui. Le traitement du lithium, une tonne de lithium, c'est 500 000 litres d'eau. Une tonne de lithium, 500 000 litres d'eau. Et c'est nous qui avons le lithium. Alors, la question, c'est de savoir quel doit être notre positionnement stratégique. Parce qu'aujourd'hui, il n'y a plus de droit international sur le respect des États. La question, un État, un droit, un vote, on nous l'a appris à l'université, mais personne ne le respecte aujourd'hui. La question c'est, je suis fort, vous avez les ressources, je ne les ai pas, je vous attaque, je récupère tout. Je vous prends votre président, je l'amène chez moi, je prends vos ressources. Je tape chez vous, je récupère votre or, je récupère votre uranium, j'amène chez moi. Pourquoi? Parce que moi, j'ai les plus grandes entreprises, je dois les satisfaire, je dois satisfaire mon peuple. Alors, cette réflexion-là doit nous amener aussi à un positionnement stratégique à l'échelle africaine. Parce qu'on ne peut pas avoir une réussite au Sénégal en oubliant la Gambie ou Sierra Leone. Impossible. Ce ne sont que des victoires momentanées. Ce ne sont que des gains momentanés. Tout le monde doit gagner dans ce jeu-là. Voilà pourquoi nous devons harmoniser nos positions. Et harmoniser nos positions, c'est quoi? C'est quoi harmoniser nos positions? Participer à ce débat sur les minéraux critiques, assumer une position et la défendre. Et notre position, elle sera respectable et respectée. Parce que c'est nous qui avons les ressources. Ensuite, à côté des minéraux critiques, ils vont nous amener d'autres questions pour dire, je vous prends votre ressource, mais ne créez pas le droit pour défendre vos communautés. Ce sont les clauses de stabilité dans les conventions. Dans la clause de stabilité, ils vous disent, dans les conventions qui sont signées, l'État doit mettre toutes les conditions nécessaires pour que j'ai un retour sur investissement sans créer des charges nouvelles pour moi et protéger mon investissement. Mais pour les juristes qui connaissent, pour ceux qui suivent la jurisprudence de la CRDI, ils savent pertinemment que les clauses de stabilité s'effacent et disparaissent quand le droit de l'environnement doit être préservé. Ils le savent pertinemment. Ils savent que les clauses de stabilité disparaissent quand la préservation des droits de l'homme et des communautés autochtones se présente. Pourtant, ils nous menacent, ils disent, je vais vous amener au tribunal, je vais vous amener à la médiation. Allez-y, bon sang, on est prêt pour nous défendre. Et aujourd'hui, on aurait pu dire, make African countries our priority. M-A-C-O-P, make up. And to make up means rattraper, pour rattraper. On a perdu tellement de temps. And we have to make up. Make African countries our priority. C'est pour cela que je salue le travail abattu par la Commission africaine dans cette dynamique d'intégration progressive des approches fondées sur les droits de l'homme dans les régimes juridiques relatifs à l'exploitation des ressources naturelles sur le continent. Et je peux citer ici la création d'un mécanisme spécial chargé du suivi de l'industrie extractive, de l'environnement et des violations connexes des droits de l'homme. Extrêmement important, Monsieur le Président. L'adoption de la résolution sur l'approche fondée sur les droits de l'homme de la gouvernance des ressources naturelles lors de la 51e session ordinaire en 2012. La résolution relative à l'approche fondée sur les droits de l'homme dans la mise en œuvre et le suivi de l'accord sur la zone de libre-échange continentale africaine, ainsi que la résolution sur les industries extractives et l'élimination de toutes les formes d'exploitation dans les relations économiques internationales de l'Afrique. Ces initiatives, auxquelles s'ajoute l'adoption de lignes directrices normatives de droit souple, illustrent le rôle de chef de file que la Commission exerce dans ce domaine essentiel. Et félicitations à vous. L'adoption de ces différentes résolutions entre en droite ligne avec les principes directeurs de l'ONU relatifs aux entreprises et aux droits de l'homme, ou cadre rigide, fondé sur le respect de ces trois piliers fondamentaux. L'obligation de l'État de protéger les droits humains, la responsabilité des entreprises de les respecter et la nécessité d'un accès aux voies de réparation, obligatoirement. Et je saisis cette occasion pour exprimer encore mes vives félicitations encore à la Commission africaine pour son engagement constant dans la lutte contre les violations des droits de l'homme liées aux industries extractives en Afrique. Mesdames et messieurs, si nos ressources sont un levier de croissance, nous ne pouvons ignorer les externalités négatives au cœur de nos terroirs. Et vous l'avez dit tout à l'heure, je ne fais que vous reprendre. Impact sur la santé, contamination de l'eau, nuisances sonores, dégradation de la qualité de l'air, destruction des terres agricoles ou encore stress lié au déplacement des populations et de l'insécurité. Et à cela s'ajoutent les changements de paradigme liés notamment au changement climatique. Et c'est pour apporter des réponses à ces questions-là, d'ailleurs, qu'au Sénégal, il y a un certain nombre de décisions prises pour la préservation des droits des communautés. Je ne ferai pas de développement sur ces points-là, mais il y a un certain nombre de fonds. Le fonds de réhabilitation, personne ne fait de la réhabilitation. Ils nous prennent la ressource, ils nous laissent des cratères, ils s'en vont tranquillement, les populations ne peuvent pas récupérer leurs terres. Il faut effectivement mettre en place des fonds de réhabilitation parce qu'il faut restituer au territoire. Il faut restituer aux terroirs et aux communautés leurs terres pour qu'ils puissent continuer à exercer l'agriculture et l'élevage. Mais on ne peut pas se limiter à ça. Parce que la question sur la RSE, il faut aller au-delà de la RSE parce que la RSE est simplement laissée à l'appréciation des entreprises. Elle n'a pas de sens. Et je vous défie. Faites les appréciations. L'intégralité des ratios des entreprises minières sur la RSE tourne entre 0,5 et 1% de leur chiffre d'affaires. Mais qu'est-ce que bon sang ça peut apporter à la communauté qui a perdu son champ, qui a perdu son élevage, qui a perdu ses valeurs morales sur les cimetières où on a gardé les anciens, où on a gardé les aïeux. Le rattachement moral au territoire, au terroir. Ils nous enlèvent tout ça, ils veulent nous donner 0,5% d'un chiffre d'affaires. Voilà pourquoi il faut le fonds d'appui pour soutenir les communautés territoriales. Et ça existe au Sénégal. Et entre autres, j'aurais pu faire encore des développements. Mais l'important, et c'est l'occasion pour moi de féliciter encore l'ITIE pour le travail de qualité qu'il fait depuis 2013 et qui s'appuie sur un cadre pour renforcer la gouvernance dans le secteur minier et pétrolier. Je terminerai pour dire que nous serons avec vous. Nous serons à côté de vous. Nous sommes prêts à assumer cette démarche-là parce que nous sommes là pour la défense des intérêts des communautés dans le cadre de collaboration win-win par la promotion du contenu local, par le transfert de la compétence, par la promotion de l'emploi local, mais par la valorisation locale de nos ressources. Et il nous faut, tous les chefs d'État, s'engager dans cette perspective-là. Sinon, les peuples décideront en faisant leur propre choix. Et ça ne produira que du désordre. Alors, donc, le Sénégal a intensifié ses efforts pour renforcer cette réglementation-là. Je me passerai de commentaires supplémentaires. Je voudrais simplement dire qu'en conclusion de tout ce que je viens de dire, je tiens à souligner que ce forum régional sur les industries extractives, les entreprises, les droits de l'homme et l'environnement en Afrique nous offre une plateforme privilégiée pour réfléchir collectivement à l'imbrication nécessaire entre industrie extractive, droits de l'homme et gestion environnementale. Des enjeux essentiels pour le développement durable du continent et pour la dignité de nos peuples. Et en plaçant les droits de l'homme au cœur de nos actions, nous avons l'opportunité de redéfinir ensemble les industries extractives comme des moteurs de paix. On nous a dit la malédiction des ressources, c'est faux, c'est absolument inexact. Ça ne dépend que de nous de transformer qualitativement. Ce n'est que la volonté des hommes. Ça ne dépend que de la volonté des hommes. Redéfinir donc ensemble les industries extractives comme moteur de paix et de croissance inclusive. Et je tiens encore une fois à adresser mes vives félicitations à la Commission africaine pour l'organisation de ce forum d'importance et à réaffirmer l'engagement du gouvernement du Sénégal en faveur de cet objectif louable de promotion des approches fondées sur les droits de l'homme dans la gouvernance des ressources naturelles en Afrique. Je déclare ouvert les travaux et je vous remercie de votre aimable attention.
Merci beaucoup, Votre Excellence. Thank you very much, Your Excellency, for your statement and for the call, your very powerful and thought-provoking statement, and the call to all of Africa to make African countries our priority markup. This is one of the key takeaways already. And we were grateful to the government of the Republic of Senegal for their support always to the African Commission. This is our second home. This is where the journey of the African Charter began, and this is our default place of meetings when we are not in Banjul. We thank you very much, Your Excellency. Thank you for declaring the opening ceremony. Declaring this forum open. And just before we come to the end of the opening ceremony, we will now receive a keynote statement by a prominent human rights advocate and Pan-Africanist. He will be, just a second, in a minute. All right. Just before we introduce the keynote speaker, we will be introduced by His Excellency Honorable Gary Sakata, who is a member of the Pan-African Parliament and the chairperson of the PAP Committee on Rural Economy, Agriculture, and Natural Resources. Before I give you the floor, Honorable Sakata, the chair of the Working Group on Extractive Industries, will make a statement, and then we'll pass the floor on to you to introduce the keynote speaker. Thank you very much. You have the floor.
Thank you very much, Abiola. Minister, I am more than delighted with your intervention. This is exactly the kind of tone, the kind of problematization, but also the kind of courage and also proposition of solutions that combines to meet the challenge of the moment. And really, really grateful. And in that respect, I would only like to make two things. I think makeup, indeed. I think there is a lot of time that has been lost, and we have to make up for it. And one of the ways to do it is by combining the efforts of the African Commission, states parties to the African Charter, civil society organizations, and communities from the ground, working together and creating the institutions, the legal systems, and the movement. Because institutions and laws can exist without the movements of people and civil society breathing life to it, it wouldn't be possible to realize. And this is the whole point of this forum. So in that respect, one thing that I would like to request is this one, for the government of Senegal, through you, to sponsor, because there is a resolution that you cited in your statement to sponsor a decision of the African Union on the development of a legal instrument on business and human rights in Africa. That is my humble request. It is basically from the resolution that you made reference to. And we would like you really to champion that, because it is Senegal that championed the resolution that led to the adoption of the African Charter on Human and People's Rights 40 years ago. And it is befitting for Senegal to take a lead on this important initiative as well. And second, in honor of Senegal, but also its distinguished son, Judge Keba Mbaye, who relentlessly championed for the adoption of the African Charter and succeeded in securing it, may we actually borrow his name to name this Continental Forum as Judge Keba Mbaye Continental Forum on Extractive Industries, Business, Environment, and Human Rights. Thank you all very much. Thank you, Minister.
Thank you, Honorable Commissioner. Honorable Sakata, you have the floor. Yes, you have the floor, sir.
Distingués membres, comme on l'a dit, je suis honorable Gary Sakata, député de la République démocratique du Congo et membre du Parlement panafricain. Je voudrais donc, à la suite de tous les discours qui ont eu lieu, noter que les nerfs de la paix ou de la guerre se trouvent dans l'accès aux ressources, mais comment préserver les intérêts des détenteurs de la souveraineté sur les minéraux que sont les populations. Ça, c'est l'une des questions importantes. Pour y parvenir, nous allons donc inviter M. Donald Dea pour qu'il nous présente les propos introductifs sur cette question pertinente. Est-ce que Donald est dans la salle? Pas là? Ah, vous pouvez venir? Et alors qu'il avance, je vais le présenter. Donald Dea est directeur général de l'Union panafricaine des avocats. Il préside notamment les comités exécutifs de plusieurs institutions au niveau international et africain. Il est membre du comité directeur et ancien président de la coalition pour la Cour africaine. Il collabore étroitement avec divers organes, institutions et agences spécialisées de l'Union africaine et des communautés et mécanismes économiques régionaux. C'est un juriste qui est très prolifique et qui plaide devant divers tribunaux et cours internationales africaines. Il collabore également avec les Nations unies et la Cour pénale internationale. Il est également procureur auprès de la Haute Cour du Kenya et exerce à Arusha, en Tanzanie. C'est donc avec plaisir que nous allons devoir l'entendre. On vous invite, Monsieur Donald.
You're welcome, Mr. Dea. Just as we welcome Mr. Dea, please, can we rise for His Excellency the Minister to leave the room because he has another engagement and we're already behind time. Thank you very much, Your Excellency. We will not forget markup. Thank you, Your Excellency. Mr. Dea, oui. Merci, Excellence. As we wait for His Excellency's departure, we will now take our seats and listen to Mr. Donald Dea. As an ardent defender of the African Charter, he makes no excuses. a strong supporter of the African human rights system. He's faced at the commission, at the court, wherever it matters to defend human rights, human and people's rights on the continent. Mr. Daya, we're honored to have you. Thank you so much. You have the floor.
Thank you very much, Abiola. Starting with the host, much as he may have left his room, the Honorable Biram Souleye Diop, Minister for Energy, Petroleum and Mines of Senegal, and his delegation. And even though they have escorted him out, Honorable Mr. Idrissa Sow, Chairperson of the Commission, the commissioners present with us, Honorable Dr. Solomon Ayele Derso, who's also the chair of the working group, and Honorable Dr. Lita Musimi Ogana, who is the vice chair of the working group, Your Excellency Willie Nyamitwe, permanent representative of the Republic of Burundi to the African Union, chairperson of the PRC, and also interim chairperson of the PRC Subcommittee on Democracy, Governance, and Human Rights. My lady, the Honorable Justice Stella Anukam, Judge of the African Court. My sister, Abiola Idowu Ojo, Executive Secretary of the Commission. Representatives of our various governments who may be in the room at this time. Our brother Dennis Geir, representing the Open Society Foundations, members of the Academy, civil society, ladies and gentlemen, all protocols observed. As has been highlighted, this year we celebrate 45 years of the adoption of the African Charter on Human and People's Rights, which happened in Nairobi, Kenya on 1st June 1981. We also celebrate 40 years of its coming into force, which happened on 21st August 1986. Interestingly, and this is not mentioned enough, we are also celebrating 20 years of the adoption of the African Youth Charter, which happened across in Banjul on 2nd July 2006. I think it is it is appropriate to signpost this 40-year journey of the Commission, especially the 40-year partnership of the Commission with the citizens of Africa through civil society, through academia, through other institutions. And especially the journey of the special mechanisms of the Commission and the soft law that they have generated and that they continue to generate, and which provides very useful guidance for member states, for citizens, for duty bearers, and for rights holders. I think it is a journey worth a clap. I must also apologize, especially to Dr. Daso, that this is my first appearance at this forum, yet it is the 5th forum. And it's also the first formal appearance of PALU, the Pan-African Lawyers Union here. We expressed interest to be part of the working group and its work, and were indeed invited, but have not made it until this moment. I think, among other things, just goes to show how few of us there are and how much work there is across this continent, that we cannot be in all the spaces that we want to be. Our apology nonetheless. Having said that, I also want to reflect for a moment on who else is not in the room at this moment. And I do acknowledge that from the African Union Commission, I did see my sister Seraphine Kando. And I do acknowledge also that we have PAP, we have the Honorable Member of Parliament, and we have one of his at least one of his parliamentary clerks with him. But several parts of the African Union that deal with trade and the economy are not in the room. Yet we're discussing business and human rights. Several parts of the private sector are not in the room. In fact, I don't know if there's anybody who is in the room who expressly identifies as coming from the private sector? If there is, please raise your hand, so we appreciate you. So we have at the moment no representation from the multinational corporations or from the medium, small, and micro scale enterprises when we're discussing them. So, ladies and gentlemen, we must all participate in bringing them here to future fora, bringing them into this conversation. On our part, as PALU, using our Corporate Counsel Committee, which has in-house lawyers, we undertake to do our part to try and bring representatives of corporations, especially the General Counsel, many times who are the ones who hold the BHR, the Business and Human Rights Agenda, into the room with us and other structures of PALU. Ladies and gentlemen, I think it was Dr. Dasso who, in his framing remarks, spoke a little bit about the present state of the world we live in. There is demographic regression worldwide. There's a rise of far-right movements, nationalist, ultra-nationalist movements, anti-immigration movements in significant parts of Europe, North America, parts of South America, perhaps even in Africa too. Certainly in Africa, there's a resurgence of xenophobia in certain parts of Africa, which is really regretful. There are wars of aggression worldwide, and the Honorable Minister spoke about them, including in Africa. Sudan remains the world's worst atrocity site and the worst humanitarian crisis in the world right now. There are significant challenges to the idea of an international rule of law. So what are our options? We do have the option of democratic disillusionment, but we also have the option of democratic resilience. At this point, when those who for the last 70, 80 years had arrogated to themselves the role of being the prefects of the world are failing in that role, it is an opportunity for Africa to provide the moral leadership of the world. You don't have to be the most powerful in order to speak truth to power. You just have to be the most truthful. It's an opportunity to the moral leader of the world, and I'll demonstrate that we've shown signs of that, to speak truth, to push for what ought to be done, to push for a rules-based order, and to the extent that some of the rules and some of the institutions that we have made for ourselves in the last 70 years may not be good enough, may not be fit for purpose, for the multiple simultaneous challenges that the world faces, to provide the new rules, to provide the new norms, to call for and establish the new institutions, including on the continent of Africa. As you may know, starting with the summit this year, there was a call to develop a common African foreign policy. And this is one of the levers that could be used to achieve that. Talking about Africa's resources, a lot has already been said this morning, including by the minister, including by the follow-up call by Dr. Dasso. And I do not intend to repeat that which has been said. I'll just say that it bears repeating that Africa's greatest resource by far are its people, and especially its young people, which is why it was important for me to signpost also the Africa Youth Charter. Africa's greatest resource is its people. Africa's proximate resource are its natural resources, especially the extractives, minerals, including the so-called critical minerals or strategic minerals, oil, gas, forests, fisheries, the blue economy elements, and so on. And our challenge is how we approach the exploitation of this for the benefit of the African people, present and future generations, in a sustainable manner. To touch on a few key points, which have also been highlighted in the concept note for this fifth forum. One is African Union's Agenda 2063. We are currently into the second implementation plan, the second 10-year implementation plan of Agenda 2063. As you know, some areas are being implemented on time or sufficiently, others are not. The African Union reforms were supposed to anchor this and expedite this. But the AU reforms results are also still mixed. There's still a work in progress. One point that the human rights community has pointed out is when you look at the indicators, the monitoring and evaluating indicators, especially on resource governance in Agenda 2063, they are predominantly economic-based rather than rights-based. And one of the things that has been called for, and we repeat, is for explicit incorporation of the provisions of the Charter, especially Articles 21, 22, and 24, into these indicators and into this reporting. So it is just not economic-based, it's also rights-based, it's people-based. Two, on the African mining vision. The African mining vision, of course, remains the central continental policy framework and implementation framework for all our extractive resources. Implementing it, especially through the African Minerals Development Center, AMDC, is ongoing. But again, it is worth noting that both the vision and the development center were developed, one, before the critical minerals rush, two, before the development of the African Continental Free Trade Area infrastructure, especially its investment protocol. And also three, that these two instruments also are largely silent on rights, especially on the rights framework brought about by the Charter and on the right to access a remedy. So among other things, as we go ahead as a community, this calls for a revision of the African mining vision to integrate the Charter rights framework, to integrate the state reporting guidelines under Article 21 and 24, and to integrate the realities of the energy transitions and the critical minerals economy. It's something we're called upon to do. Three, if I were to say one more thing about this rush for critical minerals or strategic minerals in Africa. First is to note that at least at the AU level, last year, February 2025, the African Union adopted Africa's Green Mineral Strategy, which tries to see, again, as a sub-strategy of the mining vision, tries to see how we can turn this resource into value addition, into a whole forward and backward linkages, into critical reform of our economy on the continent. But, and it bears repeating, that unless Africa adopts a continental position on critical minerals, it will be a race to the bottom. States will continue to negotiate bilaterally. They'll continue to be arm-twisted. Perverse incentives, including the insertion of war and insurgency, will continue to be part of the mix. And we will get very little while bearing a heavy costs for it. But with a common continental position, Africa can become a norm maker and a rule maker, not just a price taker. And it is very important that we insist, as has been made clear, even by some of the statistics that you gave us, Dennis. It is very important that we make it clear that this common position on critical minerals should be anchored in the Charter and in Articles 21, 22, 24. Four, coming now to the AU theme of the year. water and sanitation. And I think, Dennis, you made the point that the water and sanitation deficit on the continent is a major point of concern from a rights position, with hundreds of millions of Africans lacking safe drinking water, lacking adequate sanitation systems. You pointed out that the extractive sector is the largest industrial water user and water polluter on the continent, and is leading to the dewatering of agricultural basins in several parts of the continent. You brought out the importance of rights-based transboundary water resource governance when we're looking at our shared water resources, the Nile, the Congo, the Niger, the Zambezi, the Limpopo, the Senegal Basin, the Volta Basin, and so on. And that licensing that privileges extractive industries, usually without formal coordination with the needs of the people, ends up being a mass violator of rights. So I think we're called upon to use this theme and to use this year to make sure that safeguards on water and sanitation go into the heart of the rights of our people and are built into and computed into our mining, our oil and gas licensing. And I think it is important for us to focus on the upcoming general comment on Article 24 and make sure that we adequately articulate water and sanitation as substantive entitlements of the people of Africa. On the African Continental Free Trade Area 5, as we know, it's one of the key flagship projects of the AU Agenda 2063. And it seeks to liberalize trade, promote industrialization, build economic integration, eliminate tariffs, and so on. As of now, 49 of our 55 member states are full parties, so 6 still are not. On principle, in terms of rules, at least 100% of the rules of origin have been concluded. Protocols exist on trade in goods, trade in services, digital trade, investment, intellectual property, competition policy, and dispute settlement. But like is the bane with Africa generally, we are big on words and very little on action. We are very ambitious with our text, but very reserved in implementation. And this becomes a big issue. But also, and I give this criticism, and this critique has been given that when we negotiate our trade or our economy, we seem to wear purely trade and economy hats and completely forget about rights. So we have an infrastructure that up until the African Commission began engaging with them, I think 2 or so years ago, we have an FCFTA infrastructure that had a purely economic orientation without a human rights basis. And we are invited to remedy this as we go along, as the ship goes along. Again, focusing on the business and human rights agenda and stepping back. The AU in Addis, led by the African Union Commission, has been working for a number of years, especially through the Department of Political Affairs, Peace and Security, PAPS, on a business and human rights policy. As far as I know, this work has not concluded, even though it's run for a number of years. I know that as a matter of practice, PAPS also has units that have been engaging with the business and human rights lens in conflict-affected mining contexts. It behooves us to use this opportunity to bridge the gap, as I usually say, between Banjul and Addis Ababa. The human rights community, especially we, the citizens, invest a lot of time in our engagements in Banjul. Our engagements with the Commission as a whole, our engagements with the Secretariat of the Commission, our engagement with the special mechanisms, our engagement with the soft law development processes. And many times we risk preaching to the converted, just staying ourselves in our Banjul bubble, talking to each other, and not talking to the real power wielders, the policy organs, and those that assist the policy organs that meet usually in Addis Ababa. So it's my clarion call to the Banjul community to invade Addis Ababa more, to invade our 55 permanent missions more, to engage various organs, institutions, specialized agencies of the AU in Addis more. We're welcome to do that. The few that manage to engage, when the commission goes as one of the organs, and it's the only one engaging, perhaps side by side with the court, perhaps side by side with the Child Rights Committee, even if you're to include one or two other agencies that are likely to be aligned to our orientation, such as the Commission on International Law and so on, there would still be too few to move the dense policy-making process in Addis. So it is important that the business and human rights agenda takes itself more to Addis. As I wrap up, let me talk just about two more things: illicit financial flows and tax, because both have been talked about. And to again celebrate that Africa coming up with its illicit financial flows agenda, with its illicit financial flows campaign, with the high-level panel on illicit financial flows that was chaired and is chaired by His Excellency President Thabo Mbeki, attracted world attention and attracted world action. Africa did start a process of moving the world within our lifetime. The Mbeki panel, whose report was released in January 2015, directly led through the chairpersonship of the General Assembly and ECOSOC by Nigeria and Norway in 2020 to the establishment of the equivalent of the Mbeki panel at the global level. And that is the United Nations High-Level Panel on International Financial Accountability, Transparency, and Integrity for achieving the 2030 Agenda, what is known as the UN FACTI panel. The UN FACTI panel's report in 2021 has led, amongst other things, to the ongoing work towards a UN tax convention. So Africa pushed, and the world listened. And Africa voted. The Africa group led the series of votes with the support of the G77 and other actors to the global south that led us to where we are now, where we are wresting away sole jurisdiction for international tax making from the club known as the OECD, the Organization for Economic Cooperation and Development, and aspiring to put it in the UN, where there's at least the promise, sometimes a mirage, of one state, one vote. But at least we are in the room and not the cousins sticking from outside. But it is still important to tie implementation of the IFF's agenda to implementation of the African mining vision and with a rights-based lens, so that, again, we frame IFFs not purely as a financial issue, but also as a human and people's rights issue. And I do know that Palu and others have begun some work, some very early work with the working group that may lead to this. On tax, at least at the UN level, with the work that I've talked about in the last 2 years, at least NGOs from the global south, including Africa, were a bit more keen and were able to inject right into the terms of reference to guide the drafting. We're able to explicitly include human rights and include provisions that the Framework Convention must be aligned with the state's obligations under international human rights law, ensuring that tax cooperation supports the realization of socioeconomic rights such as health, education, and social protection. So this is expressly written into the terms of reference. But I continue to urge African states and African peoples that we really need to keep our eye on the goal at every stage of the drafting process, because there are very powerful forces that are looking for any small opportunity to delay or to derail the process, or to insert provisions or clauses that may take us back. So it requires a very full-time focus by African states, by African governments, and also by African people. As I end, I go back to one of my favorite pet projects that friends like Japheth and I have wrestled about for the last 12 or more years, and that's the Malabo Protocol that would give an international crimes jurisdiction to the African Court on Human and People's Rights. And to say that, remember that the Malabo Court, if its promise ever comes true, unlike other systems, for instance, the Rome Statute system or the ad hocs and the hybrids that we have had, combines individual criminal responsibility with corporate criminal liability and provides for a wider array of crimes that includes corruption, money laundering, terrorism, mercenarism, and illicit exploitation of natural resources. These combined actually effectively criminalize illicit financial flows and seriously proscribe crimes that may be committed by multinational corporations. A new momentum for bringing it into force has begun, led by Angola, which deposited its ratification in 2024. So again, it behooves us as a human rights community to push for this, to push for a Malabo framework, which will be the ultimate guarantor of multinational corporation activity all over the African continent. So, in summary, because one person can't say everything, I'd had some points on climate change, some points on reparations, but I think this can come later from the plenary. I look forward to the reports that will be submitted over the course of the next 2 days and the discussions that we'll hold on them. I look forward to bridging the gap between government, private sector, trade, and human and people's rights. I look forward to having more of Banjul in Addis Ababa. And I wish us all fruitful deliberations, recommendations, resolutions, and actions. Thank you.
Thank you very much.
Nous remercions M. Donald Dea pour son exposé combien exhaustif et qui a été extrêmement clair, bien articulé. Nous notons, et là nous tombons d'accord avec lui, sur le fait que nous devions traiter sur les triptyques État, entreprise et droits de l'homme entendus comme étant les peuples détenteurs de la souveraineté. Mais il a noté avec beaucoup de pertinence qu'ici, il manque un point important qui est les entreprises. Et comme vous le savez, comme je viens de le dire, triptyque État, entreprise, population, donc droits de l'homme, ayant un socle commun ou un but à poursuivre qui est le développement durable, lequel développement durable peut être subdivisé en plusieurs aspects: développement économique, développement social, développement culturel et tous autres développements. Donc voilà un peu ce que l'on peut noter et retenir de la pertinente intervention de notre collègue Donald. Alors, puisque nous sommes derrière le temps, il n'y aura pas de questions maintenant. Les questions seront posées dans le prochain panel. Nous allons peut-être devoir suspendre la séance, aller au déjeuner et revenir pour la suite. On vous remercie.
Merci, Excellence. His Excellency wants us to go straight to lunch. Thank you very much, Your Excellency. And we can assure you, Mr. Dare, that we reached out to many of the actors that you referenced within the African Union architecture, the departments dealing with mining, AFCFTA. We have some of them here, but some are also busy with many other things that they're working on. So now, as introduced by Honorable Sakata, we will now take a break, a quick break. We are 2 hours behind time. We will have a family photo first on the ground floor, and we would have tea and coffee, stretch our legs, and be back here by 12:30, please. Is it okay, Chair? It's too much? 12:15 says the Chair. We will barely digest the tea and coffee break, but this is the sacrifice for trying to make up for the time. Thank you very much. We'll meet on the ground floor for the family photo, and right after, tea and coffee will be served here on the 3rd floor, and we have some of the ambassadors, Your Excellencies. The tea and coffee will be in the VIP room on the 4th floor. We have the protocol officers who will guide you to where we'll have tea and coffee. Bon appetit, and see you at the point for taking the picture. Once you get to the ground floor, you will see where the setup has been prepared for the family photo. Thank you.
Texte 1, 2, 3. Texte 1, 2, 3. 1, 2, 3, texte. Texte 1, 2, 3. 1, 2, 3. 1, 2, 3, texte. C'est bon? C'est bon, texte 1, 2, 3. 1, 2, 3, texte. C'est bon? Yes, one. Un, deux, un, deux, trois, texte. Trois, texte, un, deux, trois. Un, deux, trois, texte. Yes. Yes, one, texte. Okay. Thank. 1, 2, 3, takes. 1, 2, 3. 1, 2, 3, takes. Yes, one, takes. 1, 2, 3. 1, 2, 3, takes. Yes, one. Yes, one, takes. 1, 2, 3. 3, takes. 1, 2, 3. Thank fii la. Bii mooy dagg. Bii mooy dagg. Bii mooy dagg nag. Non, non. Bi yee mu ngi noonu. Non, yii. Yes, one, takes. 1, 2.
Excellencies, distinguished participants, we would now like to move on into the substantive session. We'll be starting with session 2, setting the scene, which will be moderated by Mr. Welina da Silva. After that, we will proceed immediately into session 3, wherein Honorable Commissioner Solomon Ayele Derso will introduce some key background documents and work of the African Commission that contextualize the work of the Commission on extractive industries, human rights, and the environment, and also help to provide the context for the conversation that will take place. And then we would have interveners in the presence of Mrs. Elena Kilonzo, Dr. Jafet Biegon, Mr. Seven Korir, and Mr. Lassana Wedrago. So I would invite them to already come up. Mrs. Elena Kilonzo, Dr. Jafet Biegon, Mr. Seven Korir, and Mr. Lassana Wedrago to already come up to the podium, please. Mr. Welina, you have the floor.
Thank you very much. Je vais parler en français. Bonjour à tous. J'espère que la pause café s'était bien passée. Je m'appelle Welena da Silva. Je suis bissau-guinéen et membre du groupe de travail. Nous allons commencer notre session substantive 1. Et profitant de la traduction, je vais modérer cette session dans la langue qui m'est plus familière, le portugais. Donc, je vous demande de... avec l'écouteur. Mais uma vez, boa tarde a todos. Muito rapidamente, espero que a pausa café tenha corrido bem e que recarregamos bem a bateria para o início efetivo dos trabalhos após a sessão inaugural, onde os nossos ilustres intervenientes já introduziram alguns temas quentes que serão objeto, aliás, do debate hoje e amanhã. Muito rapidamente, esta nossa sessão substantiva está dividida em 3 partes, mas que procuraremos resumir em 2 partes. Num primeiro momento, a secretária executiva da Comissão Africana dos Direitos do Homem e dos Povos, a senhora Abiola Ojo, irá nos apresentar os objetivos deste workshop e os resultados atendidos. Num segundo momento, o nosso ilustre comissário Salomão Derso, presidente do Grupo de Trabalho sobre Indústrias Extrativas, Meio Ambiente e Violação dos Direitos Humanos em África, irá nos apresentar uma visão geral do trabalho que a Comissão tem desenvolvido no setor das indústrias extrativas, ambiente e violação dos direitos humanos. Nós sabemos que, ao abrigo do mandato da Comissão de Promoção e de Proteção dos Direitos Humanos em África, à luz do artigo 45 da Carta Africana, a Comissão Africana, através do Grupo de Trabalho, tem desenvolvido várias atividades de promoção e de proteção dos direitos humanos. Portanto, teremos o prazer de ouvir o Sr. Comissário para nos apresentar uma visão geral. De seguida, iremos convidar também de novo o Sr. Comissário para vir apresentar o estudo de base, sobretudo as conclusões e as recomendações do estudo de base sobre as operações do setor das indústrias extrativas em África e o seu impacto na realização dos direitos humanos e dos povos ao abrigo da Carta Africana. Senhoras e senhores, sem mais delongas, convido agora a secretária executiva da Comissão Africana para vir apresentar muito rapidamente os objetivos e os resultados atendidos com este fórum. Senhora, tenha bondade.
Thank you very much. Thank you, Mr. Walina da Silva, who is an expert member of the Working Group on Extractive Industries, Human Rights and the Environment. I have been invited to contribute to the setting of the scene for this forum and to help in framing the context within which the substantive conversation will take place. In addition to the various opening remarks that we have listened to, which have already given some directions in terms of what we should be engaging in discussing during this forum. This intervention serves the purpose of a technical framing of the forum within the parameters established in the concept note. It is intended to align participants on the rationale, the thematic focus, and expected outputs of the forum, and to situate the subsequent presentations within a coherent analytical and institutional framework. In terms of a normative and institutional context, the forum is grounded in the normative architecture of the African Charter on Human and People's Rights. As we've said, this is the ground norm for the African human rights system. Particularly, the Charter's recognition of one, the relationship between natural resource governance and the realization of human and people's rights. Two, the obligations of states to regulate both public and private actors. Three, the centrality of collective rights, including rights under Articles 21, 22, and 24 within this framework. Commissioner Delso will be expounding subsequently on the guidelines and principles that have been elaborated by the African Commission on the content of Articles 21 and 24 of the Charter. Within this framework, the establishment of the Working Group on Extractive Industries, Environment and Human Rights reflects also a sustained effort by the African Commission to develop standards and guidance, to undertake research and country engagement, to promote accountability in the extractive sector governance, and therefore the engagement and the presentations within this forum would also be viewed within the framework of the work of the WGEI, which is the abbreviation for the Working Group, and the contributions to the normative framework for natural resource governance in the context of human rights in Africa. As this forum seeks to operationalize the mandate of the Working Group, among others, we will need to also bear in mind Resolution 550 of the African Commission, which calls for a continental platform for peer learning and knowledge exchange on business, trade, and human rights, again to understand that this is a context within which this forum has been convened. On the rationale for the forum, and as outlined in the concept note that we shared, it seeks to respond to persistent and well-documented challenges associated with extractive industries in Africa, including a number of issues have been alluded to already this morning. I'll just highlight, among others, the ones that persistently come to the Commission. Commissioner Delso has talked about the issue of constraints that African states are facing in terms of being compelled to grant concessions to certain countries or their allies. The issue of the role of business and the big businesses in the context of extractive industries, environmental degradation and pollution, which we have addressed in the jurisprudence of the Commission, land dispossession and impacts on communities, illicit financial flows and governance deficits, which is also another area where the Commission is conducting a study, violence and risks faced by affected communities and human rights defenders. We have people who would address these issues. We have Mr. Daniel Kobe in the room representing the Oge community in Kenya. At the same time, the forum is framed by emerging dynamics, notably, as was discussed this morning, the global demand for critical minerals and the new rush for Africa. The evolution of continental economic frameworks, such as the AFCFTA. The need to align extractive governance within the development agendas of the African Union and of member states at national, regional, and sub-regional levels, including Agenda 2063 and the Africa Mining Vision. So this forum serves the purpose of being both a responsive mechanism to ongoing challenges and a forward-looking platform to address emerging pressures on resource governance systems. That's why it has been institutionalized as an annual forum. It's a platform for continuously looking at and addressing the emerging issues and speaking to them and framing responses to these issues. In terms of the thematic framing of this forum, the discussions are anchored in the forum's theme. 1, advancing responsible extractive governance in Africa and in the context of the global rush for critical minerals. This is the second aspect. Insights from the 40 years of promotion of the African Charter. Therefore, this theme situates the forum at the intersection of 1, historical reflection, 40 years of the Charter. 2, contemporary governance challenges. 3, emerging global economic and resource dynamics. It underscores the need to integrate human rights, environmental protection, and development imperatives within extractive sector governance. In terms of the core objectives, to anchor these forums squarely within the concept note as we had shared, the forum is structured around the following core objectives. 1, providing a multi-stakeholder platform for dialogue on extractive industries, human rights, environmental protection, and water governance. 2, strengthening accountability, including through the application of state reporting guidelines under Articles 21 and 24 of the African Charter. 3, promoting the dissemination and implementation of ACHPR normative instruments. We don't want them to stay only in Banjul or on our website. We want them to be widely understood, widely disseminated, and widely used by the diverse stakeholders. 4, advancing responsible business conduct through operationalization of the soft law standards that have been developed by the Commission under the auspices of the working group. We've talked about the guidelines that Commissioner Deso would expatiate upon, the background study. We want member states to use them. 5, facilitating peer learning and exchange of best practices amongst key stakeholders. 6, supporting inclusive and sustainable natural resource governance aligned with continental frameworks. All of these objectives both define the scope of the discussions and the expected direction of the contributions. As Commissioner Deso said this morning, we are not here only to talk about the problems or appreciate the beauty of the problem, if I can borrow his expression, but to formulate responses to these issues and how Africa can concretely and practically move forward. In terms of the focus of substantive engagement, the various interventions are located within the following themes. 1, practical application of human rights standards in extractive sector governance. 2, we want to hear experiences from states, NHRIs, communities, and industry actors. We're not just speaking theory, we are looking at real life situations because these are issues that affect our people across the continent. 3, implementation of reporting obligations and regulatory frameworks. We don't just want to talk. We want states to look at their national frameworks and report about how they have aligned with the national frameworks with the obligations under the African Charter, as the Commission has tried to expound in various soft law instruments that Commissioner Des will be addressing, among others. 4, community participation, consent, benefit sharing, beneficiation, all of these principles that have been expounded in terms of what the implications of Article 21 of the Charter really are. We want to discuss them. And lastly, policy and institutional alignment at national and continental levels. In addition, the forum will advance ongoing normative processes, for instance, work toward a regional legal instrument on business and human rights, as Commissioner Deso has called on His Excellency the Minister of Senegal to champion, consideration of accountability and dispute settlement mechanisms. Justice Anukam will address the role of the African Court, and the development of a general comment on the right to a satisfactory environment, an initiative that the working group is currently undertaking. On the expected outcomes, and I'm about to wrap up, the concept note defines 2 primary strategic outcomes for the forum. 1, strengthen national, legal, and institutional frameworks for promotion and protection of human rights in the context of extractive industries. And secondly, concrete commitments by stakeholders, diverse stakeholders, to align laws and policies with obligations under the Charter, including firm commitments like markup that we heard this morning, make African countries our priority. These outcomes are intended to be measurable within a defined time frame and supported by indicators, including uptake of state reporting guidelines by states, integration of human rights due diligence, adoption of environmental and water safeguards, and strengthening of accountability and remedy mechanisms. And lastly, maybe not lastly, I still have a page. Expected deliverables. The forum is expected to produce concrete outputs, including the following. One, a forum declaration capturing key findings and recommendations. Two, action-oriented tools, including an action matrix and implementation resources documented in a forum report, which will be published and made accessible to all stakeholders. Increased application of ACHPR standards, particularly the guidelines on Articles 21 and 24, policy and regulatory proposals aligned with the Charter. And these deliverables are designed to ensure that the forum translates into sustained engagement beyond the event itself. Parameters for engagement in line with the concept note, contributions during the forum are encouraged to focus on implementation and operationalization, to draw on concrete experiences and practices, to identify replicable approaches and reforms, and to support the development of actionable commitments. And lastly, the presentations that follow should be understood as contributing directly to the objectives and outcomes outlined that I've outlined, and should provide substantive basis for refining recommendations, informing commitments, and supporting development of the forum's outputs, particularly the declaration that we would have at the end of this forum. I humbly submit and I wish us all fruitful deliberations. I thank you. Now I will hand the floor to Honorable Commissioner Derso to start session 3 by setting the scene with the background documents that we've addressed, that we've highlighted. You have the floor, Honorable Commissioner Derso.
Thank you very much, Abiola. Most appreciated. In the interest of, I see Donald Dea's name here, and I see Donald Dea somewhere else. It looks like that it's in a typical African tradition or of the ambition that we set for norms and the implementation gap. The ambition is here, the implementation is down there. Don't. Dear colleagues, friends, we, in the interest of time, we collapsed the two sessions. The session that was meant to introduce some of the work that has been accomplished by the African Commission's Working Group on Extractive Industries, Environment and Human Rights. I don't know what you are suggesting by increasing the volume, whether my voice is not good enough. You can reduce it, please. There is an echo. Yeah, I think this should be fine. Thank you very much. So the idea is not so much for us. Yes, I think there is volume with this. When he adds the volume more, it would create an echo, making it difficult for them to interpret. Thank you very much again. The idea is not so much to belabor the point about the work that has been undertaken. The idea is really to actually highlight what has been done so that, as Don in his keynote address rightly pointed out, we wouldn't be reinventing the wheel. We build on what had already been built, what has already been put in place. And I think that is really very important for us. First, the Working Group on Extractive Industries, one of the assignments that it was given upon creation was the development of a background study on extractive industries, environment, and human rights in Africa. And following quite a few years of work, the working group developed, finalized, and presented the study to the Commission, and the Commission considered and adopted that study, becoming the anchor on which the work of the Working Group on Extractive Industries is to be guided with. One of the points highlighted in the working group's background study is what I called the human rights protection vacuum in which extractive industries have historically and in so many ways to this day operate. Much of there are a number of factors for this. History is one of them. Remember, extractive industries start operating long before the establishment of the Organization of African Unity, long before the establishment of the African Charter, the African Commission on Human and People's Rights. And indeed, one can say that that is where the original sin is. Okay, the encounter that I made reference to earlier on. Because the way the relationship between Africa and its natural resources started was through the establishment of exploitative, extractive systems. And that pattern of exploitation and extraction has not been disrupted because of the end of colonialism. Because part of the reason for that is that Africa's economies were integrated into, quote unquote, integrated into the global economy based on the existing pattern of supply of raw materials from Africa and the development of these raw materials elsewhere. And therefore, that past dependency, if I may call it, is one of the factors for this, the operation of the extractive industry sector in what I call the human rights, the human and people's rights protection vacuum. That is one factor. And the other thing that we have identified in the study has to do with the power asymmetry that exists between African states and the corporations that operate in the extractive industries. The nature of this power asymmetry is such that the bargaining power between African states with the limited technical expertise that they have at their disposal and the enormous technical, financial power that is at the disposal of corporations is such that the field is not plain. The field of negotiation and bargaining is not even. It is skewed in favor of the extractive companies. And you add to this layer the fact that many of the arrangements on the operation of extractive companies are regulated by laws that are not in the realm of human rights. Sometimes they are regulated by bilateral investment laws, bilateral trade treaties. Again, these are legal regimes whose wiring by their very nature draws on the weaknesses of African states rather than their strength. So if you take, for example, dispute settlement within that framework, one of the things that you find in many countries is basically dispute settlement as far as investment from within the framework of those bilateral investment treaties or trade treaties wouldn't be left to national jurisdictions, national courts. It is actually taken to tribunals, dispute settlement tribunals that operate elsewhere in the world. The valuation of these resources is not determined on the African continent. The market that determines the value of these resources is located elsewhere. And Africa doesn't have control over it. This past couple of days, you were listening to the United Arab Emirates walking out of OPEC. OPEC was created to exactly avoid the determination of the values of oil by markets that are not influenced by those who produce the oil. Now, you can hear a very unpalatable reference to OPEC. They call it what? Cartel. All right? Simply because they established that system in order to protect the interests of the producers. It is referenced as what? As cartel. Systems. There are licensing. But what we see is proposed to change their mining codes. And terms of license as well, any mining license. As resources. It's not intended that we are not neglecting the value of those resources. So that it's we are made worth of because of the extraction process, because the externalities of these processes in terms of health, in terms of dispossession from land, in terms of environmental degradation, who bears that cost? People became poorer, dispossessed, displaced, and impoverished because the externalities are borne by people. So part of the question that we have been asking of the working group on extractive industries is, what are the things that we need to do? Part of the factor for this is addressing the legal vacuum that allowed these areas of, public life to operate outside of the application of human rights law. And bridge the gap between other areas of the law and human rights law. That is extremely critical. So which means that we need to tackle the exclusion of the legal jurisdiction of national courts when it comes to grievances, when it comes to access to remedy. Communities need to have access to remedy. For that, national courts need to have jurisdiction over these issues. Without that, we cannot be able to ensure access to remedy. Two, we need to have laws, but also regulatory institutions that are empowered to actually adopt, to monitor first. For that, they need to have the technical capacity, but also to enforce legal standards, whether that is in relation to environmental impact assessment or the monitoring of, the operation of extractive industries as far as their impact on the environment is concerned, social and human rights impact assessment, tax responsibilities, so that we address illicit financial flows, transparency requirements, so that we address corruption, because this is a sphere that is riddled with corruption, and that is one of the factors. All right. And then, of course, importantly, to ensure that communities, affected communities, are provided with minimum guarantees in terms of participation, in terms of access to information, and of course, as I mentioned earlier on, access to remedies. And there is one thing that is also important. We often talk of, in this sphere, about the obligations of states. Of course, the states are the primary holders of responsibility, no doubt about that. But given that we are in an era of big business and companies whose power and influence far exceeds even the most powerful of states in the world, there is something that is fundamentally destabilizing for the human rights system that arises from this development in human societies. And that is the accountability vacuum that relates to this most powerful phenomena, corporations. There is a contestation that has been happening within the framework of the UN, led by South Africa and Ecuador, for the establishment of a binding legal instrument on business and human rights. Happening for a long period of time, not going anywhere. So basically, there is also, therefore, that need for understanding the obligations of businesses. We cannot just treat them as an entity that can use its discretion and responsibility responsibly. As have been mentioned earlier on, it is motivated by Danish, it is motivated by profit, and therefore the tendency is to basically be, the gravity is towards making profit rather than exercising its authority responsibly. So there is a case to be made for establishing legal obligation on businesses and holding them accountable for that. And what that requires is basically not just administrative accountability, but also, even as Don mentioned, the question of criminal accountability comes in. That is extremely important. Now, beyond the national level, however, as have been mentioned earlier on, by Don again, individually African countries, in the face of bargaining with most powerful actors, stand very little chance of overcoming the pressure, addressing the power asymmetry, and creating the conditions for the protection of the interests and needs of people. And therefore, what do we need? We need to elevate the scale up to the continental level. That is extremely important. That is why Article 21 of the Charter actually clearly recognizes the collective responsibility of states. It is one of the provisions of the Charter that talks of collective responsibility of states. Exactly because it is cognizant of how deeply entrenched the odds are against Africa. for individual states to deal with these issues on their own. And therefore, that is where the resolutions that Abiola made reference to and the minister made reference to call for a regional legal instrument. That is what I was referring to when I was addressing His Excellency Ambassador Willie Nyamitwe, for us to discuss it within the framework of the PRC as well. The idea of that is not to replace the Malabo Protocol, which deals with criminal responsibility. It is actually to address one important factor, which is to create a regional dispute settlement framework where disputes relating to the interpretation of licenses would be addressed at a continental level. This is not about the criminal responsibility dimension of things. There is a gap that needs to be filled in there. That is what that resolution is referring to. And of course, articulating the obligations from a human rights perspective. And that would also speak to the gaps that Don made reference to of linking the human rights norms with the wider African Union instruments relating to mining vision, relating to the SAFTA, to which the resolution itself makes reference actually. All right. And when it comes to, of course, critical minerals, I think that is where I will end. It is really about avoiding the repeat of the cycle that Africa endured for a long time. It is about avoiding that. That is why we need to elevate the discourse and the conversation. And I welcome what the minister said earlier on. At the highest levels within the African Union system, we need really to have serious discussion about this thing. Whether we are negotiating on critical minerals, so-called critical minerals, from a position of weakness and vulnerability or from a position of strength. That's why in some circles, beyond and above the common foreign policy that Don made reference to, one of the calls is basically the establishment of an African common authority on strategic minerals along the lines of OPEC that would actually provide the minimum protection, the minimum shield that is required by integrating human rights and standards into these things. We need to have that continental framework that would enable Africa to have that role that it needs to play. And therefore, ladies and gentlemen, one of the things that I would like to invite you beyond and above all of this work is also distilled into the state reporting guidelines and principles on Articles 21 and 24 of the African Charter on Human and People's Rights. I kindly invite each and every one of you to have a copy of the state reporting guidelines and principles on Articles 21 and 24 of the Charter. What we did is, when we talk about human rights, we cannot limit ourselves to what we know as members of the human rights community. As Don rightly raised, we need to interrogate the tax law of countries. We need to interrogate the banking law of countries. We need to interrogate trade and investment legal regimes of countries. That is where the vacuum can be filled and the necessary protection mechanisms can come in. That doesn't mean that we do not need civil society. We do not need national human rights institutions. We do not need litigation. We do not need social movement. We need all of these, but we cannot limit them to the sphere, as Don mentioned, to what we are normally used to. That is talking in the same area to the same people in the same way, talking to the converted. That model doesn't work, hasn't worked, and it needs to change. We need close, accountable system of governance. Cannot replace anything. Without accountable system of governance on our continent, we cannot be able to avoid the repeat of what has been done before. That's why the whole question of accountable system of governance and democracy, not in its procedural sense, in its substantive sense of being responsive to the needs of people, ensuring the progressive upliftment of the standard of living of the masses of our people becomes so crucial. And how do we get there? The work that has been done by the Working Group on Extractive Industries provide the foundation. But the implementation of it, the follow-up of it, and its actual life within society depends on the work each and every one of you sitting here would be able to bring and to do. And we need to bring in all the sectors of society that Don made reference to earlier on. And we need to add to that list the media. We need to engage the media in all its forms and manifestations in order for us to mobilize the active engagement of the cross-sector of members of society, whose role is critical if we are really going to avoid the repeat of what is described as the resource curse and turn these strategic minerals into not just opportunities, but also blessings for advancement of the welfare and well-being of women, girls, children, and men of this wretched of the earth that is our Africa. Thank you very much. One last point that I wish to make is that, please note that under the African Charter, sovereignty over natural resources belongs to the people. It is very clear. These resources, it says, have to be developed in the exclusive. It didn't say just in the interest of people. It says in the exclusive interest of people. The points that Abiola made about beneficiation, value addition, and ensuring that we get the best benefit or the best value for resources depends on the kind of responsible system of government that we have. The state has delegated sovereignty over natural resources, not original sovereignty. Original sovereignty belongs to the people. And we need to engage litigation, social movement on the basis of that. Thank you very much. I now go back to the agenda and invite further reflections, particularly for session 3, where we have the pleasure of Miss Helena Kelonzo, AU Women, Gender and Youth Direct from AU Women, Gender and Youth Directorate, Dr. Javed Bayagon from Amnesty International, Mr. Stephen Korir, representing the state party, the Republic of Kenya, and then we have Mr. Lansana Odroago from the Center for Human Rights. So we have the AU Commission, civil society organizations, NGOs with observer status with the Commission, and a state party represented in this platform. I will give the floor first to Ms. Helena Kilonzo from the AU Women, Gender and Youth Directorate. And this is on how we address the human and people's rights protection vacuum in the extractive industries. The floor is yours, please. Most welcome.
Thank you. Thank you so much, Ambassador Solomon, for this wonderful opportunity that you've given me. I'm here representing women and youth, and it's to voice our submission onto the point that human and people's rights not only affect men, women and youth carry the huge burden. So in my presentation, I am presenting from the point of the perspective of women rights, how the factors these violations have contributed, and probably the possible interventions that you may consider going forward. In my context, I'm looking at rights at risk. The extractive industries are a key economic growth across Africa. Yet they carry significant risks of human people's rights violations. Weak governance creates accountability gaps, leaving communities exposed to displacement, pollution, and deepening inequality. On governance gaps, weak oversight enables unchecked corporate conduct and limited state accountability. On community impact, that these violations, displacement, pollution, and loss of livelihoods disproportionately affect the local populations. Women and youth in all these extractive industries bear the greatest social and economic cost of the extraction activities. When we talk about the protection vacuum, we are saying that despite the existing frameworks, critical gaps exist. But the institutional muscle for consistency in the protection rights, of rights within the extractive sector, the enforcement remains limited. And communities are rarely meaningfully consulted before these projects begin. When we are talking about the limited enforcement, we are saying that even though safeguards exist on paper, lack of institutionalizing the muscle for consistent implementation is evident. Local populations are insufficiently engaged in decisions that directly affect their lands and lives. On gender blind policies that sometimes these frameworks make rarely incorporate gender responsive provisions and protections. Fragmented oversight on regional frameworks remain disjointed, undermining the coordination and accountability across borders. When we talk about the natural resource curse in Africa, even though we brag about vast wealth of resources, paradoxically, this has fueled instability and persistent poverty, a phenomenon that we always call it a resource curse or a paradox of plenty. Rather than generating shared prosperity, resource extraction has too often entrenched inequality and conflict through revenue management, where public funds are diverted for gain. And we see evidence of financial accountability mechanisms. Extractive industries have resorted to armed groups and resource-driven conflict among local populations who suffer from violence. Land and water resources have been destroyed, and negative health impact, as has been said before, on communities. We have continued to see resources benefit the elite, not the poor, and thus leading to limited improved rights, living standards. The role of the working group, as has been stated before, the working group has played a very critical role in transforming how Africa governs its natural resources, centering on gender equality, youth participation, and inclusive policy across member states. By promoting policies that recognize and address the distinct impacts of the extraction on women. The working group has also strengthened meaningful inclusion and youth in decision-making processes. The working group also has supported alignment of extractive governance frameworks across the AU member states. It has also on inclusive benefit sharing and advocated for mechanisms that ensure communities receive equitable resources, returns on the resources. My proposal for strategic interventions, when we talk about closing the protection vacuum, this requires concrete, coordinated action from all stakeholders in regulatory, institutional, and community levels. The 4 pillars form a foundation of our rights-centered governance approach, which embed human and people's rights obligation into existing regulatory frameworks. Through community consultation, there is need for establishing structure, inclusive mechanisms for free, prior, and informed consent. Transparency as mandated disclosure of contracts, revenues, collection, and benefit sharing arrangements. Through capacity building, which strengthen national institutions to monitor, enforce, and report on rights compliance. Empowering women and youth leadership transforms extractive governance is inseparable from empowering those most affected. Women and youth must move from the margins to the center of resource governance as decision makers, advocates, and beneficiaries. In governance, women representation in negotiation and oversight bodies, gender-sensitive impact assessments, protection from gender-based norms linked to extraction. On youth engagement, including them in discussion in natural policy dialogues. Also, skills development tied to extractive sector opportunities and youth-led accountabilities and monitoring initiatives. The way forward is to align with 2063, a bent extractive governance reforms within the AU's Continental Development Vision. Also, this need to strengthen the AU coordination to build a robust platform for cross-border oversight, data sharing, and policy alignment. On rights-centered resource economies, there's need to build sustainable, inclusive economies where natural wealth benefits all, including women and youth who are most vulnerable. The goal is a future where Africa's natural resources are a foundation for shared prosperity, not a source of conflict and exclusion. Thank you.
Thank you very much. I'm mindful of the time, but despite being mindful of the time, I wanted her rich presentation to get full or all the time and attention deliberately, because the area that she covered clearly highlights one of the sectors of society that bears the brunt of the adverse consequences of the operations of extractive industries and the kinds of precaution that needs to be factored in our engagement and interrogation of the adverse impacts of the extractive industries, and how these precautionary measures can be integrated at different levels from the national all the way to the continental level. So thank you very much for that. I now hand over the floor to Jafet for his intervention. I don't think that I will be as generous to Jafet as I was to an important intervention on that. Jafet, you are warned.
The power asymmetry is very clear. Thank you, Commissioner Solomon, for this opportunity. I want, now that I have a very strict warning, we were asked to speak about the factors and conditions that have enabled the emergence and persistence of the resource curse in Africa, and how that contributes to, and the place of the protection vacuum that we have on the continent. I want to propose and simply build on what other speakers have said before us, before this panel, and to focus on three main things. The inadequate regulatory frameworks or poor enforcement that Mrs. Kilonza has actually already mentioned, but with a focus on women and girls. The corruption and lack of transparency, and economic marginalization as some of the three factors really that contributes to the resource curse that we experience on the continent. As a starting point, we know that regional and international standards do clearly say that companies, multinational corporations, businesses have a responsibility to respect human rights in whatever sector that they are working in, and regardless of their size or nationality. They have a responsibility to protect human rights. But the biggest challenge that we have is two intertwined issues. One is the inadequate regulated frameworks to regulate the activities in exploration and management of resources by these private actors, or where there actually exist strong regulatory frameworks, the failure to enforce or implement those regulatory frameworks. The result is that across the continent, we have predatory investment by multinational companies, by businesses that actually engage or enter into unfair secretive contracts with governments, with institutions, predatory investments that prioritize profit extraction over local development, over the dignity and rights of local communities. And therefore, we see that despite the existence of and efforts to legislate, we still have predatory investment and predatory extraction across the continent. And the link also to this is then that we have a failure of accountability, an accountability vacuum. But in this particular context, the African Commission itself has laid very clear jurisprudence on the questions of accountability. While the responsibility of multinational companies and businesses is to respect human rights, the ultimate duty bearer is the state. And we remember, for instance, from the CERAC case, that the African Commission first said that despite the multinational companies violating human rights, it's the duty of the state to ensure that they do not violate human rights. And if they violate human rights, that the state will ensure that justice and accountability is ensured in the CERAC case. And most recently also in the Kilwa case that involved DRC and the Anvil Canadian company, where again the African Commission says that the state bears the responsibility for ensuring that it has the regulatory frameworks to regulate these companies, or if they violate human rights, that they are held to account. The second biggest thing, and Solomon did mention this, is corruption and lack of transparency. Because of the high value of extractive industries and the minerals and other natural resources that we have, this is a sphere that attracts rent seeking, that attracts patronage. And Africa loses millions of hundreds of dollars every year because of corruption and patronage and rent seeking. And here, perhaps one of the important issues to bring into this conversation is also the place of the African Union Board Against Corruption. That could actually then conduct, for instance, studies on the extent to which corruption is embedded in the critical minerals area, but also more generally in the natural resources exploration and management. And thirdly is economic marginalization. It has already been stated here that local communities, just leave alone the whole country as a whole, but local communities that actually live near exploration of natural resources, critical minerals, are rarely consulted, are rarely given a voice, but even more importantly, rarely benefit from these resources. The result we have, for instance, is the conflict we had in Niger Delta, is the conflict that we have in Eastern DRC and in many other parts of the continent. A study a few years ago by the UNDP showed how marginalization of economic marginalization of communities are the spur or the root causes of conflict across the continent. And here again, when it comes to economic marginalization, we see a decision from the African Commission, the Enderois decision, where the Enderois people had been marginalized from the resources that they were receiving from the Lake Bogoria ecosystem. And the African Commission actually recommended the payment of royalties to be shared with these communities. So the African Commission, its jurisprudence actually set out a standard on how royalties, on how income from natural resource extraction and management can be done with local communities. But these three issues that I've mentioned, regulatory frameworks, corruption and lack of transparency, economic marginalization, I want to submit to you are actually symptoms of the problem. The bigger problem is a leadership problem. The legal problem is a political governance problem, a failure of natural resource governance problem, a failure of debt governance, a debt governance problem. So sometimes when we speak of a resource curse, the word curse presupposes that there is an outer being that brings this curse. But we are the architect of the curse because of political leadership. Commissioner Solomon Derso did mention that the previous generation of President Songo, of President Dawada Jawara of Gambia, who gave us the African Charter, had a purpose. The problem is, what is the purpose of our current leadership across the continent? And when we speak about natural resource, I know our focus is on critical minerals, but we have to link this to the whole range of resources on the continent, beginning with what Don Deas talked about, we the people as the main resource of Africa. We see Africans in labor camps in Cambodia. We see Africans in other parts of the continent as being used in that context. We have seen about the medical data that is being used on the continent. We have seen about ports that are being sold, railways that are being sold. So our resources beyond critical minerals are actually being violated. I want to suggest some 3 things that have already been mentioned before, but just to put emphasis of them. One is strong domestic institutions coupled with civic space and strong citizen engagement. We have seen in the context of health data, for instance, in Kenya, where the High Court has suspended or stopped for the time being the implementation of that health financing bill. So strong institutions that can be able to control the leadership and the executive arm of the government. 2 is that the AU has been discussing, at least since 2015, the AU policy on business and human rights. But somehow it has just stalled in the pipeline, and maybe even passed by time, because now we are demanding something more tangible, something more binding, like a regional binding treaty on business and human rights. I think I'll stop there for the time being. Thank you, Commissioner Solomon.
Thank you very much. We live in a capitalist world, so the tendency is to look at everything as either a market or as a resource. So I warn us against using human beings as resources, please. That is a very capitalist language. May I, on that note, and me, Jafet, and others will talk about this African Union, what is it called?
The policy.
We have to ask for member states, where is the origin of that policy, honestly? Yeah?
What did you say? EU.
Okay. I mean, what does that tell you? Let me move to let me move to the next speaker, and that is Mr. Stephen Quarrier from the Republic of Kenya. Jafet mentioned one important thing here, the role of civic space. And of course, leadership and responsive system of government. These are really, really critical. I don't think that we can continue to blame others. We have to assume responsibility for our own situation as well. If others come and take resources in a very extractive way, we have to ask what made that possible for them to do that, beyond and above the power that they have. There must be something from us that made it possible. And that's why I think those points by Jafet become so important. And the litigation going to the High Court that stopped Kenya from proceeding with a negotiation that was ongoing with respect to data protection, for example. So we are happy to have with us the representative of the government of Kenya to also share a very important perspective from the angle of a state party to the African Charter on Human and People's Rights. Stephen, most welcome. Thank you again.
Okay, thank you so much, Commissioner Solomon. I think it's my pleasure to be here once again, and I'm going to take you through the lens as far as this topic is concerned as regard to Kenya. Okay. Oh yeah, it's been projected. If you look at what my colleague here has just said, he pointed out 3 issues. And I want to categorically say that in Kenya, the president issued a stern warning to the corrupt. And he said 3 things. He said, 1, do away with that behavior. 2, you go to prison. And 3, you leave this world early. So based on that, we know that as a state, we have a responsibility, and a responsibility to protect arises out of the constitutional dictates. The law provides us with the platform in which we ride on our daily activities. From what I've gathered, it's that we all have the gist of what all this conversation is all about. You know, we came out of what the commissioner had said earlier, colonialism. And if you mark it out, perhaps if you come to Kenya, and I invite you to come to Kenya, and feel free to visit our museum. You will find a small portrait at somewhere at the corner of our founding father, President Mzee Jomo Kenyatta. And in it, there's a quote that said, the colonials, the European came and told us to close our eyes and pray. And while they were praying, they took off with the land. So when they opened up their eyes, the land was gone. So it's the same rippling effect that we are feeling right now, because the minerals, and I can just teach my commissioner solo. There's a maxim in law that says, quid plantatur solo solo sed it. It means that whatever it's planted in the soil belongs to that soil. But nevertheless, the minerals are never for any individual. It belongs to the government. That said, if you look at what we experienced through colonialism, it's that they gave us the Crown Land Ordinance. When they came in, there was the first, from the East African part of Africa, there used to be the East African Protectorate that covered Tanzania, Uganda, Kenya. So they came up with the Crown Land Ordinance of 1902 that spelled out that the land belongs to the Crown. So basically, we still live in that miasma that these all issues still belong to the colonial master. And if you look at it critically, in our laws, we've entrenched that minerals belong to the government. So out of this topic, we've been able to see part of what has made us call it a curse, because it's a paradox, because we have plenty as a African continent. And if you look at what factors contribute to this being a curse, you might as well point out on issues like state capture, or the corrupt of the elite, as it has been said here, community exclusion, as well as weak institutions. In this regard, we know that at least Africa plays a very critical part in terms of mineral extractions. So in Kenyan context, the key examples that I can project today, we have oil and gas, and a good example is the tallow oil that it's extracting oil in Turkana. And of course, we now have complaints that they don't have, they did not get the good deal in terms of resource sharing. And of course, again, as a government, we don't have that law in place. The law is still in process. So we have the natural resource benefit sharing bill of 2022, which is supposed to now cover up these issues and be able to give each party that is concerned its own benefit. Part of the issues, the rights issues that have been raised in terms of the Turkana is also FPIC deficit. You realize that FPIC is a phenomenon that maybe we can attach to the declaration on indigenous community, indigenous, yes. It's not really brought out well in our laws. And that is what is another problem as well. But going forward, we've noted it, and we intend that anything to deal with marginalization, it has to be addressed under this FPIC framework. So those are just part of the companies. We have the coal mining in Kitui County, and some of the problems include environmental issues, climate impact that this coal mining might cause. So these are the basic problems that attaches to mining. And if you look at the area at the mining in Brima Hills, it's the same issues. So in terms of Kenya getting into play in these issues, we have a robust constitution, which is the primary legislation that governs our state, and out of it comes out other legislations. It's the bedrock for other legislation. So we have the constitution and various articles that addresses issues of community rights, land rights, as well as principles of governance and national values. As far as Kenya is concerned, we can say we are at par with the world in terms of having a progressive constitution. But the issue we can say is partly implementation, lack of implementation. Because already we have the Mining Act that covers everything to do with mining. We have regulations under that. We have Community Land Act. And this is where the problem is also, that communities are supposed to be recognized and registered. Their lands are supposed to be registered, but if you look at the status currently, it's not what had been projected. We are supposed to have probably registered all the community lands, but that has not been done. So that's part of the problem. Now, the National Resource Sharing Bill is in the pipe. We have the Petroleum Act. All these legislations are supposed to cover things to deal with the extraction of minerals, oil and gas, and etc. So Kenya, I think it's in good place in terms of legislations. This I've mentioned, this slide, we also have policies in place. We have policies in place. We've been able to come up with the national public participation policy that enables the public to have a meaningful participation in every item that affects them, the decisions that affects them. They're supposed to come in and participate. We also have the NAP on business and human rights, which is meant to ensure that as a state having this responsibility, it also means that other parties like companies and third parties are supposed also to respect the human rights aspects in terms of carrying out their businesses. And again, in that policy, there's a remedy framework where we encourage access to justice in terms of either state-led judicial mechanism or non-state actor grievance handling mechanism. So in that note, we also have the recently passed policy on ethnic minorities and marginalized communities. And these issues have been put in that policy that we are supposed to ensure that they are part and parcel of Kenya. And that whenever anything on extraction, they are supposed to entrench FPIC. So I think touching base to the problems that have been raised by my colleague here, lack of regulatory issues, I can attest that at least we are better off. Corruption and transparency, this is an issue that cuts across. It cuts across. And I think the most challenging thing is that the contracts that perhaps government entered into with the multinational companies, that's where opaqueness comes in. And we might be lacking expertise in those fields. Capacity we don't have. Being able to mine these minerals, we can't. So I don't know whether there is imbalance in terms of negotiation power, and that's why we have been taken advantage of. And you mark you that whenever you enter into a contract, this contract might be by its binding. Of course, it's binding. And the terms that you've agreed, since the citizenry don't know, it's the government and that party. So that could be a big problem, a very big problem. But in terms of us coming up with ideas on how to solve them, we are best at it. Again, so in terms of land rights, we are doing well, apart from the gender issues that we are here to recognize that women also need to be at par with men. In terms of environmental rights, it's entrenched in the Constitution, and we have an institution that governs environmental issues. Basically, when we talk about mineral extractions, we intend that at the end of it all, it's that it will be beneficial to the communities, and that the money that comes out will be able to engage in development, social development, and economic development. But it's not always the result, because if you take, for example, our oil extraction in Kenya, we have not seen any benefit so far. And I don't know the agreement, whether it was to be shared within a certain ratio for a number of years. So we are still waiting for it to come to us. So issue of transparency, this is now the solutions that are meant to cure the defect. We have accountability, transparency, good governance, participation. We're supposed to encourage FPIC and participation of the citizens. And then we have to put in place the benefit sharing framework. So those are the things that are ongoing. Yeah, I can conclude because I think the rest is just a repetition of what has been said. I wish you all the best, Commissioner.
I think that is the highlight of this morning, right? There are some obligation takers. But Stephen, I think this was really great because you highlighted project areas for rare earths, for oil, for other cobalt, and so on and so forth. And then under each of them, the examples that we made reference to in terms of problems, whether it is land dispossession, whether dispute settlement, license, free prior informed consent, issues relating to water competition, for example. I mean, all of those issues that we have been talking about this morning basically illustrated in specific sectors of natural resource development in Kenya. I think also the experience of responding to these through legal development that you have outlined also gives perspective in terms of where we stand vis-a-vis the challenge that you mentioned, including lack of expertise and the power asymmetry, question of transparency, question of corruption, a question of participation that you mentioned of affected people, for example, and what is the legal regime that exists to enable that participation. And of course, in some of the areas, as Javed also, illustrated, there are at least people can go to court because of the nature of the constitution, and of course because of the fact that courts still remain an important domain of independent authority, okay, that is much more amenable for upholding the constitutional norms. Where courts do not do that, of course you would have a much more problematic situation. So the role of courts, okay, that you didn't mention but came earlier from Javed, is also another area that we need to flag. And therefore, the whole question of, you mentioned dispute settlement, but that suggests to me that there are certain terms that suggest that it's not courts at the national level that have a role, it is somebody else elsewhere in the world. And what does that mean from a constitutional perspective, which invests national courts with full authority to address any issues that arise within Kenya? Is that even a constitutional thing? I mean, and the other thing that you said is many people do not know what is contained in the contracts. Okay, again, right? So I think really that illustrates to us a number of things that need to happen. And thank you very much, Stephen, for wishing me best of luck. And you said that we are invited. We requested to come, and we are yet waiting for your response. Okay, so there is progress. It's coming. We are going to undertake a promotion mission to Kenya. I mean, that is extremely important. I think the last thing really is that I want to say is how much of what you are working on, Stephen, is actually drawing on the work of the African Commission, including the jurisprudence that he made reference to. For example, the Indorois. How much is that informing the legislative and institutional framework that you are building? I'm not sure about that. I think it would be good if you also make reference to the Ogie case that we have been long working together, and in Doris case there, those are important for you to reflect on as well, as part of your thing. Last but not least, and I think that would end our morning session from what I was told by our boss. And the last speaker would be Mr. Lansana from the Center for Human Rights. Please help us. You are standing between these great people that you see in front of you and their lunch.
Okay, Commissioner Solomon, thank you very much. I think a lot have been said about the issue we have been discussing this morning by great minds, and then I'll help us to have to save more time. Yeah, on the diagnosis, I think I'll skip some of my presentation points, but I would like to stop on the charter's promises. Solomon has highlighted it in the morning. The main provision in the African Charter is Article 21 on the free disposition of wealth and natural resources by the people, and that must be done at the best interest of the people. We also have Article 22, which is the right to development. Obviously, Africa is the only continent to have the right to development provision in its human right instrument. Yeah, nowhere you cannot find such kind of provision. Also, we have Article 24 on the right to satisfactory environment, and yeah, and it has translated into several jurisprudence that also have been highlighted this morning. But where is the vacuum of human rights? Uh, uh, my main argument is that it's not in the standards per se, but it is in between the standard and the implementation or the practices. We have beautiful instruments with sound provisions that protect communities, that protects people. But when it's come to practices, when it's come to implementations, that's where the gaps lie. Uh, I think four conditions sustain the vacuum. The first is the regulatory fragmentation. The second is the opacity in the, let's say, the extractive sector. The power asymmetry you have highlighted, and also the marginalization of some part of the population that Helena also has highlighted. And when she was highlighting women, gender in the industry sector, it reminded me on children. What are the issues regarding children in the just transition, the critical mineral sector? We are aware of what is happening in DRC, Zimbabwe, and Zambia as well, where what is happening currently is that children are abandoning school to join the mining sector because of a lot of structural issues. But what are the responses from the Working Group Commission and from the brilliant mind in this room? And it's yeah, I am also wanted to highlight few elements. We have a strong jurisprudence starting with SERAC. I'm not gonna go through my notes, the Endores case and the Lido. And for me, the Lido case is very important. The Trafigura wisdom in Abidjan. The court has done an amazing work, but it has a limit that I wanted to highlight. And I think most important voice than me has also touched on, which is Blaise Chikaya. I think he issues his opinion on it, but I wanted to emphasize on it and also take us back to the working group reporting guideline on Article 21 and 24. On this reporting guideline, I've engaged with it in 2019 and 2020 while I was trying to write a dissertation on business and human rights. And I found it very interesting, well written. One may look at, there is a section on company duties starting at paragraph 51. It has highlighted that a company has duties under the African Human Rights Charters, but through a progressive rating of Article 27. And I think the main debate around the question of multinational accountability, private sector accountability in the human and business right fields lies on the personhood of companies under this general international law. I think there is a need to settle that question at the African level. A lot of work has been done. The report itself, the Malabo Protocol, but I think there is a more to do. Maybe that can be translated as an invitation for the working group to do a report or to write a guideline on how courts can understand Article 27. For me, it's very important. Yeah, that will help everyone in the sector, everyone in the field, to have a better understanding on the personhood of companies. Implicitly, it says that these entities has duties under international law, but explicitly, it's not there. Then there is a need to do something. That's where lawyers has been fighting decades ago on this issue, and I think it has a huge implication. Donald also has touched on the dialogue. I think between Banjul and Addis, maybe Arusha as well, where the court is sitting, if I'm not mistaken. For me, it's very important, such kind of dialogue. The AFCTA has a framework on trade, but the most important framework for me on the business and human rights perspective is the protocol on investment. This protocol has a lot of provisions on corporate accountability, not accountability, but obligations, environmental obligations, human rights obligations, and so on. For me, there is a need to have such kind of dialogue where not only those in the trade and investment sectors have to come to the human rights issues, but those in the sector of human rights issues also must go and look at what is happening there and draw lessons. And my final words is to say that throughout the discussion in this room, Africa's resources are not cursed. No, for me, African resources are not cursed. The governance of those resources has been. And then for me, that's the right moment to do something about it. And Chair, thank you very much.
Thank you very much. I'm looking at Abiola because I'm sure our Tammy must also be knocking to say we must get something, what we are entitled to. I don't know if it would be good in the interest of you all and respecting you if I allow one or two interventions, one or two quick interventions without the need for us to respond from the floor. Sincere apologies to all of you, but I thought it would be good if we have interventions, I don't know, pick up anyone who wants to comment on anything or to ask question or to probe, problematize, whatever you think of. Just one or two quick. Excellence, Mr. Faye, I gave you the floor first, and I'm looking at a lady. Yes, a lady. Okay, thank you very much, madam. I'll give you the floor next. Yes, Mr. Faye, let me start with you.
OK. Merci beaucoup. C'est un réel plaisir pour moi de prendre la parole à l'occasion de ce forum régional sur les industries extractives, les droits de l'homme ainsi que l'environnement. Moi, je voulais juste faire une contribution. Je ne pose pas de questions, mais une contribution parce que je dirige le comité national ITIE Sénégal et nous savons le rôle que jouent les droits de l'homme dans le cadre de la gouvernance des industries extractives. Et pour nous, c'est extrêmement important pour la Commission africaine et notamment le groupe de travail de voir quels sont les liens qu'on peut faire pour jouer un rôle fondamental dans l'intégration, dans le cadre de la norme ITIE, les aspects liés aux droits de l'homme. Parce que c'est une norme qui évolue naturellement tous les 3 ans. Et chaque évolution, il y a de nouvelles règles qui sont insérées dans la norme. Et en Afrique, on a plus d'une vingtaine de pays qui sont déjà membres de l'ITIE. Et sur 55 pays totalement au niveau mondial. Donc, vous voyez le rôle que l'ITIE joue c'est-à-dire les pays africains jouent au sein du secrétariat international de l'ITIE. Et d'ailleurs, le Sénégal, c'est pas pour nous glorifier, le Sénégal est le premier pays de mise en œuvre de l'ITIE d'après les évaluations qui sont faites. Et donc, on n'a rien à envier les pays développés. Et donc, pour nous, c'est extrêmement important de voir quels sont les liens qu'on peut avoir, ne serait-ce qu'en regroupant un certain nombre de pays, travailler sur des indicateurs clés qui seront traqués au niveau de nos différents pays et qu'on pourra à chaque fois évaluer aux besoins. C'est ce que je voulais ajouter. Je vous remercie.
Thank you very much. Madam, I am prevented from reading your name, so if you kindly introduce yourself as well, please.
My name is Esther Findakande. Esther Kande from Sierra Leone.
Most welcome.
Yeah, thank you. It's a question. Because from the discussion since this morning, these are issues we have been discussing. Is it? Yeah. Oh, the mic is on. Okay. Yeah, these are the issues I've been discussing for a very, very long time. And one of the problem I see here is, like the chair was saying, is a negotiation. And I was just thinking, is it possible for Africans, to have trained people, not per country or so on, but trained people that can represent different countries or Africa to negotiate on their behalf? Because this is where the devil is. And because our ministers, for instance, in my country, you have like 5 years to serve. That is, if it pleases the president. Otherwise, after 2 months, you can be sacked. And these ministers are so desperate to making sure that they bring in investors, whatever they call in investors, so that they can have good names or whatever, or they can have whatever they want to have. So at the end of the day, can go into any kind of negotiation. At the end of the day, people continue to suffer. So I'm just asking if this body can think of something like that. We have specialized people. That person does not need to be in your country. But these are set of people as Africans. We decide the people that have integrity, that have love for the country, that can make good decisions on our behalf. Thank you.
Excellent. I'm sorry. Excellent contributions from the two interveners. I know that there are more hands to intervene, but as I promised, with those two interventions, one is as part of the bridge making that Don made reference to, there was a proposal on also leveraging and engaging with and having dialogue with Extractive Industries Transparency Initiative. I think that is the point that Mr. Faye made. Madam Kande made a very important point. Is it possible to build a pool of experts, African experts, who can be actually enlisted to African states for enabling, basically for creating that playing field to address the power asymmetry? I think that is really a very important point. I hope all those who are intervening are taking note of the issues. I will just give 1 second each for a word or two from the members of the panel. I have taken note of your point about Article 27 of the Charter as it relates to the obligation of corporations. We have raised it in a commentary with a former colleague of mine when it comes to the court decision. And I'm happy that in some scholarly sectors, the work of the working group is being picked up in a very nice way. That is encouraging for us. So just one word, Madam. Let me start with you.
Thank you so much. What I've heard, what we've discussed is critical going forward. But my plea is women voices are important. As we think, as we even consider the proposal from Madam Kante, these experts, pool of experts, women play a key role in moving things forward. Thank you.
Um, okay, from my yeah, I would like to encourage the working group, as I've said, to have a sound engagement with all stakeholders. I think that's the best way to be able to capture what is going on each sector. Yeah, thank you.
I think maybe just to respond to Madam Esther, there is already some precedence in terms of building a pool of experts of AU negotiators in the context of climate change and climate justice, where we have AU negotiators who attend and negotiate during the conference of state parties. But of course, the challenge is the number and the range of expertise, because you find that other countries have many negotiators on very small, tiny issues. But maybe we have only a few on the general issues. So just not building the pool of experts, but in the whole range of issues. I think that will be my final point. Thank you.
Thank you so much. Maybe also to ride on Esther's comment is that we need to bring back our ethos, patriotism, integrity, and embrace transparency and accountability. I think that's all.
Please join me in thanking you first of all for your patience and indulgence, and the members of the panel. Thank you all very much. And I wish to give the mic to Abiola for her to make an announcement, and then we go to lunch. Thank you all very much again.
Thank you very much. I think we all deserve a round of applause. There's a lot to say, and actually we would have loved to be here for days because there's a whole lot to say, and there's a whole lot that we could be reflecting on in terms of solutions. But we want to thank you for these sessions that we've had. We will now break for lunch. It's more than one hour since we should have had lunch. So we will go for lunch for 45 minutes. It's now it's 20 minutes after 2. We will come back at 3. So yeah, so 5 minutes has just been deducted. So it's 40 minutes for 40 minutes for lunch. And we will have lunch in the same restaurant where we had breakfast on the first floor. And when we resume, we will come to session 4. We will take sessions 4 to 6 today, and we will defer session 7 till tomorrow morning. So thank you very much. Bon appetit, and see you at 3 p.m. For the panelists for session 4, please be back before 3. You need to be back like 5 minutes in advance because, leadership requires that you make that sacrifice. So we will be expecting on the podium by the time we come back to discuss session 4 on critical minerals in a shifting geopolitical landscape. Mr. Moses Balajizi Musada, a government representative from DRC. We will have Mr. Bob Felix Ositi, who is from the African Energy Commission and is a senior policy officer, oil and gas program lead, African Energy Commission. We will have Dr. Laura Ani, who is a senior legal fellow from the Nigerian Institute of Advanced Legal Studies. And we will have Dr. Victoria Nanule joining us online, an energy and mining expert and consultant who has over the years contributed to the work of the Working Group on Extractive Industries. See you at 3 p.m. for the other people and 5 minutes to 3 for the people who will be on the high table. And this session will be moderated by Mr. Eliman Khan. I thank you and see you soon. Bye. Okay, while we wait for the other participants to join us, we would like to invite those who are involved in the session 4. Dr. Victoria Nalule would like to confirm that you're online. And IT, can we confirm that we can hear her and that she can hear us? Dr. Nalule, can we test by hearing her voice?
Yes.
Dr. Nalule, can you say something, please?
Yeah, can you hear?
Hello?
Hi, this is Dr. Victoria.
Okay, can it be louder, IT?
Hello, this
Can
is
you say
Dr.
something
Victoria.
again, doctor?
Hi, this is Dr. Victoria. Can you hear me?
Yes, yes, exactly. Thank you. That's better.
Thank you.
We have Mr. Moise Balajizi Musada from DRC. We have Mr. Bob Felix Ositi from AFREC. And Dr. Laura Annie. Can we please go up to the podium? Yes, please. Hello, Chair. Okay, we invite all the participants to please take their seats. Okay, welcome to session 4. We hope that the rest of the participants will be joining us. We have all the panelists in the room, and we will just proceed in the interest of time. We were supposed to resume at 3 p.m. and already it's 17 minutes after 3. So we are on session 4 to discuss critical minerals in a shifting geopolitical landscape, safeguarding sovereignty, human dignity, and sustainable development. The moderator is Mr. Eliman Khan, Executive Director of LEGS Africa. We have Dr. Victoria Nalule, energy and mining expert and consultant online. As one of the panelists, Mr. Moise Balajizi Musada, who is a government representative from the Democratic Republic of Congo. Mr. Bob Felix Ositi, is a senior policy officer, oil and gas program lead from African Energy Commission. And lastly, Dr. Laura Ani, who is a senior legal fellow at the Nigerian Institute of Advanced Legal Studies. Mr. Eliman, I will hand over to you. We have 45 minutes for this panel, as opposed to the initially planned 1 hour. I hand the floor to you now, Mr. Moderator. Thank you.
Thank you. Alors, merci beaucoup. Merci beaucoup. Ce n'est pas le meilleur moment pour faire une session parce que après un déjeuner copieux, les gens ont tendance à observer une sieste. D'autres arriveront en retard parce que traînant avec le dessert. Alors que nous abordons en ce moment un sujet très critique et stratégique. Nous allons parler des minéraux essentiels. Et, comme vous le savez, sont aujourd'hui au menu de l'économie moderne. Je pense qu'on a un problème avec la traduction. Je ne sais pas, est-ce que vous m'entendez? It's okay for you? OK. Donc, il y en a peut-être qui ont des problèmes avec leur appareil, mais il y en a d'autres qui suivent bien. Can you use this one, maybe? Yeah, we are having it. OK, d'accord. Donc, on va y aller. Parce que, comme je l'ai dit, les minéraux critiques en Afrique attirent le monde entier. D'ailleurs, j'ai un ami douanier et essayiste qui récemment a publié un ouvrage sur ça. Il parlait du banquet des minéraux critiques. Mais malheureusement, en lisant ce livre, on découvre que c'est un banquet des minéraux africains, mais autour de la table, il n'y a pas les Africains. Pour parler des enjeux géostratégiques qui sont liés aux minéraux critiques, et là, il est question pour nous de voir comment l'Afrique peut aussi en profiter tout en préservant sa souveraineté sur ces minéraux, en faisant respecter la dignité humaine, mais aussi à s'assurer un développement durable. Ces minéraux étant concentrés dans quelques pays, mais en Afrique, il y a des pays qui en disposent à foison. Et ce qui nous interpelle aujourd'hui, parce que toutes les dispositions et les directives qui sont dans la charte, établie depuis 2018, mais quand même rattrapent les nouveaux enjeux autour des minéraux critiques. Alors, pour en parler, nous avons d'éminentes personnalités, des experts, des praticiens. On commencera par Dr. Victoria Nalouli, qui est experte et consultante en énergie et mines, qui va intervenir en ligne. Ensuite, on aura Moïse Balagizi Moussada de la République démocratique du Congo et Bob Félix Otiti de la Commission africaine de l'énergie et Dr. Laura Ani, Institut nigérien d'études juridiques avancées. On a réduit notre temps, donc au lieu de prendre 8 minutes, je donnerai à chacun 5 minutes uniquement et je vous demanderai tout simplement de faire focus sur l'essentiel des messages que vous voulez partager avec nous. Donc, je vais démarrer avec Dr. Victoria Nalouli qui est en ligne. Are you hearing me? Dr. Victoria?
Yes, I can hear you. Yes, please, I
Okay.
can hear you.
So go on, the floor is yours.
All right, okay, thank you. I'm pleased to contribute to the discussion under the framework of the African Union and the work of the African Commission on Human and People's Rights. And I'm pleased and honored to be back again because I've contributed before in previous years. This is a very interesting discussion about critical minerals, sovereignty, human rights. But I would like to start by mentioning the fact that critical minerals may be strategically important today or in recent years, but we have to remember that they remain part of natural resources. They are minerals basically, and therefore they are part of Africa's broader natural resource governance reality. What has changed now is the geopolitical context, including the global energy transition, because we all appreciate the fact that with the 2015 Paris Agreement and UN SDG 13 on climate action, all countries are focused on addressing the global challenge of climate change. And one of the ways of addressing that is by ensuring that we reduce reliance on fossil fuels, which are contributing over to 80% of the greenhouse gas emissions. Hence, we come to the reality of the global energy transition. And this global energy transition, obviously, like we all know, has necessitated the need for more critical minerals like cobalt, copper, lithium, because it's these minerals, it's these strategic minerals that are driving the global energy transition. But on the African continent, whereas critical minerals are presenting opportunities, we have to be very honest and acknowledge the fact that we have been extracting our resources for a very long time, not just critical minerals, but also other minerals, other natural resources. And the challenges have been persistent, and we seem not to be having a solution. So whether these resources are critical minerals, whether it's oil, whether it's renewable energy, at the same time, these are just natural resources. So the governance challenges we've been experiencing in the past decades are occurring right now. So it's not about critical minerals, but rather it's about how, as Africans, are able to govern our natural resources to be able to benefit from them. But something has changed, obviously, because with the global energy transition, we're seeing competing global powers seeking to secure mineral supply chains from different jurisdictions, including in Africa. And then another worrying thing is bilateral agreements are being negotiated rapidly. And there is ineffective ways of negotiating these agreements in different countries. And this has been a challenge for many decades or even centuries. Poorly negotiated contracts have costed us a lot on the African continent. And this has persisted for a very long time, be it in the agriculture sector, be it fishery, be it in the general mining sector, be it in oil and gas. Poorly negotiated contracts have really impacted us negatively. These governance challenges are being translated or are being transported into the critical minerals sector. So whereas we might sit here and ask ourselves, how can we benefit from critical minerals? The question is, we've had various opportunities to benefit from our natural resources, but why haven't we been able to benefit from these resources? I had previous speakers obviously mentioning the issue of negotiation, but we have to appreciate the fact that many African countries have invested a lot in capacity building. Myself, I was in Scotland, I studied in Scotland, and I saw many governments sending their people to really get the required knowledge and expertise. They hire big law firms. So is it an issue of negotiation? Is it that we always rush to negotiate these contracts without really understanding them? Because the expertise is there, the technical expertise is there, but then what exactly is making us lag behind? So across the continent, we have long faced structural challenges in the extractive sector and in the general natural resources sector, including human rights abuses, poorly negotiated contracts, lack of infrastructure, and even financial constraints. And then when it comes to the mining sector or even the critical minerals sector, artisan and small scale mining has been a very big issue. And we have failed to address it even in the general mining sector. So how exactly are we going to address it in the critical minerals sector? Because artisanal cobalt mining is rampant in the Democratic Republic of Congo. Environmental degradation has also characterized the extractive sector. We are all aware of what has been happening in the Niger Delta region. And then in countries like Zambia, copper extraction has not always translated into broad-based economic transformation. And in emerging lithium producers such as Zimbabwe and Namibia, we continue to see patterns of exporting raw materials with limited domestic value addition. These are the pertinent challenges we've been experiencing, even without these new terms that we are calling critical minerals or strategic minerals. So what can we do differently? And obviously the other challenge is poor governance and weak enforcement. Because in most countries we have the laws, we have the institutions, but then enforcement is poor. Transparency and accountability, they're also poor. So the governance challenges we associate with critical minerals now, they are not new. They have been there for a very long time. And it's time for us to ask ourselves, what can we do differently? Because the challenges that we're going to see, or the challenges that we're seeing, we're putting a lot of focus on critical minerals, but the focus should be what exactly has failed us in the past, and how can we address that? Because without addressing those pertinent challenges that we have been experiencing for a very long period of time, even with the existence of continental initiatives like the African Mining Vision, we still experience the same challenges. Without addressing those challenges, we are going to be wasting a lot of time with these new terms called critical minerals, because at the end of the day, these are natural resources. And when it comes to sovereignty, the commissioner had already mentioned it, they belong to the people because natural resources belong to the people. The government is just a custodian of these resources, implying that the people have to benefit from the resources. The human rights of these people, of these citizens, have to be protected. And for a very long time, our natural resources, although they have been belonging to the people, they have not benefited the people. So what makes us think that we're going to do something differently when it comes to the critical minerals? So because of the limited time we have, I believe that what we can do differently is to strengthen governance frameworks and move beyond extraction and address the full value chain, from resource development to processing, manufacturing, and industrialization. And then secondly, transparency and accountability have to be strengthened in practice, not only in principle, because in principle we have good laws and everything. And then obviously, like the previous speakers mentioned, value addition is very key. And artisan and small scale mining, that is the backbone of the African mining sector. Let's empower these miners through finances, advanced technology. Let's empower them. And then The other important thing is to ensure that African states must act collectively through the African Union to strengthen their bargaining power and avoid a race to the bottom. In most cases, we call this the neighboring effect, whereby if we don't act collectively, multinational companies are going to exploit countries individually, and countries, African countries, will start to compete amongst themselves for this capital, limited capital. And in that regard, they are unable to negotiate good deals because we can complain as much, we can make suggestions, but at the end of the day, everything starts with the negotiation. Negotiations are very key. And surprisingly, throughout this year, I started the negotiation series in the extractive industries, pinpointing the key things that governments have to really look out when they're negotiating with these multinational companies. Because we have the expertise, our people are exposed, then why do we still negotiate contracts that are not beneficial to the people? Like why? What exactly is the problem? So we need to move from policy, we need to move from reports, and we need a costed action plan of how we can benefit from critical minerals, but not just critical minerals, but also other natural resources. Because Africa, we have had natural resources for a very long time. We own over 30% of the global minerals. In the oil and gas sector, we have a lot of oil. Agricultural land, that is all natural resources. So the question is not really about critical minerals, but why exactly have we failed to benefit from our natural resources and what can we do differently? Because of the limited time, moderator, that will be my submission for today. Thank you.
Thank you, docteur. Merci beaucoup, docteur, d'avoir rappelé justement cette pression sur les minéraux liée justement à cette perspective de la transition énergétique et de dire également qu'il faudra peut-être éviter que les mêmes asymétries connues sur les mines et autres types de ressources donc se retrouvent dans la gouvernance de l'exploitation des minerais essentiels. Et donc, les défis sont nombreux de renforcement des capacités de négociation de nos gouvernements par rapport aux multinationales surtout, mais également de pouvoir gérer donc, les intérêts des populations, les droits humains et autres. Vous avez parlé, vous avez cité du Congo, on peut aller plus loin parce que le prochain intervenant justement nous vient du Congo. Il s'agit de Moïse Balagizi Moussada, qui est à ma droite. Donc, docteur a pris quand même 10 minutes, alors que c'était 5 minutes. J'espère que vous allez nous aider à revenir sur le timing, docteur.
Merci beaucoup pour la parole. Je vais m'efforcer de respecter le temps. Comme il s'agit des minéraux critiques, vous savez tous que la République démocratique du Congo est au centre des discussions mondiales sur la transition énergétique. Et c'est là, à travers la position stratégique que nous avons actuellement. Vous savez que la RDC est le premier producteur mondial du cobalt. Plus de 70% du cobalt mondial est produit en République démocratique du Congo. Et nous ne sommes pas aussi moindres dans la production du cuivre. On peut peut-être même estimer à plus de 2,5 millions de tonnes qui est produit par an en République démocratique du Congo. Alors, avec cet enjeu, la question est tellement importante. La question qui nous a été posée aujourd'hui, comment transformer cette centralité en levier de souveraineté, de dignité humaine et de développement durable? C'est vraiment une question très, très, très importante à laquelle je vais rapidement tenter de répondre à travers quelques éléments. Premièrement, je vais parler de la reconfiguration géopolitique autour des minéraux critiques. Et pour moi, aujourd'hui, les minéraux critiques ne sont plus des simples ressources naturelles. C'est aujourd'hui des actifs stratégiques qui structure aujourd'hui les rapports de puissance, les dépendances économiques, mais aussi les stratégies industrielles. Mais avec cette compétition, il est important de réfléchir en comment l'accès à ces ressources peut aider non seulement à contrôler les chaînes de valeur, mais aussi à faire de la transformation locale, mais également à maîtriser les technologies. Et donc, vous allez comprendre avec moi que dans ce contexte, il y a un risque qui se dessine pour les pays africains, notamment celui d'être, que moi je dis, j'utilise toujours les termes euh, j'utilise toujours les termes confinés dans des modèles d'enclave extractive. Alors ça, c'est un risque pour les pays africains parce que il faut qu'on soit prudent pour que nos minerais ne soient pas non seulement exploités et puis après, il n'y a pas de valeur ajoutée au niveau local. Rapidement, par exemple, pour la République démocratique du Congo, il y a des réformes qui sont initiées par le gouvernement pour faire en sorte que tous ces minéraux critiques ne soient pas des ressources de malheur. Quelqu'un en a parlé aujourd'hui. Pour la petite histoire, pour ceux qui ne connaissent pas la RDC est agressée, je dis, par un voisin verré à cause de ses ressources, parce qu'il est utilisé par des puissances, des grandes puissances extérieures, qui, au lieu de passer par la grande porte, préféraient passer par des petites portes. Et aujourd'hui, nous avons 30 ans de souffrance, 30 ans de guerre en République démocratique du Congo. C'est l'une des guerres que je dis les plus meurtrières que le monde n'a jamais connues, même si on n'en parlait pas, mais ça fait au moins plus de 8 millions de victimes, 8 millions de morts, tout simplement parce que il y a de grandes puissances qui, au lieu de passer par de grandes portes, préfèrent passer par un voisin verré et qui déstabilise la région. Donc, si je peux donner même un exemple concret aujourd'hui, vous connaissez que cette partie, l'Est de la République démocratique du Congo, regorge aujourd'hui d'innombrables minéraux critiques essentiels à la transition énergétique. On ne parle pas seulement du cobalt ou du cuivre, mais il s'agit aussi du lithium qui est là, il s'agit du tintal, il s'agit de minerais 3T, donc en général, qui sont aussi des minerais essentiels. Et si même je regarde à la salle ici, peut-être qu'il y a même ceux qui nous doivent ici, parce qu'ils utilisent peut-être de smartphones. Je me rappelle qu'il y a, depuis 2024, qu'on a interpellé Apple pour avoir fabriqué le téléphone que certains disposent ici grâce à ces minerais qui ont été extraits à l'est de la République démocratique du Congo, au sein de mes compatriotes congolais. Donc, vous comprendrez que ce forum est vraiment organisé à un moment où nous devons beaucoup plus réfléchir sur la manière dont nos ressources doivent contribuer au développement de nos pays, mais aussi à la dignité humaine, mais aussi comment ces opportunités que nous disposons peuvent être réellement de levier d'influence internationale et d'opportunités stratégiques majeures. Je vais aller rapidement parce que je n'ai pas beaucoup de temps. Je vais finir par dire, parce que c'est une situation qui pose réellement des défis. Par exemple, en République démocratique du Congo, on n'a pas tout simplement l'exploitation industrielle. Il y a aussi l'exploitation minière artisanale qui est beaucoup plus exploitée, donc on ne peut pas laisser de pas de parler de ça. Comme nous parlons du cuivre et nous parlons du cobalt, je dois ici souligner que c'est l'exploitation artisanale en République démocratique du Congo est beaucoup plus exploité par de nombreux compatriotes qui vivent de ça. Et le gouvernement congolais a engagé des réformes nécessairement pour répondre à la question initiale qui nous a été posée. Et parmi ces réformes, depuis 2018, nous avons révisé le code minier et l'une des réformes majeures contenues dans ce code minier, c'est qu'on essaie un peu de voir comment tous les minerais, tous les minéraux critiques et stratégiques que dispose la République démocratique du Congo peuvent profiter d'abord aux communautés, d'abord à nos populations, mais aussi on a essayé de voir comment on peut éviter ce qu'on a appelé de perdre notre souveraineté économique. Parce qu'avant, on se rendait compte que on était en train de perdre notre souveraineté économique. À travers ce code minier révisé, on a en tout cas rééquilibré les débats. On a aussi même diversifié le partenariat. Aujourd'hui, nous sommes en train de discuter avec les États-Unis d'Amérique. D'ailleurs, depuis l'année passée, le 4 décembre, on a signé des accords avec les États-Unis d'Amérique sur ces minerais stratégiques. Et il y a aussi les Chinois aussi qui sont chez nous. On est en train de revoir comment rééquilibrer le partenariat avec la Chine, parce qu'on a eu à connaître avant de mauvaises expériences à travers des investisseurs, des partenariats chinois. Ils exploitent nos minerais contre les infrastructures. Malheureusement, ça a été avant qu'on révise le code minier, c'était mal négocié. Et donc, je vais citer par beaucoup plus encourager euh, la recommandation d'ailleurs de docteur Victorine qui a parlé d'une action collective, parce que moi, je me dis que si au niveau africain, on n'arrive pas à réfléchir sur la manière d'agir collectivement contre les impérialismes, c'est vrai, ils vont finir nos minerais et après, nous allons continuer de mourir avec la faim. Donc, c'est important. Et donc, un autre élément, c'est que on essaie un peu les réformes qui sont initiées aussi visent à renforcer la gouvernance, la transparence et la responsabilité parce que c'est des choses très, très, très nécessaires. Et donc, la RDC est aujourd'hui engagée dans ces efforts visant à renforcer la transparence des contrats qui sont signés avec le partenaire internationaux, la lutte contre la corruption et le flux financier illicite, mais aussi on essaie un peu de renforcer des mécanismes de contrôle et on essaie un peu d'aligner aussi le travail extractif avec les normes internationales, donc, avec la Charte africaine des droits de l'homme, avec le mécanisme de l'OCDE, tout ce qui va avec la diligence raisonnable. On essaie un peu d'initier des réformes qui peuvent aider non seulement à contrôler tout ce que nous avons, mais aussi à en tirer profit. Donc, en quelques minutes, c'est ce que je peux dire.
C'est très bien, vraiment, parce que vous rappelez l'essentiel de justement ce qu'il ne faut plus faire à partir de cet exemple congolais, hein, que vous donnez comme étant un exemple de la malédiction et que vous revenez sur les vrais défis, effectivement, surtout de gouvernance, de transparence, et qu'il y a des réformes en cours. Mais en Afrique, on parle tout le temps et presque partout de réformes. Nous avons déjà des textes qui sont là, voyez-vous, ce qui nous réunit aujourd'hui ici. Mais l'importance d'insister sur l'action collective pour être beaucoup plus efficace, je pense que là, on est dans le cadre où effectivement une telle initiative peut être renforcée au niveau africain. Bon, peut-être qu'on a en pratique des expériences qu'on peut partager pour concrètement dire comment véritablement transformer tout ce cadre législatif que nous avons en réalité pour défendre nos ressources au profit de nos populations et en défendant également l'environnement. Certainement, on en saura plus avec les prochains intervenants. Là, je vais vers Bob Félix Ochiti, qui est de la Commission africaine de l'énergie, qui doit pouvoir nous entretenir justement sur la même question.
Thank you, moderator. Yeah. Oh, yeah, sure. Yeah, so thank you very much once again. I lead the oil and gas program at the African Energy Commission. but I've done a lot of work for the mineral sector in conjunction with the African Mineral Development Center. And so today we are speaking about critical minerals, shifting geopolitical landscape. We're talking about sovereignty. We're talking about human rights, dignity, and of course, sustainable development. So I'm going to focus more on critical minerals, a little bit of geopolitics, and more on the sustainable development, because I think we have identified some of the problems which I'll just have a small snapshot on. So to begin with, let's just go to the good old question. This is just my outline. Let's go to the next slide. As an introduction, we have the good old question that we always ask ourselves. And I think this morning, there was one side, I think, that was speaking about the resource we have, the critical minerals is a curse. And then there's another one that said, it's not a curse. And I think that speaks to this. So I was reading this paper, which talks about the race for critical minerals in Africa, a blessing or another resource curse? And I think these are the big questions that we need to ask ourselves today, because the race for critical minerals cannot be overstated. We know in terms of the reserves that we have on the continent, at least right now it's estimated at least 30% of global reserves for critical minerals are on the continent. We are seeing the demand for lithium increasing tremendously, tripling since 2010. We're looking at cobalt, at least 70% increase since then, and 40% for nickel. So there is no doubt that this demand for critical minerals is going to even increase by the mid-centuries. So the question we are asking, is it a curse or it is a blessing? And that we shall be able to see. Let's go to the next slide. So talking about the geopolitics, just a little over, just less than 2 weeks ago, actually, the US just signed this pact with the European Union on the action plan for critical mineral supply chain resilience. And what are they looking for? They're looking for a measured-based reference price. They're looking for a standard-based market, and they're looking for technical regulatory corporations. And where are these critical minerals coming from? What you see here basically is the US aligning with the EU in order for them to be able to manage what the supply chain looks like. And this is mainly to counter, as you go to the next slide, please go to the next. This article by Raphael, you can find it again online, the new scramble, critical minerals and competition in sub-Saharan Africa. What it was looking at there is that the China now controls over 70% of the minerals concessions on the continent. So you will see that what that actually tells you is that we perhaps, and this one now I'm trying to interpret what is happening, what the US and the EU are doing is to try and counter the influence of China on the continent. Let's go to the next. But perhaps what I want you to remember the most, this is a bit of an old report, but it explains the point I'm trying to make here more critically. The neo-colonialism. And this was a report by War on Want. They published this sometime in 2016, but it speaks more about the cost of inaction for the continent if we do not do anything about what we are speaking on today. And I want you to go back and look at this report again and say it actually talks about this was only about the British scramble for Africa's energy and mineral resources. And it estimates the concessions of the British alone on the continent to about $1 trillion US. It was looking about at 101 organizations and companies that have concessions on the continent. But if you look at that report, then you'll understand why the conversation we are having today is very important. But I want us to talk about rethinking the mineral resource management in the next place. Now, I like my brother from the DRC, and I want to show you this slide. Now, this slide, again, is all, but it illustrates. I'm not saying this is the kind of value chain we're looking at today. I think DRC has tried to improve this today, but it illustrates the idea that we are trying to bring out today. At least today, DRC controls over 70% now, or at least of the global supply of cobalt alone. Of course, he talked about very many other minerals that we know historically found in DRC. But what I want you to remember here is the contrast between the traditional resource governance question and the sustainable resource governance question. Because traditionally, what we used to think about is how do we extract resources efficiently and profitably? And what companies we're looking for is basically that. But we need to ask ourselves beyond, because if we are talking about sovereignty, if we are talking about human rights, and if we are talking about sustainable development, then we have to think about how do we manage these resources in order to create long-term value for our people, our ecosystem, but also to see how we can utilize them for the future. So I'm showing you this to show you how we are trying to transform and move away from the traditional way of doing business. Now, last year, go to the next please. Last year in the G20, this is the model that we came up with. Traditional model: extract, export, refine, and import finished goods. And that's what we looked at the previous cobalt value chain, where most of the resources were extracted from Congo, taken mainly to Asia, to China, processed there. Valuable components went to Europe, to the US, and finished products, like he mentioned about our phones, come back here as iPhone 15, 16, and 17. And we are all happy about that. Now, this is the model that was adopted in G20 as much within the Africa mining vision. The value chain talks about extraction, local beneficiation, where we have to promote the local value chains and industry, and then global chain integration. Global chain integration means that if China needs a certain component to produce a certain, EV vehicle, then we should be able to actually produce that component and transport it to China as a value-added product. Boeing as a plane does not produce all the components. You will find that Rolls-Royce perhaps is producing the engine and so on and so forth, and then they actually bring out the finished product. So that's what we're talking about, value chain integration. And of course, high-value products and services diversified within the company. This was the G20 AMV proposed model. Let's go. I'm about to finish. Now, as we are rethinking, the AU has done a lot of work, and working with the Minerals Department and the African Minerals Development Center, all these are tools that were developed for the implementation of the Africa Mining Vision. What does the vision say? It talks about three key things. Transparent, we discussed it in the morning. Equitable, which means that when we are talking about contracts and there's a company coming, we need to see a win-win situation in discussions and our negotiations of contract. And also optimal. Optimal means we are also thinking about the environment, we are thinking about local beneficiation, we are thinking about not utilizing everything about the race to the bottom that we have been discussing since morning. For us to be able to actually have a sustainable growth and socio-economic transformation. That's what the vision is talking about. All these 5 tools and many others basically gets toward 3 fundamental things. Sustainability, one key word: environmental sustainability, social sustainability, and economic sustainability. So if you look at everything about the AMV implementation tools, is ensuring that we can be able to achieve that. Go to the next. How are we maximizing this value from critical minerals? These are now my proposition as a way forward, as a take-home, in order for us to actually see that geopolitics does not jeopardize our strategic interest as a continent. Go to the next. This is my forward-looking action plan for Africa. Based on everything that I have said, the first thing we must be able to do is to leverage our resource endowment for strategic positioning. What does that mean? It means that when we are at a national level and we are developing critical minerals strategy, we must be able to align them with the aspirations of the Africa mining vision. And that is where we can be able to talk about a unified continental voice. I do not know how much we will emphasize this, because if we are divided, we will fall. And that is exactly what the colonialists did for us. They divided us and then they conquered us. Unless we can speak with one voice, it is indeed, and it will be, a race to the bottom. The second thing we must be able to do is we must be able to shift away from the extraction of raw materials to value addition. What does that mean at a national level? We must incentivize downstream value chain. How can we do that? We should be able to at least bring in place things like preferential tax treatment for value chain modernization within the country. We also have to promote industrial zones and maximize the benefit that comes with the Continental Free Trade Area Protocol, which we have all adopted as a continent. This is the second thing we must do. The third thing we must do is we should be able to strengthen our negotiation power in a competitive geopolitical landscape. The reason you see the US having alliance with the EU on critical mineral value chain is because they understand the power of being together and having a common value. When they're talking about a standard-based contracting, they're talking about offering subsidies for certain value chain. It is because they understand the power of geopolitical alliance. So we must be able to standardize contracts. I think Dr. Victoria talked about that. Frameworks to improve transparency and also to leverage on our bargaining power. We cannot overemphasize that. That's very important. The fourth thing we should be able to do is invest in enabling infrastructure and energy system. I come from the energy background. Mining is energy intensive, extremely energy intensive. And that's why on the continent as AU, we are promoting things like African single electricity market so that we can be able to at least bring electricity and energy closer to the people who need it the most. So we must expand reliable, low-cost power, invest in transport corridors, not only the one that exports, but also locally. Think about something as I'm about to call, this is the last slide. When the colonialists came here, think about the railways they built, the roads they constructed. Everything was heading towards the coast. It was not by mistake. That was not by mistake. It was intentional. Why can't we be intentional? So we should be able to do that by also building transport corridors and digital infrastructure, because now we live in an era where a lot of things are digitalized, including the AI, artificial intelligence. The last thing we should be able to do is ensure sustainability in governance and community inclusion. That's where we are all talking about the ESGs, the standards. We live in a globalized world. Last week we were in Geneva for the annual gathering on the expert group on resource management. What we are discussing there right now is how can we incorporate sustainability in every value chain of mineral resource development. And that we cannot run away from. We are living now in a global village, so we must be able to promote those ESG standards, align them to AMV, align them to Agenda 2063 and the Sustainable Development Goals, and ensure that revenue is shared equitably still within the framework of the mining vision. These are the 5 recommendations and action plan I want to leave you with as far as this discussion is concerned. Thank you. Thank you.
Merci beaucoup pour cette contribution très incisive, hein, basée sur une vision qui est assez pertinente, et surtout avant d'avoir mis les noms sur les prédateurs qui sont autour du banquet des minéraux africains. Cette alliance du Global Nord, États-Unis, Europe, en compétition avec la Chine. Et donc des modes opératoires qui sont différents, c'est vrai, mais qui tous finalement agissent contre les intérêts de nos États, mais surtout continuent de créer des problèmes à nos populations, même si, vous l'avez dit, le cadre est là. Vous avez rappelé la vision minière africaine et fait remarquer l'exemple, le bon exemple congolais sur lequel il faudra insister pour la création de valeurs au niveau local. Et donc, merci vraiment pour ça et nous espérons que la conférence des chefs d'État vont vous entendre et vont donner des ordres dans le sens de progresser dans cette perspective. Alors, nous allons finir avec la dernière intervenante, Dr. Laura Hani, de l'Institut nigérian d'études juridiques avancées.
Okay. Yeah, good afternoon. Yeah, good afternoon. Okay, I'm a senior research fellow of the Nigerian Institute of Advanced Legal Studies, and my research focus is mainly in energy and natural resource governance. Pardon me, I have a cold, so my voice is kind of tweaking off. Now, when I read the concept note for this forum, there's a statement that struck me. It says, development and natural resource government are inseparable from equity, equality, human dignity, and environmental stewardship. Now, why did it strike me? Because I feel that statement to me is ideal, or I'm tempted to say idealist, because that's not our reality. Because with the energy transition, what we're seeing now is that sovereignty and territorial integrity have become very fluid. Human rights are taking a backseat, and host communities continue to suffer the brunt of unsustainable extractivism under a green guise. And also, because minerals are mining is so foreign investment driven, we as states are not even helping ourselves, because we are so focused on bringing in investors that we're not negotiating sustainable contracts. Now, like Madam Esther said, I feel it goes beyond having the best negotiators. If you do not transform your domestic foundations, like for instance, infrastructure, mining, finance, etc., the balance of power will always tilt in their favor. You can never negotiate with strength, so to speak, because you don't have those foundations. So no matter how good you are to negotiate, that can get. But to just look at this topic, it's a very broad topic, so that I'll look at it from two spectrums. The first spectrum is the geological strategic juncture, and the second one is the ecological juncture, because there are two frames. There's human rights and criticality. But for me, mining is no longer a peripheral industry. It's now become a matter of high geological strategy. You can see the recalibrations worldwide. The EU critical mineral framework. The one that struck me the most was the United States National Security Strategy. I don't know if you've seen that document. I read the whole document and I was waiting to see what they would say about Africa. The last paragraph, what did it say? Just about extracting minerals and a playground for competing with China. That's how we're seeing. Also, there are also other recalibration, like the G20 critical minerals framework, the African mining vision. There are a lot of recalibrations, but regardless, like you said, Horandeso, there's an asymmetry, because the resources are based in the South. And who has the capacity? The North, in terms of technical capacity, manufacturing capacity, and even consumption capacity. It's over there. So that balance is already skewed in favor of them. That I won't stress too much on criticality, because that's been spoken about. Looking at it from the ecological juncture, I will look at it from criticality assessments. What is criticality? It's been discussed. Criticality does not take into consideration the development aspirations of us, for instance, because criticality has two junctures. The first juncture is what? Supply risks and economic importance. Supply risks focuses mainly on what? Geological concentration, product stability, and import dependence, while economic looks at maybe minerals importance to certain sectors like defense and what's the other one? Energy transition technologies. So it's heavily skewed in that favor. So you can see it has nothing to do with our development. And also, if you also look further, it doesn't even take into consideration the issue of communities at all. Social license to operate and even environmental stewardship. As these assessments do not take into it's skewed for the North, totally skewed for the North, but it doesn't favor us. So I would say the problem is with criticality. And I also don't like using the word critical minerals. I prefer to use green minerals, because I don't see what's critical minerals. It's not critical. Honorable Deso actually stressed that. That's why I'm stressing on it. It's not critical to us. I like to call it, like the AMDC call it green minerals, and I like to stick to that word. So that's one. Yeah, and another thing I like to add is that when you look at criticality assessment, because it's so focused on national security imperative of foreign countries, you find out that these countries, so to speak, would do anything, come up with several policies, intervention policies, to make sure that they can access its critical minerals. That's why, like he spoke about, investment treaties, I will look at things like ISDS, investor-state dispute settlement. That's a very, very big plug in the hole. I'm also saying that even I think that international economic law, to me, favors capital importing states and foreign investors over equitable distribution and ecological sustainability. It does not take into consideration. A very good example is Indonesia, nickel industry. They came up with a policy called downstreaming to ban exports of their nickel. Because what happened is that Indonesia was exporting their nickel industry at very low prices and then importing back steel at very high prices. So what are you doing? You're exporting wealth, importing poverty. So they went up with this very, very, very strong policy to ban it. And that matter came before the WTO. The EU took them to WTO, and they said that Indonesia was going against the General Agreements on Trade and Tariffs, which bans states from prohibiting exports. And you just wonder, and that what the EU said was that they feel that that restriction deprives them of accessing critical raw materials. So who does it favor? International economic law. That's one way to look at that criticality assessment and all that. So that's one aspect of it. And then trying to just pack everything up into 5 minutes. I also would say, I want to go back to the issue of free, prior, and informed consent. Can we not move that from principle to practice? Because communities are the ones who bear the brunt of these extractions, but yet they are not well represented when it comes to these contracts. Can communities not have veto power as opposed to just being rubber stamp consultations? Can they not say, no, we don't want this development to start? Can we give them that power? They don't have that power. Women and youth, whoever it is, So I think for me, I would say that for this, when it comes to host communities, human rights, I think we need to look at it from a multi-stakeholder governance level, as opposed to just looking at it from a monocentric system. Because there's a theory I read by Eleanor Ostrom. She came up with this framework called Institutional Analysis Development Framework. That framework was brilliant. It gave a very broad mapping on how to manage common pool resources. And she said that countries who have natural resources are actually very complex societies, and they are not best governed by just the state alone. I come from Nigeria, and everything is done at the center, and subnationals are not involved. So her theory was that not just monocentric system, but it's a polycentric, multi-level governance. The state subnationals, private NGOs, CSOs, and even the communities should be involved in the governance of critical minerals. So that's just broadly speaking. I'll just round up by giving what weaknesses that Africa has, in my opinion. I would say first, inadequate geological mapping and data. Most times you hear countries saying we have ABC minerals, but they don't have they don't need actual results. We don't even know what we have. Sometimes I'll use my country as an example, right? We can just say, oh, we have this amount of lithium, but we don't know exactly the amount of lithium. And that's one thing, we need to know what we have. Then also, I would say low domestic mining capital. We're so focused on foreign capital. 100% ownership provisions. I'll give you a good example with Chile. Chile, thank you. Chile came up with this lithium exceptionalism. They've taken control of lithium projects. And why is that? Why is that very good? Because now they can manage complex things like indigenous rights and environmental integrity. So it's no longer just the foreigners, they have control of lithium projects. So that gives them sovereign control too as well. Because if I just go back on what I said about criticality, you understand that these interventionist policies that through international economic law actually undermine sovereignty. They do energy sovereignty, because if you could take Indonesia to court, you're undermined as to actually be able to determine what trade policy, industrial policies I want, but you're taking me to court. That means you're tampering with my sovereignty. That's another thing, criticality, sovereignty. Then I'll say another weakness is limited downstream and midstream processing capability. That's why we can never bargain with strength, because we don't have the capital, we don't have the processing facilities, so we depend on them, and that's it. And then I will also give some action points too, just to round up quickly. We need to review and amend our mining laws and regulations to align with AMV principles. That's African Mining Vision principles on local content, beneficiation, domestic resource mobilization. All these things can give you some kind of balance of power when you're negotiating. Then you don't have to be relying on, foreign capital. I also say we should harmonize our mining laws with trade, industrial, and energy policies. We should harmonize them as well. And I would say also strengthen ESG and ethical sourcing standards to attract credible investors. And I think lastly, let me just run up. Lastly, I would say I agree that for countries to, should I say, go into processing is very expensive. There's skill and cost, right? And not every state can do that. So there is need for us to utilize the AFCFTA because it gives a continental-wide strategy for mining value chains. But that cannot happen because, not that it can't happen, it'll happen until countries domesticate the AMV. There's a slow implementation of the AMV, continental-wide. Even in Nigeria, there's a slow progress with that. We're getting there, but so I'll give example. If I don't understand why some countries will amend their mining laws without having a policy that aligns with the AMV. It's just, to me, it's like putting the cart before the horse, And then I would say, lastly, countries should move up the value chain. It's very critical. So you can attract economic and employment benefits using the AMV and the African Green Mineral Strategy as a framework, an implementation framework. And because the AGMS, I've read a bit about it, it's quite a very voluminous, but it gives states, I would say, should I say, a framework to go into investments that create some kind of, what's the word I use? A framework to go into investments that attracts the processing facilities, so to speak. So it gives you that framework. And states can do this with cooperation with the AMDS as some kind of technical support. So I think the priority for me for state is to have a national green minerals implementation plan. So I'll just stop there for now. Thank you.
Thank you so much. Vraiment, grand merci pour cette approche très critique, surtout sur les modèles extravertis, qui demandent à ce que nous ayons quand même des plans internes développés par nous-mêmes. Donc, incitation, attractivité, c'est bien, mais il faut tenir compte des intérêts locaux, défendre les droits et avoir nos propres plans. Et effectivement, ne pas toujours suivre les concepts tels qu'ils nous sont balancés. Et donc, essayer quand même d'être souverain aussi sur le plan intellectuel et le développement de ces modèles-là. Merci pour tous les exemples que vous avez donnés, Indonésie, Nigeria et Chili, et l'importance aussi d'avoir des données, une maîtrise des données. Ça fait partie des formes d'asymétrie qui existent dans le domaine et demande des capacités pour ça. Merci beaucoup pour tout ce que vous avez partagé avec nous, qui, je suis sûr, inspire beaucoup d'acteurs ici. Maintenant, je ne sais pas, on a dépassé le temps, mais est-ce que vous permettez qu'on puisse faire au moins 2 questions? 5 minutes, so je prends 2 questions. Moussa, et puis voilà, et vous devant moi. Allez-y d'abord Moussa et ensuite vous. Ah, j'ai 2, hein?
Merci et je suis vraiment très heureux de toutes les possibilités en fait qu'aujourd'hui en fait nos même 4 panélistes ont donné en termes de vision. C'est-à-dire comment est-ce que aujourd'hui on met des actes qui nous permettent d'avancer. Et j'ai bien aimé en fait les 5 points sur lesquels en fait Félix est venu et qui aujourd'hui pour moi ça doit être quelque chose qui doit être bien ressorti dans les rapports qu'on va faire. C'est dans les perspectives qu'on se donne comment nous, Africains, nous réinventons notre futur, en fait. Je pense qu'il y a cette dimension sur laquelle nous devons commencer à travailler, autant dans le sens d'avoir les ressources humaines disponibles pour négocier, mais aussi les ressources humaines formées pour nous faire avancer dans cette perspective-là. Si nous ne sommes pas dans cette dynamique aussi de mobiliser le plus possible nos ressources domestiques Et je pense que c'est cet aspect-là, nos pays africains n'ont pas véritablement travaillé sur ces circonstances-là. Je donne l'exemple du Sénégal. Pendant longtemps, on a parlé d'aller chercher des eurobonds, alors que tout l'argent qu'on avait, c'était le plus de l'argent du pays qui était là que l'argent des eurobonds. Donc, nous, États aussi, devons savoir comment mieux mobiliser nos ressources domestiques pour nous permettre d'arriver à des schémas qui nous permettent de véritablement peser de notre poids sur les politiques qui vont advenir en matière minérale. Merci.
Merci beaucoup, Moussa Mbege. Yes.
Thank you very much. My name is Songora Udombana. I'm a law professor. I have two questions, and the second one is just a way of a recommendation. And my question goes to Mr. Okiti. I hope I'm pronouncing your name right. Given your area of expertise, I would like to know how many African companies are actually involved in extracting activities, not just in terms of cheap labor. Because almost 60 years after independence, we are still having Western countries, American companies, British, European companies, now Chinese companies are all over Africa, extracting minerals and all kinds of things. So how come that 60 years after we seem to lack the capacity to do this for ourselves? We can sit down here and speak from beginning, from now to the end. The foreign models, and the fact is that the business are here to extract for profit. But if we cannot develop the capacity there, then to make it to the Pan-African Parliament. The Commission, this is not working well. Is it possible for the African Commission to work together with the Pan-African Parliament to develop possibly a model law on a model contract on extractive agreements, covering leases and licenses and all of that, which state might be encouraged to adopt? It might be easier that way than to impose any treaty from the continental level, apart from the fact that the African Union is a reflection of the member states. And many states they adopt this instrument, they do not ratify them. There are several protocols dotting the African continent which have not entered into force because political will to ratify them is not there. So we might try to be looking at elaborating a sort of a model contract law or a regime that probably each of the states, particularly those involved in these extractive industries, might be able to adapt it into their local environment when dealing with the multinational corporations. I think that's just by way of a suggestion.
Thank you so much. So, want to respond first, Ochidi?
Thank you. Thank you for your comment, Senegal, and thank you, Professor. First of all, on the model law, actually, the African Union was already developing something on the model law with the Department of Industry, Minerals, and Trade. But that process is still, it has not been concluded, but your proposal is very good. And I think if we can be able to develop something, a model law, like you're saying, with all these aspirations as part of, some contract negotiation, it will help. Because I know at national level, countries are trying to do that. I come from Uganda, and when we were actually developing our oil and gas laws and protocols, we learned a lot of it from Nigeria. We adopted some of the elements on the model laws from Nigeria. But think about if we had something we had adopted continentally. I also know that the African Legal Support Facility is trying to, they have a department that they support member states on contract laws and things like that. And I think maybe that is, I know they're also part of the process of developing this model law. So it's something that we can take away and see how best we can be able to take that forward. But I agree with you 100%. On the question on how many countries, how many companies, indigenous African companies are actually in the extractive centers industry, I would like to say I can't put an exact number, but I can tell you about the trends. what we see in terms of trends is that a number of them are still in the artisanal and small-scale mining component. The big players, of course, the ones that have the capital are still coming from out, but there are joint venture opportunities that we now keep seeing. And again, let me mention Nigeria in terms of this, because I think Nigeria, it's probably a place, Nigeria is very unique on the continent. We learn a lot of things, the extremes of everything, including the best. Because I'll tell you, if there is any industry, for example, the oil and gas sector, that I've seen Nigeria doing tremendously well in terms of local content, promotion, and even indigenous companies. Today, a lot of pipeline works, a lot of small-scale machineries within the oil and gas is produced locally. And the local companies are actually taking concessions, especially, I know there was a deliberate move by the government as a policy in order to promote local content and allow the local indigenous companies to take concessions. Those are some things we can be able to adapt and replicate in other countries. But it's work in progress. And where we always get bogged down the most is where the capital, how we can be able to access the capital for bigger projects. But your sentiment, I agree, 60 years down the road, we should be doing much better. But we have foundations that we can build on from where we are right now. Thank you.
Okay, thank you so much. You want to add something or to respond to? Okay, that's all. Vous voulez ajouter quelque chose? C'est bon? C'est bon? Est-ce que, Dr. Victoria, do you want to add something?
No, that's it. Everything has been covered. Thank you.
Thank you so much. Et puis, merci à tout le monde aussi. Et bravo pour ce panel.
Thank you very much. A round of applause again for the panelists. Mr. Eliman Khan, Dr. Victoria Nalule, Mr. Moise Balajizi Musada, Mr. Bob Felix Ositi, my brother from Africa, Dr. Laura Ani, thank you all so much. Thank you. Thank you all so much. Thank you. Excellencies, distinguished participants, I have a request to introduce an icebreaker. This is something that ordinarily in my culture, I'm not able to do as a young one. But because you have given me this responsibility of moderating, I believe I also have delegated powers with your kind indulgence to ask my elders to rise up for a few minutes. Can we please rise up? Because we have 2 more presentations. We already deferred one. We can't afford to defer another one. Tomorrow is also a busy day. Please, I'd like to ask each and every one to please identify someone you've never met before or someone you haven't spoken to today. Walk towards them. You have 2 minutes and talk about nothing related to work. Nothing related to work. Nothing related to extractive industries. You are not moving. Commissioner there, so you know everybody. That's an undue advantage. We have to move. Please meet your brothers and your sisters. And let's talk about everything else but work. Let's bingo, because the essence of this meeting also is to network, please. Yes. We have 1 more minute to mingle. If you still want to be formal, you can ask a light professional question, but nothing too serious. But we have to move. We are not moving. Mr. Deya is coming first. He came all the way here to that place. You are getting the first prize. You really moved. Okay, thank you very much. Thank you. A round of applause for ourselves. Thank you so much. Thank you. Now people are enjoying this too much. Okay, merci beaucoup. Shukran Jazeera. Thank you so much. Obrigada. Let's take our seats. Asante sana. Now we will move to panel number 5. I think we are now ready for panel number 5. And this will be moderated by His Excellency Ambassador Willie Yamitwe, Chair of PRC and Chair of the PRC Subcommittee on Human Rights, Democracy and Governance. Your Excellency, you may mount the podium. And the panelists are representatives from member states. We have Her Excellency Letsi Osula Matheko, Minister Plenipotentiary and Deputy Head of Mission, South African Embassy to Addis Ababa, to the African Union. We have the representative of the Republic of Mozambique, Mr. Josias Masi, Human Rights Technical Officer, Ministry of Justice in Mozambique. We have the representative of Angola, Mr. Daniel Masukini, Senior Technical Officer, Ministry of Justice. And we have the representative of the Republic of Zambia, Mr. Simoyamama Nifegi Chunga. I call him Mr. Chunga. And is the first Secretary Legal at the Embassy of the Republic of Zambia to the African Union, and he's a very good supporter of the African Commission. You're all welcome, Your Excellencies. I hand over the floor to you, Excellency, Ambassador Willie.
Merci. Thank you so much. So we have 1 hour, right? 45 minutes. Reduce it. It was 1 hour on the program. Okay, 45 minutes. Thank you so much. Nous avons écouté les techniciens. We have listened to the technicians, experts. Now the conversation will be more political, I think. Of course. Là, aujourd'hui, let me put it in English. It's even very difficult to have this panel. The last one was so dynamic and very rich. So I hope the panelists will keep the momentum. OK. Alors, maintenant, aujourd'hui, nous parlons du renforcement des cadres de gouvernance dans le secteur extractif, le partage des meilleures pratiques législatives, réglementaires et institutionnelles. Alors, c'est comme j'ai dit, bon, voilà, les ressources naturelles de l'Afrique constituent à la fois une opportunité exceptionnelle de transformation économique et un défi majeur en matière de gouvernance. Et trop souvent, l'exploitation de nos ressources a été aussi à l'origine des tensions sociales, sécuritaires, etc. Et je ne ferai pas une longue introduction pour essayer d'écouter les États membres, mais en résumé, cette session 5 porte sur le renforcement des cadres de gouvernance dans le secteur extractif à travers le partage des meilleures pratiques au niveau législatif, ça veut dire les lois, réglementaire, ça veut dire les règles d'application, et institutionnel, disons les structures et mécanismes de gestion. Et parmi les panélistes, il y a Gender Balance, nous avons une dame. J'ai vu que partout, le Gender Balance n'a pas été très respecté. Une a toujours représenté tout le reste. Et à tout seigneur, tout honneur, je vais commencer par l'Afrique du Sud, Miss Letsi Mateko. Et je ne poserai pas de questions directement. Parce qu'on a besoin d'entendre, d'écouter l'expérience. Quelles réformes concrètes les pays sont en train de mettre en place pour renforcer la gouvernance dans le secteur extractif et surtout quels résultats ils obtiennent dans ces pays respectifs. Et j'espère que dans les 45 minutes, les 40 qui restent, ça pourra être interactif. D'autres pays qui se trouvent ici aussi peuvent partager leur expérience. Je donne la parole à l'Afrique du Sud, à la représentante de l'Afrique du Sud, Mateko.
Good afternoon, everyone. I do really stand on all existing protocols at this point. It is the graveyard shift. I've had a lot of plantain and rice, and my stomach is really full. So I will not keep myself here any longer than I have to. As Ambassador Willie has introduced, I am Mateko Litsiye from the Embassy of South Africa based in Ethiopia. On the question, you know, the session that we just finished now is probably the session that I wished I was sitting on the panel for. But it's a pity we don't get to choose. Yeah? We get to be told which panel we get to sit on. But maybe I just want to, because we're talking from member states, and I do know that perhaps people have an interest to know, what do heads of states actually talk about when they are together? Because we sit here and we have all the ideas of how to improve our continent. We understand all the laws, we are the experts, we know exactly what needs to be done to get us where we need to be. So the question is, are they having this conversation amongst themselves? I know that's not what you asked me, but I'm getting somewhere. In the margins of the AU summit in February, there was a conversation amongst heads of states, private conversation that I'm bringing you into confidence. And there was a meeting of the G7, not the one that South Africa was invited and disinvited from. Another G7 that had taken place prior to that. And it was before, it had happened just after, obviously, you know, before the summit. And so in the summit, we were reflecting on this, and this is what the heads of states were reflecting on. And it was said that in the G7 meeting of whenever, the conversation on the table was, how are we going to get Africa's critical minerals? How? And there was a response by one member state, a very powerful nation, that said, well, if Africa will not give it to us, we will take it. That comment sent such chills down my spine, hearing it being spoken by heads of states. And one reporting to peers that that is, in fact, what the conversation was at G7. Africa, wake up. You do not have the capacity to fight off certain wars. We don't have the luxury to not learn from each other. We do not have the luxury to not collaborate. We do not have the luxury to not put value add in the minerals that we actually have. We simply do not have that luxury. Someone made the comment earlier that it is so important to negotiate as a collective so that you're negotiating from a position of power, position of strength. We will never, if we are continuously jealous of each other, if we are continuously jealous of each other, happy to get someone outside the continent to collaborate with, but we can't collaborate amongst ourselves, then what's the point? The conversation in that table was, my brother, they are coming for you. And in them coming for you, what we ask is that when you do negotiate, at least demand the things that are imperative for your economy to grow. Demand it because you are in a position of power. Do not do what our ancestors did, our forefathers did, ancestors to me, and just negotiate from a position of not knowing. We know better. And so we should negotiate better. But negotiate and really go for the jugular. Go for the one thing that is critical for the growth of your people. Demand it. They want it, we demand it. But also pay attention to your region. Pay attention to your neighbors. Only when your neighbor grows will we all just prosper. So how about you look at, and the advice was, how about you look at small scale value add so that you incrementally build the capacity to add value to these critical minerals. Because someone was talking just now that we do not have the money, we do not have the investment to actually create these beneficiation of value add machinery, right? But start small. In what you are demanding, start small so that as neighbors, we start building the capacity, and over time we will learn, and then we'll be able to be fully fledged. And I don't know, maybe in 2063. I'm being told I have a minute, but but Ambassador really knows once I speak, I start preaching. So we really do have a trust deficit that I'm really hoping that somehow at some point we will really get over it so that the future of our people is not missed. Ambassador Willie, you asked me a question around South Africa and what it is and what are the lessons learned and what it is that we're doing from a legislative perspective. You know, for South Africa, everything is based on our constitution. Constitution really being the base document that guides how we actually conduct business, even in business in the country. And also from the human rights perspective, that is where you'll find the Bill of Rights. And all of this is to say that we acknowledge as a country that we are very, very dependent on this, on the minerals that we also that we also sell and the mines that we have, because they really, really do generate a lot of employment for our people, and therefore it's not something that can easily be ignored. But what have we done since then? So in 2024, 2025, we had the Mine Health and Safety Act 29 of 1996, which has been the most effective tool for driving accountability on safety measures in the country. So in this act, we were looking at getting mining executives or owners to show that they could, that the ones that took reasonable practice steps to ensure safety in the mining sector, because in the past, what we found is that they were avoiding liability by only demonstrating that they took reasonable practical measures to ensure safety of workers, but now they are obliged. Now we have set up penalties for all those violations, and we've really looked at the legislation that speaks to that. Another one that has been effective in our country has been the Mineral and Petroleum Resource Development Act of 2002, which really just looks at protecting the social and labor plans, and also we monitor the failures where benefits have been promised. And this is quite big when you look at what the private sector does when it actually gets into our communities. They hire people like you and I to really try to get people to give over their land in order for them to be able to obviously extract all of these minerals. But we have a program in South Africa called, it was passed through cabinet. It's called public participation programs, where we have izimbizo. And izimbizo is when you go through a chief, a local chief, a local kingsman, where you go negotiate with communities and you have conversations with communities. So what cabinet did in the decision that they took, they forced all cabinet ministers in their respective ministries to be able to go to communities to go have conversations around various laws that are in place that are beneficial to people. The only way our people can be gatekeepers is if they understand the law. And by understanding the law, we need to understand and take the education of our people very seriously so that they are able to be the vanguards, so that they are able to be the ambassadors. They are the ones who are able to then defend the land and in so doing also defend their own human rights. Thank you.
You're welcome. Thank you so much. Thank you for to have shared the experience of South Africa, particularly, the public participation program. So let's go with Zambia now. If you can share with us, what is the experience, concrete reforms that you have, your country, even the challenges. Thank you.
Thank you so much, Honorable Chair, Excellence. So for Zambia, I'll go straight to the point, just to make mention that I'm sure we all know that Zambia is one of the major producers of copper in Africa. I think it's third, second in Africa, and third, I think, in the world. So really, yeah, this is one of the cornerstone of our economy. And the mining industry actually contributes to about 70%, I believe, of our GDP in terms of GDP growth, employment, earnings, and investment opportunities. So for us, this is a very important sector, and I'm speaking as Zambia. And so talking about Zambia's geology, it comprises of critical minerals. I'll not call them critical minerals because I think someone said that's not the best way to call them. So I'll call them green minerals. So we have minerals such as cobalt, gold, manganese. We have lithium. What is the lithium and emeralds? Okay, so these are some of the minerals that are scattered across the country. And so what we are doing right now, we have our chief marketing officer, who is our president, who is actually going around trying to market Zambia and see how we can benefit as a country from the industry. And so by 2032, we are targeting production of about 3 million metric tons of copper. That's our target. But you might be wondering that why are you more or less like you're selling your country? We've put measures, and for us, I think I wish Honorable Commissioner was around, because he's been talking about ownership of these minerals by the people. And so for us, the starting point as Zambia is that these minerals are actually vested in the people. They're actually vested in the people, but so the president only has control, delegated authority over the minerals, but these minerals are vested constitutionally in the people. And I think that's a plus for us. That's a good starting point. And so in terms of governance and legislative framework, yeah, so the starting point is, so we approach this governance issue as, I would say, a direct obligation under the charter. So, Honorable Commissioner, our constitution actually is an alignment with Articles 21 and 24 of the charter. So we did an amendment in 2016 after, as you know, we're a state part to the charter. And so in response to that, we amended the constitution. And there's actually a particular part in the Constitution that deals with the issue of natural resources. So that should be very exciting for you. And so, this is under Article 255, which mandates public participation in environmental policy and guarantees access to environmental information. That's under our Constitution. Number 2, we have Article 256, which imposes a binding duty on every person to protect the environment, okay, and use the resources, natural resources, sustainably. That should be a plus for us. And so, what you see here is a creation of a dual-layered legal architecture of collective state obligation under the Charter, and also reinforced by individual civic duty under national constitutional law. That's what you see here, I believe. And so we identified some challenges, particularly in the areas of licensing. And so we undertook in 2024, we undertook a legal reform to try and see how we could reform to deal with the issues of leakages, public resources leakages, in response to Article 24, where these resources should actually benefit the Zambian people. So what are we doing? So we did the reform, and we came up with what we are calling the Minerals Regulation Commission, okay? This commission actually operationalized it to centralize licensing because we identified it as a problem. That is where the problem. We were seeing that the Zambian people were not benefiting. And so government intervened by repealing the previous the Minerals and Mines Development Acts. And so we came up with the Minerals Commission, Regulation Commission, which is now responsible for licensing and giving out permissions. Okay, so sorry. Okay, so what's the rationale from this is simple. We are separating policy direction from regulation execution, which closes these integrity gaps. And so we create this independent body that deals with licensing, and only the Ministry of Mines only plays a role of giving policy direction, and it ends there. So the resources, we've closed all those corruption gaps, and the resources are really benefiting the Zambian people. And so Chair has told me that I have only about 2 minutes. And so what other institutions we have in place? We have what is called the Ministry of Mines and Minerals Development. This one, like I said, only focuses on policy and strategic vision. It has nothing to do with licensing, issuance, and so forth and so on. Then we also have the Zambia Environmental Management Agency. This one independently leads the environmental impact assessment, permitting, and compliance. And so you realize that sometime in 2024, there was actually court litigation where in the lower Zambezi, where the local community sued the government in hoarding the licenses that was actually granted to an investor. And so what do? They went to the High Court, and the court actually granted them an order. So the operations were actually stopped. So these are some of the measures. Learning from experience, we reformed, we actually revised the agency to give its teeth, and they halted the operations of the mine. And I believe Honorable is very excited to hear about that. I'm concluding, Honorable Chair. So as I conclude, I would just like to talk about the challenges. Yeah, we identified some challenges. Yeah, and one of the challenges I think we identified was value addition. And in response to that, because we lack the capacity, the capacities in processing of these minerals, we have these minerals, but government came up with a policy intervention, which we have created what are called MFAs, multi-facility economic zones, where we'll build some industry of some sort. And when investors come, They are designed for a purpose of, for example, processing these minerals. And so we have scattered them around the country. That is still work in progress. The idea is actually to encourage investors who come to come up with some processing industries in those MFAs, or multi-facility economic zones. So when they invest, what is there is that we process these minerals. So the resources will remain within Zambia. So that's what government is doing. And so we have also done what we are calling a mapping exercise across the country, where we've mapped all the minerals, because what was there are people who just go there and start mining everywhere. But then we have done a mapping and we understand the geology of our country. We know where the minerals are. And just to summarize, sorry, Chair, because of these policies that have been put in place, right now, we are talking about free education policy that is being implemented by the government. And I would say that about 2.4 million children have actually gone back to school. And that's huge for us. So that's how we are benefiting from these reforms that we are doing. Chair, I would go on and on and on, because this is very important to.
No, it's
Thank you
worth
so much.
listening, my brother. And you know, it's difficult as a chair of the PRC. It's difficult to interrupt a member state. You know, sometimes we call ourselves member states, and the others are not member states, as if they were stateless or orphans. We are all member states, you know. So, my brother from Mozambique, please.
Sim. Muito obrigado, embaixador Nhamtiwe. Eu chamo-me Josias Américo Maci, sou técnico no Ministério da Justiça, Assuntos Constitucionais e Religiosos em Moçambique, e sou técnico da Comissão Interministerial para os Direitos Humanos e Direito Internacional Humanitário. É uma honra estar aqui neste fórum para, de forma coletiva, debatermos alguns aspectos que minam o setor da indústria extrativa a nível de África. E de manhã, no período de manhã, foram avançados alguns assuntos que, para Moçambique, não constituem uma exceção. O setor da indústria extrativa em Moçambique está na fase embrionária, mas nesta fase embrionária já experimentamos uma série de problemas que foram avançados no período de manhã, dentre os quais o problema da falta da responsabilidade social das empresas, o problema da destruição do meio ambiente, e nós, a nível de Moçambique, experimentamos também dificuldades de cumprimento de programas de compensação das comunidades que são retiradas das zonas de exploração desses recursos. Assistimos também à falta do envolvimento das comunidades no processo de estabelecimento das multinacionais. E, por fim, é quase que consensual no nosso país a falta de transparência sobre os contratos entre o governo e as multinacionais. Esta situação tem levantado muitos debates e um mau olhar sobre os negócios que envolvem o Estado e as multinacionais. E, em reconhecimento destes problemas levantados no setor extrativo, nós, como Ministério da Justiça, em representação do governo, como coordenadores da pasta dos direitos humanos, tomamos iniciativas que vale a pena destacar, e também essas iniciativas foram tomadas em cumprimento de recomendações feitas tanto por organismos regionais de África de direitos humanos, assim como organismos das Nações Unidas sobre direitos humanos. E, indo concretamente, queria destacar os principais avanços para colmatar os problemas decorrentes dessa problemática da relação comunidade e indústria extrativa. Nós criamos, elaboramos o Plano Nacional de Negócios e Direitos Humanos. Este plano vem ou procura responder à falta de cumprimento das suas responsabilidades por parte das empresas. Este é um plano que foi produzido de forma envolvente. Para a sua produção, tomou-se como base a auscultação às comunidades, principalmente da zona norte da província de Cabo Delgado, que é a zona onde ocorrem ou estão implantadas já a maior parte das multinacionais. Então, nós priorizamos uma política de descer até a base onde estão as comunidades, onde as empresas estão instaladas. Então, adotamos uma política de negócio de direitos humanos com uma vigência de 5 anos. Portanto, é um instrumento orientador do governo na área de negócio de direitos humanos para o presente quinquênio que iniciou em 2026. Com esta política, com este plano de negócios e direitos humanos, o primeiro objetivo é promover uma conduta empresarial responsável, integrando formalmente o setor empresarial neste processo e estabelecendo um diálogo construtivo entre todos os setores sociais. E o outro objetivo é promover a cultura de compromisso empresarial em matéria de direitos humanos, no âmbito dos negócios. Qual é a importância? Este plano nos permitirá promover a responsabilidade empresarial, nos permitirá fortalecer a governança e a transparência. Este plano nos permitirá garantir a proteção dos direitos das comunidades vulneráveis. Também nos permitirá a promoção da justiça e da reparação. E, por fim, julgamos que nos permitirá fortalecimento da imagem internacional de Moçambique no âmbito dos negócios e direitos humanos. Continuando, para minimizar os conflitos no âmbito da indústria extrativa, Moçambique aderiu à iniciativa de princípios voluntários para minimizar a questão da segurança, porque na zona onde ocorre ou estão implantadas as indústrias extrativas, temos assistido um conflito entre as comunidades e as forças que visam proteger os interesses das multinacionais. E, em reconhecimento desta problemática, Moçambique aderiu à iniciativa de princípios voluntários e, atualmente, está a decorrer, hoje que estou aqui, uma consulta nacional para ouvir as comunidades, para assegurar a sua participação nesta política, e é uma perspectiva de incluir todos e não deixar ninguém para trás. Então, estamos nesse processo de elaboração do Plano Nacional de Ação no âmbito dos princípios voluntários. Não menos importante, importa destacar que nós, no nosso país, no âmbito da escutação sobre negócios de direitos humanos, assistimos fenômenos não agradáveis que resultam desta implantação de grandes multinacionais, como é a questão do uso indevido da mão de obra infantil, o uso das crianças, o caso da prostituição infantil nas zonas onde estão implantadas as multinacionais. E, muito mais grave, assistimos à poluição dos rios, à destruição dos campos onde as comunidades praticavam agricultura e, em grande medida, a destruição ou a não construção de infraestruturas sociais nas zonas de acolhimento. Então, para nós, o setor da indústria extrativa está numa fase embrionária, mas já nos trouxe grandes problemas e estamos aqui desde amanhã a aprender, a colher experiências de outros países que já estão minimamente avançados e também assumimos o princípio que se avançou de manhã, que nós, como africanos, precisamos de agir de forma unida e se calhar elaborarmos, avançamos em propostas que integram a todos os países para dirigir o setor da indústria extrativa. E muito obrigado.
Merci beaucoup. Nous venons de manger. We have already eaten 30 minutes. Remaining is 15 minutes. We have been given 45. Don't forget that. So, je vais donner la parole à Monsieur Daniel Masukinini. Hein? Daniel Masukinini.
Obrigado, obrigado.
Obrigado.
Excelências, minhas senhoras, meus senhores, boa tarde. Relativamente ao nosso tema, melhores práticas legislativas de Angola no setor extrativo, garantindo a dignidade humana e a proteção ambiental. Angola tem como popular ético-constitucional o fundamento da dignidade humana. Todos os projetos extrativos em Angola devem ser primordialmente servir o bem-estar do cidadão, independentemente da sua nacionalidade. A Constituição da República de Angola impõe como tarefa fundamental o Estado de assegurar, proteger a fauna, a flora contra a exploração predatória, bem como o direito ao ambiente e à qualidade de vida. Relativamente à questão do Código Mineiro, a lei também trata da questão da proteção à mineração artesanal. Ela garante a subsistência e inclusão social para as comunidades locais tradicionais. Relativamente à abertura ao direito internacional, Angola destaca o artigo 26, que obriga os tribunais angolanos a aplicar a Carta Africana e a Declaração Universal dos Direitos Humanos, mesmo que as partes não invocam nos seus contratos. Ou seja, Angola é um Estado de direito aberto e moderno. Relativamente ao quadro regulamentar ambiental, é tutelado pelo Ministério do Ambiente. Angola possui ferramentas práticas que garantem que a economia não sobreponha à ecologia. Temos a Lei de Bases do Ambiente, que define o uso racional dos recursos naturais e a preservação do equilíbrio ecológico. Temos ainda também a avaliação do impacto, ou seja, nenhum projeto extrativo em Angola avança sem o licenciamento ambiental rigoroso e sem um procedimento de avaliação de impacto. Temos ainda o decreto presidencial, que destaca que o princípio do poluidor-pagador, ou seja, se houver um dano, há obrigação de reparar e indemnizar, seja o Estado, seja as pessoas coletivas, inclusive os particulares. Exemplo foi o que aconteceu recentemente na minha cidade de Benguela, em que um rio transbordou, ou seja, o rio transbordou a água devido à questão climática das chuvas, em que o presidente da República teve que financiar ou aprovar uma linha de financiamento para aquelas comunidades no valor de 30 mil milhões de kwanza, ou equivalente a 30 mil milhões de dólares, para apoiar aquelas famílias e empresas afetadas pelas cheias. Relativamente à questão do setor extrativo, petróleo, gás e minas, Angola já está a aplicar as boas práticas com as reformas legislativas. O decreto-lei presidencial aprovado em 2024, obriga que 10% das taxas de exploração sejam aplicadas a favor das comunidades locais. Em caso de abandono do poços, o decreto presidencial 91/98 garante que as petrolíferas assumam a responsabilidade final pelo encerramento das operações eliminando passivos ambientais, ou seja, antes de uma empresa privada exploradora sair ou pretender sair ou abandonar esse projeto, ela deve primeiro reparar todos aqueles passivos. Quanto aos parceiros da sociedade civil, Angola reconhece a importância dos parceiros da sociedade civil. Destacar aqui o Comitê Local de Direitos Humanos, as associações, de Angola, bem como aqui a questão das fundações, elas são muito importantes para a questão da transparência. Exemplo, temos aqui destacar aqui o Comitê Local de Direitos Humanos, que é um instituto que fiscaliza e observa todas aquelas matérias de violação de direitos humanos a favor das comunidades. Ela não envolve só o Estado, como também envolve todas aquelas figuras importantes da sociedade, autoridades tradicionais, igrejas, polícias, militares, sociedade civil. Quer dizer, é um conjunto de pessoas, podemos assim dizer. Relativamente à questão da responsabilidade civil e probatória, Angola adota o critério da probabilidade de verosimilhança, ou seja, quanto à questão da, 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 da justiça ambiental, Angola, ela usa uma certeza absoluta impossível, ou seja, se houver aqui uma ação apta a produzir um dano, um cenário normal de risco, ou seja, o poluidor aqui é responsabilizado. Exemplo que eu dei, por exemplo, daquele rio, da minha cidade, se tivesse uma empresa que tivesse a explorar aquele espaço, não era necessário o provar, mas sim a lei já obriga, se caso de houver aqui uma suspeita ou probabilidade, então a própria lei já impõe que aquela empresa se assuma a responsabilidade. Mas existe também uma recomendação sobre a questão da inversão do ônus da prova em crimes ambientais, em que coloca Angola na linha da frente do direito ambiental. Ou seja, essa recomendação é defendida por vários juristas, inclusive o Ministério da Justiça e Direitos Humanos e acadêmicos das diversas faculdades de Angola, influenciados pelos padrões da União Africana e pela Comissão Africana de Direitos Humanos e dos Povos. Relativamente aos recursos biológicos, Angola também não está paga. Ela tem uma proteção específica da biodiversidade aquática e da subsistência das populações que dependem da pesca contra o risco da exploração offshore. Relativamente à gestão dos recursos resíduos, existe um plano estratégico de gestão de resíduos sanitários estabelecido pelo Decreto Presidencial de 196/2012. Ela foca na proteção da saúde pública através de recolhas urbanas eficientes para eliminar focos de doença. Este plano promove a valoração de resíduos via reciclagem e economia circular, ao mesmo tempo que impõe uma gestão rigorosa de fluxos especiais, especialmente os resíduos tóxicos do setor extrativo. Por fim, este plano foca também na educação e sensibilização contínua dos cidadãos para garantir a sustentabilidade ambiental. Ou seja, o plano estratégico de gestão de resíduos sanitários ela foca em 4 princípios, que é, primeiro, a recolha urbana, a valorização, o fluxo especiais e educação. Bem, ainda também temos o regime jurídico dos aterros e o regulamento de transferência de resíduos para a reciclagem. Em caso, por exemplo, de um derrame, o Decreto Presidencial 11, ela obriga que essas empresas poluidoras ou danificadoras, em menos de 8 horas, para que, ou seja, exige uma resposta rápida aos reclamos de petróleo. E agora, vou avançar 2 minutos, só tenho, o direito penal em Angola, relativamente, ela tipifica os crimes de agressão ambiental, como os crimes de radioativo e poluição sonora, vamos dizer. Quanto ao desafio, Angola também tem desafio, como outros países. Primeiramente, Angola, nesse momento, está a fazer as suas reformas, de modo a expandir que os comitês locais de direitos humanos atinjam aquelas zonas remotas, para que possa proteger, ou seja, para que possa proteger os recursos e chegue a essas comunidades. Nesse momento, o Ministério de Justiça também está formando membros dos comitês locais para fiscalizar passivos ambientais e sociais das empresas extrativas. Concluindo, dizendo que o governo de Angola, em primeiro lugar, ela é digna pela dignidade da pessoa humana. Em segundo lugar, Angola, em Angola, a aplicação da legislação é rigorosamente acompanhada pela Associação Nacional da Associação Nacional de Petróleo e Gás e pela Associação Nacional de Resíduos Ilegais. Uma das boas práticas também que podemos aqui citar é a questão do desenvolvimento do presidente da República. É uma das conclusões que a gente chega também. Recomendação, deixamos aqui neste fórum, é criação de comitês, de modo que possam monitorar as atividades locais e reforçar o Código Penal relativamente aos crimes ambientais e industriais, harmonizar as leis entre os vizinhos em corredores logísticos, por exemplo, cooperação em 2004, que Angola fez com a Zâmbia, também uma boa prática de experiência, e, por fim, digitalizar todo o cadastramento e licenciamento no sistema de gestão de informação e reporte de direitos humanos de Angola. Obrigado.
Merci beaucoup. Voilà, donc nous avons fait le tour. Le temps qu'on nous avait donné, on devait terminer à 17h15. Il est 17h13. We still have 2 minutes, but since the moderator is not around, then we can take 10 minutes. Yeah, je vais directement donner la parole sans faire un résumé. Je vais commencer ici. Et puis, voilà, là-bas, nous avons 2 interventions. Allez-y directement et derrière, on en profite. La modératrice n'est pas là.
Merci beaucoup, Excellence, Monsieur l'Ambassadeur. Je voudrais un peu poser une question de curiosité aux 4 intervenants.
En vous introduisant pour qu'ils sachent.
Je suis Monsieur Sakata Gari. Je suis député du Parlement panafricain et président de la commission de l'agriculture et de ressources naturelles. Alors, je suis de la République démocratique du Congo. Alors, je disais que je voulais poser d'abord la question, non pas en tant que vraiment député, mais parce que d'ailleurs, je suis professeur d'université dans le cours de droit minier et des hydrocarbures, mais également avocat dans le même secteur. Alors, ma question aux 4 intervenants, je n'ai pas bien entendu ça de vous, peut-être un peu le Mozambique, si j'ai bien compris la traduction. Est-ce que pour la gouvernance la bonne gouvernance entre les entreprises et les droits de l'homme, vos pays respectifs disposent-ils d'un plan d'action national? Le plan d'action national servirait par exemple à mettre en œuvre le plan qu'on appelle les règles des RUGI, donc le plan directeur des Nations Unies de 2011 ainsi que de l'Union africaine je crois que c'est 2023. Est-ce que vos pays disposent de ce plan? Parce qu'il n'y a que ce plan qui permet l'opérationnalisation de la gouvernance entre les entreprises et les droits de l'homme. Voilà. Merci beaucoup. C'était l'unique question.
Merci directement ici. Bref.
Thank you. Thank you. I have interest in the politics of investment. I know that there have been arguments today.
Please introduce yourself.
My name is Peter Kwekwe. I come from Liberia. I work in the Secretariat of Environmental Rights Africa Coalition. My question is to the effect that the question of resources, the commissioner said resources are owned by the people. I've heard one of you say that it is owned by the state. But the truth is that states have human rights obligation to their people. Essentially, and there is record across the continent that almost all the countries across the continent that do investment or concessions, there are violations of rights. What is being done by you governments to protect your people in the face of these concessions that are coming to your countries? Because it seems that there is more concern about your investment as opposed to protecting the people.
Thank you. C'est bon.
Merci. Donc, moi, c'est Colonel Siaka Oumarou. Je suis le directeur général du Bureau national d'évaluation environnementale du Niger. Donc, je voudrais d'abord remercier la Commission africaine des droits de l'homme et des peuples. Excusez-moi, j'ai la gorge qui est un peu... pour m'avoir invité à ce forum qui se tient, comme vous le savez, dans un contexte de bras de fer entre les sociétés occidentales, pour ne pas dire françaises, et mon pays, vous le savez bien. Nous avons actuellement un bras de fer avec la société Orano. Et aussi, je pense que ça marche. On fait les interventions que j'apprécie. La situation
Take another microphone. Vous pouvez prendre un autre micro, c'est plus facile.
Oui, je pense que ça marche maintenant. Donc, on fait en tout cas la situation des industries extractives et on a énuméré un certain nombre de contraintes, notamment ce qui est l'application lâche, il faut le dire, des textes législatifs et réglementaires. On a parlé aussi de la corruption, on a parlé de la symétrie, en tout cas des pouvoirs que nous vivons actuellement chez nous. Donc la faiblesse des États face aux puissances occidentales, il faut le noter. En tout cas, plusieurs points ont été développés. Mais pour revenir au panel, le partage des meilleures pratiques législatives, réglementaires et institutionnelles, je constate, bon, c'est un constat personnel, en tout cas, tous les panélistes sont ici des pays anglophones ou lusophones, pour ne pas dire, pour ne pas parler de colonisation. Et cela veut dire que les autres pays, en tout cas, n'ont pas de belles expériences, ou bien, en tout cas, nous nécessitons vraiment l'appui des autres pays pour nous permettre aussi d'être dans le droit chemin, pour permettre à nos populations aussi de bénéficier, en tout cas, de ces droits, si on peut le dire ainsi. Merci beaucoup.
Merci beaucoup. Let me, I just want to inform the moderator that we took advantage of her absence, and there was a democratic move. They gave us 15 minutes, and we have already consumed like 3 minutes only. So, oh, thank you. Thank you. So, quick one we have here. At least a woman. We need a female intervention. Honorable. Try to be brief as usual.
Thank you. Thank you very much, Chairperson. And since I'm taking the floor for the first time, I'd like to congratulate Commissioner Deso for this very brilliant initiative and for the wonderful interventions that we had this morning during the opening. I think they set the pace, and I think it is in that spirit that I'm taking the floor. So, Chair, I'm taking the floor to just respond to what the delegation from South Africa presented on the conversation. When you say G7, it took me back to the Cold War days. So that conversation must have taken place before G7 became G8. Because at the NEPAD Secretariat, when I worked there, we engaged the G8. And the mindset of the G8-7 had changed. When Russia was admitted and became the 8th G. And we even participated in G8 meetings as a continent through the NEPAD initiative. And then it went further. G20 was born, and BRICS was born. So if that conversation is taking place in 2026, this is a different environment. And so we can say that those statements that were made that time, today may not be very valid. And so this is very good timing for Africa to reposition itself, if I want to be asked, because we saw what happened in Venezuela, and we saw how China and Russia responded. And so we really cannot say we are helpless. And if we are united as a continent and we take our position as a continent, we can have allies. And I think it's no longer our minerals, Honorable Chair, are not just flying to the west as they used to fly. They are flying also to the east. And so we can position ourselves and take advantage. That's what the opportunity I wanted to say. For Zambia, I have a question for you. It's very, very exciting to hear what the country is doing in terms of capturing back its minerals through legislation and also through a government that is willing to look at the problem right in the eye. I have met some indigenous people and rulers, traditional rulers from Zambia, who say that it is true the minerals are on our territory, but guys are arriving here from Lusaka with signed contracts. So we don't know what the government means when it says that these are our minerals, that Zambia's approach has changed. And so my question to you is, are you working in tandem with the traditional territories where these minerals are? Because if what you've just told us is true, then Zambia should be an example of the way to go. Because surely, so I need to hear more from this. So thank you, Chair, and I submit.
Thank you so much. I don't want to abuse, because now she's back. You gave us 15 minutes. Now it's only 5 remaining. So let me give 1 minute. 1 minute. Yes, 1 minute per person. It will be 1 hour, 60 minutes in total. Yeah, because it was 45 minutes. Then you added 15 because she was not around. Then, please, Zambia, start.
Thank you, Chair. Just to maybe try and attempt to address the question raised by Commissioner, well, in terms of what Zambia is doing, in terms of consulting the local leadership. Well, like I said, the starting point for us is the Constitution. That's the starting point. It mandates public participation in terms of consultation. And so when, I'll give an example of...
Straight to the point.
Yeah, so, yeah, we do it. We do it, actually. If you got, I'll pick an example in Northwestern Province. where recently mining rights were actually granted to an investor. The starting point was actually the local leadership. And the president, even when he was laying the foundation stone, the starting point, he will meet the local leadership there, consult with them. Do you agree with this? So there is that mechanism.
Thank you.
I'm sure the person you met was trying to be malicious, but thank you.
A quick one. Litsie.
Thank you very much. Thank you very much, Chair. I think to the first question that was asked by the honourable member of the Pan-African Parliament. Yes, South Africa has a legal policy framework that combines mining and human rights governance. All of that is anchored around our constitution, as I said. We also have the Minerals, Petroleum Resources Development Act and also the Mining Charter. That is what actually guides our country in terms of our action plan. So all of these frameworks, they mandate community development and labor rights and the environmental protection. Of course, it's not that it goes without having its own challenges, and that's why in 2024, 2025, we're going through a reform process that has to do with preserving community rights. Thank you.
Thank you so much. Angola.
Angola também tem, sim, algo para dizer.
1 minute.
Ok. Relativamente à questão do plano operacional entre empresas, direitos humanos, recursos que estão a ser feitos para as comunidades locais, Angola também não está distante. Ou seja, Angola tem o decreto presidencial 51/24 e exige as boas práticas de Angola. Ou seja, Angola, por ter ratificado as convenções, as suas convenções junto da Comissão Africana e da Declaração Universal dos Direitos Humanos, ela também não está distante. Ou seja, Angola também tem, sim, um código mineiro que ela obriga aquelas comunidades, ou seja, a receber 10% deste valor. Isto é uma imperatividade que vem da Carta da União Africana, ou seja, em Angola, devido ao facto de ter ratificado o acordo junto da Comissão Africana, automaticamente esta lei obrigatória ela entra diretamente para o ordenamento jurídico angolano e são de caráter obrigatório junto dos tribunais angolanos, uma vez que estes acordos estão ratificados. Então, nós não temos muito esta problemática da questão dos 10%, uma vez que é uma obrigação uma obrigação constitucional,
Merci.
uma vez que já está legislado.
Obrigado. Obrigado. Moçambique?
Muito obrigado. Sim, eu vou responder de forma direta à questão que me foi colocada. Se o Plano Nacional de Negócios e Direitos Humanos permite uma governança entre as empresas e o governo, acho que foi essa a questão. Dizer que este documento é um documento que permite o governo impor o respeito de direitos humanos nos negócios. Portanto, é uma forma do governo intervir no setor de negócios e exigir que haja o respeito de direitos humanos. O que assistimos, o que forçou este plano? É que havia violações de direitos humanos. Tivemos reclamações de funcionários ou empregados que trabalhavam acima das horas, trabalhavam em condições deploráveis e também assistíamos à questão da poluição, a questão da destruição das machambas e a questão de não compensação pelas empresas. Então, é uma forma do governo impor-se no setor da indústria extrativa e exigir o respeito dos direitos humanos. não é uma política para regular a indústria extrativa. É uma política para exigir o respeito de direitos humanos no meio dos negócios. Muito obrigado.
Merci, merci. La dernière question qui n'a pas été répondue, c'est celle qui a été posée par le distingué représentant du Niger. Pourquoi c'est ceux qui parlent portugais et peut-être anglais qui sont là? Est-ce que d'autres n'ont pas d'expérience à partager? Je peux seulement répondre que c'est le fruit du hasard. Il y a eu d'autres interventions avant. C'est comme elle disait, j'aurais bien voulu être dans le panel précédent. Donc c'est toujours un hasard. Donc c'est comme le premier panel qui était avec Solomon. Il y avait 3 Kenyans sur 4. C'est un hasard. Ce n'est pas voulu comme ça. C'est par rapport à la matière et puis ceux qui peuvent venir présenter la matière, mais ce n'est pas parce que c'est seulement les Kenyans qui ont quelque chose à partager. Voilà. Merci beaucoup et thank you so much, moderator, for your indulgence. And thank you so much for the audience. Thank you so much for the panelists. A round of applause, please. Thank you. Bye-bye. Okay.
Thank you very much, Your Excellency, Ambassador Willie Nyamitwe. Thank you to the panelists for the bonus time that you awarded to yourselves. Thank you very much, Your Excellency. Let's see Osula Mateko of South Africa, Excellency Mr. Josias Masi, Mr. Daniel Masukini, and Mr. Chunga. Now we have come to the last session for the day. It's 1 hour past the time that when we should have been wrapping up for today. I would like to kindly ask you to indulge us to take one more session, and then tomorrow we'll start with session 7 because tomorrow there are 2 events. The forum will take place for up to half the day, and then we would have a consultation on general comments on the right to environment that is also being developed. So we would like to maximize today as much as possible. So please kindly indulge us. So now we're going to session 6, and this is a session that talks about complementarity in action, balancing economic development and human rights in extractive industries through the African Commission and court systems, insights from the Ogie case. Now, I have a request to make sure that the room is awake during this presentation. The presentation will take 30 minutes, and I wouldn't want to introduce any strenuous exercise. I would just like us to do what they do at the African court. From the first time I went for the public hearing of the court, I found it very interesting. I'd like us to please rise, and I will just say, court as Her Lady Justice Stella Anukam takes the podium. Court. Thank you so much. A round of applause for her, please.
Thank you so much. Please be seated. Yes, I think there's a moderator for this. Okay. I want to introduce her.
Yes. Madam Clementine, please, you will take the podium. My apologies. I think I was getting too excited that we're coming towards the end of the day. Mrs. Clementine Inamuntu from APRM, thank you very much. Justice Stella Anukam has the podium. I'll give the microphone to do the introductions, and then you take the podium while she makes her statement. I thank you.
Good afternoon once again. Yeah, my name is Clementine Nyinaumono. I'm here representing the African Peer Review Mechanism, which is an organ of the African Union in charge of promoting good governance. So I'd like to take this opportunity actually to thank the Commission for inviting us to be part of this important forum on human rights. So now our session, which is going to focus on the complementarity in action, I'd like to briefly introduce Lady Justice Stella. she serves our continent as a judge at the African Court on Human and People's Rights, where she was elected since July 2018 until now. She has extensive experience in the legal matters for more than 35 years. So she's going to take us through this important concept of complementarity or complementarity model between the Commission, the African Commission on Human and People's Rights, and the court. And she's going to do that using the case study of the case of Ogiek community in Kenya. A community, when I was doing my research, that dared to challenge the state, the Kenyan state, by bringing a case to the African Commission, which ended up into the hands of the African Court. So I think it's going to be very interesting. I'm going also to learn a lot about that kind of, complementarity between both the court and the commission, because we very often hear that, with the challenges that the African continent and the African people face, we always face the question, what is the role of the AU? What are they doing about A, B, C, D? So I think this is really a practical case that is going to give us some insights into what can be done using this case. So, Lady Stella, so I think you have the floor, and thank you for availing yourself to explain to us the work of the Commission and the court. Please take the floor.
Thank you so much, ma'am. You take your seat.
Yes,
Okay.
please, Justice Anukam. My apologies. I actually think I'm missing a page of the program. Yes, so I have the wrong, we gave the nice ones to the participants and I got this one. So I don't have a page. We should also have on the stage at the moment those who are going to react to the presentation by Honorable Justice Stella Anukam. We have Mr. Daniel Kobe of the Ogiek People's Program. We have Ms. Esther Finda. Am I reading the right program? Okay, Commissioner. So because I have a program, Commissioner Deso's program, there's a mix-up. Commissioner Deso is the one that is missing one page. Yes, so I'm right? So it's just Justice Anukam. Okay, and then you will take the interventions. My apologies, please. Thank you very much for your understanding. Thank you. We apologize. This is the one that has a problem. I thank you.
Right, thank you so much. Good afternoon, distinguished ladies and gentlemen. Permit me to also stand on the already established protocol. The day seemed to be fast spent, but we need to do what we have to do. I would like to begin by bringing greetings to us from the president, the vice president, the judges, the legal officers, and indeed the African court family, all the way in Arusha, Tanzania. The seat of the court is Arusha, Tanzania, for the benefit of those who do not know. And I also want to appreciate the Commission for our involvement in this very important forum. I have learned a lot on my own path since the beginning, and I will have a lot to take back home. So I commend Honorable Solomon, who I've known for a very long time, simply on extractive industry. He has been so consistent, so diligent, and he's so glad that he's still pursuing and that he's still so passionate about it. And I think the time has come when we begin to pluck the fruits, especially with all that we have had today. That being said, I also feel that we should also pay tributes and attribute some kind of accolades to the founding fathers of the Union, then the African OAU then, now AU, for the legal framework that resulted in what we are discussing today. Very tight, very robust, very comprehensive. That is the legal instrument, the African Charter on Human and People's Rights, particularly Article 21, 22, and 24 that have been the bedrock of our discussion all through the day. You can all agree with me that is so very tight. It's a legislation we all should be proud of, and it's still living. It seems as if they lived in the present time. It seemed to me they anticipated the challenge we'll be facing in the industry, in the extractive industries, when they put together those particular articles in the African Charter on Human and People's Rights. So, in essence, what am I saying? Regarding legal framework, there is no problem at all. Regarding the laws, there is no problem. But understanding and cooperation, collaboration has been the issue confronting us in the continent. And as far as this topic of complementarity in action, I'm going to be very brief, straight to the point, because we are using a case study which already is reported everywhere, discussed, this landmark case of the OGIG. I'm sure a lot of us are familiar with it, so I would not talk too much about the case, but to say it's a reported case. You find it in our law reports, and you could also go to our website if you want the nitty-gritty of the judgment. And this judgment is also so peculiar in the sense that it's in this judgment, we have 4 judicial decisions. First, there was an order for provisional order, and then the judgment on merits. Then we have the judgment on reparation. And last year in December, the judgment following the compliance hearing. So this case is indeed very unique in all these aspects. And I'm glad that it's forming part of the discussion at this forum, the Extractive Industries, Environment, and Human Rights, organized by the working group. That being said, I am sure my paper is already showing on the screen. I think I'll be fair to all of us if I just stick to what I have in my PowerPoint presentation, because the time is so well spent. So this presentation will examine how the interplay between the African Commission and the African Court addresses the tension between economic development, human rights in extractive industries, drawing from the OGIG jurisprudence. It's going to be in 8 parts. Briefly, very brief, in all the slides are all very brief. First, the introduction, who are the OGIG people and what actually happened. We'll have a brief summary on that. Then complementarity in action, the legal architecture. Then we look at the complementarity in practice, the OGIG case in the 5 steps. Then balancing economic development and human rights, the core tension. Then we look at the 3 doctrinal pillars from the OGIG jurisprudence, and then we look at what the court ordered, the merit stage, reparation, and compliance. Then we look at key lessons and the way forward, which I think is what we are all interested, and then we'll conclude. So we'll progress that way. I'll go to the next slide. The introduction, who are these people? The OGIG people. I have one of them live here with me, with us. Yes, that is him. And what happened? Yes, the OGIG, also called the OKIG, a forest dwelling hunter, gathered indigenous community of Kenya. In essence, they are indigenous people, indigenous community. At least that was the pronouncement we made at the end of the at the end of the deliberation and consideration of the application before us. They occupy the greater Mao Forest complex on the Mao escarpment. Their very name means caretaker of all plants and wild animals. Their culture, religion, livelihood, and identity are inseparable from the forest. So you can imagine how the forest is so dear to them. They are forest dwellers, hunters. I think that's already said. Then the pattern, then this group of people, over time, we are facing all manner of eviction from this forest that is so close to their heart. Over a century of forced removals, beginning under the British colonial administration, it progressed to presidential decrees, excising more forest blocks from the non-Ogiek settlers and private concessionaires, corporations. Then commercial logging and tea plantations, fragmenting the Ogiek customary territory, like an abuse of the territory. State-framed evictions as conservation evidence showed extractive exploitation by the non-Ogiek actors caused the deforestation. The trigger. In October 2009, precisely on the 26th of that month, of that year, the Kenyan Forestry Service issued a 30-day eviction notice to the Ogiek from the Eastern Moa Forest Reserve. Then this group of international NGO with observer status at the African Commission, they approached the Commission in communication 381/09, and they assessed the Commission. They had the audience before the Commission on the 14th of November. And the case before the Commission contained allegations of violations of Articles 1, 2, 4. All these are articles of the African Charter, majority of them, and I think ICCPRO as well. Complementarity in action. So how did the courts get in? Recall I said it started at the Commission. And complementarity, by the way, is the courts and the Commission working together, complementing one another. The courts is a baby of the Commission in a sense, because the protocol establishing the courts says that the protocol establishing the court gave us a protective mandate, and before then, the Commission enjoys a promotion and protective mandate of of our rights across the continent, human rights across the continent. Then with the subsequent establishment of the court, we were required by our protocol to complement that mandate already enjoyed by the Commission. So the principle of complementarity is the organizing framework of the African human rights system. It is the constitutional design through which both institutions jointly deliver accountability. The court shall, this is Article 2 of the court protocol, it provides that the court shall, bearing in mind the provisions of this protocol, complement the protection mandate of the African Commission on Human and People's Rights that has since been in existence, actually created by the Charter itself. So the African Commission, which is a 1987 legal instrument in Article 30, created the Commission. That you will see on the left-hand side, my own left-hand side on the screen. So what is unique about the Commission, the Banjul Commission? They allow a broad NGO and individual standing under Article 55 of the Charter, the gateway for affected communities. They are also a fact-finding body, and they can also make orders for provisional measures in urgent situation. And then they are politically, or they also can make politically authoritative recommendations to the AU, and they have direct referral power to the courts under Article 5.1a of the court protocol. In fact, they are number one, and then they have a normative standard setting through the various, its working group. Then for the courts, which is a later creation, created in 1998 protocol, which came into force in January 2004, with ratification by the 15th state party. The court on its own can make binding judgments enforceable by the AU Executive Council under Article 29.2 of the protocol. So for those who do not know, because I'm always asked this question, what is the problem with the implementation of the decision? You can tell from Article 29.2 that that question should actually go to who? The Executive Council of the AU. Then we have provisional measures under Article, we can also make provisional measures under Article 27, sub 2 of the protocol. In instances where there's urgency and then to avoid irreparable loss regarding an application that has already been filed before us. So just in the domestic cause, we could say to preserve the recs, we can make order of provisional measures. And we did so in the Oge case, and I think the commission equally did so, but the order was not obeyed, and the commission had to approach the courts. And the first step we did was also to make an order for provisional measures with the effect of suspending the eviction notices. Then the court also have the power to make comprehensive reparations order, including land restitution, compensation, and all that goes with reparation. Because in our article, Article 27 says, having found a violation, what do? You need to remedy the situation. You need to remedy the damage that has been caused resulting from the violation. And that means we have the power to make an order for reparation, including compensation, which we did also in the Oge case. And the reparation can come in different forms. We have public apology, we have compensation, restitution. The most formidable one for me is the call for legal reform or institutional reform. Because once a country does that, I think that is the end of the matter. It prevents a reoccurrence of the matter, of the violation, the alleged violation. So to prevent repetition, we just say, change your law, amend your law. Especially in cases where there's massive violation. I'm sure you must have heard of the case on urbanism. We had to do that for Tanzania. Yes, we made an order for a change of law. And also in Tanzania, we have also made an order for change of law in the case of their electoral, the provisions they have in their constitution relating to election. For example, you cannot challenge anyone who is pronounced as the president after an election. I would say no, that is contrary to the provisions of the charter that allows for political participation. And we also have a popular, another landmark case on election, which allows for independent participation in politics. You can stand as an independent candidate. We also have a decision on that, which is Reverend, the case just, I'm tired, but yes, thank you. That is Reverend, no, there's a particular, yes, thank you. So we also have compliance hearing. This we introduced recently, and I think in 2022, where we amended our rules to allow for compliance hearing. And you asked us, and we have been asked over time, who gave you the power? What instrument gave you the power to do so? We said, no, we drew our, our powers from the protocol establishing the court. Because in the protocol establishing the court, I think Article 30, we are required to, we have a reporting obligation to the heads of states and the heads of government and state. And then in making our report, we are expected to mention states that have complied with our decision. So as far as we are concerned, to effectively discharge that mandate, we will need to organize the compliance hearing so that the states can come before us and tell us if truly they have, it's possible they have complied, but we are not aware. Even though in all our judgments, we usually request the respondents to tell us, the parties, to give us information on the compliance with our decision within a period of 6 months once the judgment is delivered. And we realize that some states actually do comply, but they do not give us that information. And because of that gap, we needed to start having compliance hearing, like our sister called the Inter-American Court. Because when we do have compliance hearing, then we'll be so sure beyond all reasonable doubt the extent of compliance with our decision. And then we can now report to the summit the level of compliance, either partial or full, regarding the decisions that we have given. Complementarity in practice, I hope I've not jumped any slide. You are my guide. The OGA case is the locus classicus of operative complementarity. Every major modality of the commission and the court cooperation was deployed in this particular case. Short of repetition, in November 2009, the commission itself was seized of a communication 381/09, and the commission immediately, from a group, from an NGO that has an observer status before them concerning the Ogiek population, and the commission immediately issued urgent provisional measures requesting Kenya to suspend the eviction notice, but Kenya failed to comply. What did they do next? So in 2012, there was a referral to the court. The commission referred the case to the court under pursuant to Article 51A, which is on access to the court, and the commission is mentioned as the first organ there that has access to us, instituting application 006/2012. This step became indispensable. Kenya has not made, because Kenya, as at that time, and unfortunately till today, had not made the Article 34.6 declaration enabling direct access of its citizens and NGOs to the courts. So this Article 34.6, I would like us to look at it, seems to be a barrier or an obstacle preventing citizens across the continent and NGOs from having direct access to the courts. Because until the state party that has ratified the protocol establishing the court makes this declaration, the citizens they have no access to the court. Neither do NGOs have access to the court. And as of today, we have just 7 that have standing or active declaration, that their declaration are still active, in the sense that there were some that had made the declaration before, but they have withdrawn. In that category, we have Rwanda, the first to withdraw, with the complaint that the court should not entertain any matter that has to do with the genocide. Following, we have Côte d'Ivoire, then we have Benin, then we have Tanzania, and then one is already in the pipeline, Tunisia. So that is the challenge we have. That is the challenge of facing your courts. It's our courts. So we are not owning that challenge alone. It's a challenge for the entire continent. So Kenya had not yet made the declaration, so they could not assess us directly. But based on complementarity, their alleged violation could be entertained by the courts based on complementarity and the right invocation of that particular complementarity principle backed with a legal backing by the commission. Then in May 2013, the court issued provisional measures as well. The court ordered Kenya to suspend all land transactions in the Mau Forest and refrain from any act prejudicing the application. The court finds the risk of irreparable harm to the Ogek right, because that was the basis for making that order, as I said earlier. Where we anticipate irreparable harm, we can make an order for provisional measures. In May 2017, the court delivered this judgment on the merits. The court finds 7 violations of the African Charter. We can see Articles 21 and 22 there. Article 1 is the fundamental article. Once there's a violation of any article, Article 1 becomes relevant. Conservation defense, which was brought up by the Kenya, was emphatically rejected. They also raised the issue of development, and we say no, because we are talking about the rights of indigenous people, and the number of victims involved, 35,000. Then in 2022 and 2025, reparation and compliance, the reparation judgment was delivered on the 23rd of June, 2022. And in this case, by way of reparation, Kenya was requested amongst others, which you will find in details in the judgment, to make a whopping sum to pay a whopping sum by way of compensation of 157 million Kenyan shillings plus the equivalent of about 1.4 million US dollars to a fund. We actually established a fund, a compensation fund, because if there was need, as at that time, we could or not on our own determine the victims. But we created a fund where this money will be paid into, and then we expected the government, in consultation with the indigenous people, to know who the victims were. We also talked about giving the Ogiek people collective land title, and also consultation with them regarding the implementation of the decision based on the free, proud, and FPIC, free, proud, and intentional consent, informed consent from the persons, because that was another issue. They claimed that they were never consulted. So government needed to evoke this principle of free, prior, and informed consent from the persons involved. And on the 4th of December 2025, the court's first ever compliance decision was heard. It was a public hearing. Kenya was there in full force, and I commend Kenya for that. They were there, and they had to explain why there was yet to be full compliance with the decision given as far back as 2017. And at the end of the day, the court judgment was that there weren't full compliance with our decision, And again, we requested that they should comply and they should also notify the court of full compliance within a period of 6 months. So now, today we're in May. Yes, one will expect that by June, we should get a report. The 6 months would have almost run out, and it's almost running out. So by June, we expect that we are expecting to hear from Kenya, and I know they will, especially after the discussion of this particular matter in a forum like this. And we have a lot of them around, our good friends. Balancing economic development and human rights. Yes, this is where I've been urging to come to. Complementarity in action, the legal architecture. The principle, am I correct? Okay. The principle of complementarity is the organizing framework of the African human rights system. This is in no doubt at all. It is the constitutional design through which both institutions jointly deliver accountability. I think this is repetition. Are you sure? I told my sister she should reschedule us for tomorrow, but she refused. Okay. No, I think I should be in slide 7 now. Yes. Yes. I think this is where I should be. I should be here. Balancing development and human rights, the core tension. Although Kenya framed the Mao forest eviction as conservation, the underlying reality was an extractive frontier. The cost analysis establishes principles directly applicable to mining, oil, gas, and agribusiness projects affecting indigenous communities across Africa. These Kenya's arguments, and any one of us can read this judgment. The Mao Forest is a critical water tower and biodiversity reserve requiring protection. Defense number 1. Defense number 2, eviction serve the public interest in conservation and national development. Argument number 3, the Ogiek was not a distinct ethnic group entitled to special charter protection. Argument number 4, domestic costs and mechanisms are adequate. And before now, you will know, you will agree, and I'm sure you are familiar with our Article 56. Before you can approach the African court, you must have exhausted local remedy on the issue you are bringing before the court, except where the local remedy does not exist or is unduly delayed. So as expected, this group of persons, the Ogiek, they have a lot of litigation had already been heard at the domestic level. So there was clear, the African court was convinced that there was exhaustion of local remedy. And you know, one unique thing about our charter is human and people's rights. So the litigation must not be by the victim. Anybody could. So the issue of local standard is not applicable to us. Any one of you, especially where there is a massive violation and public interest litigation, the matter can be brought before us on behalf of the direct victim, which is what happened in the Ogiek case. So what did the court do? The court finding, the court found that the Ogiek met all 4 Diaz criteria. That is one special rapporteur of the UN on indigenous persons. She established certain criteria to determine who is or what group of persons are indigenous population. And we went through that criteria and we found out that the criteria was completely met as far as the Ogiek people were concerned. The Ogiek met all the 4 Diaz criteria for indigenous status, priority in time, voluntary cultural distinctiveness. You heard me tell you that they were hunters, and identification, and experience of marginalization. They were truly marginalized as at then. Conservation too. Conservation cannot justify dispossession of an indigenous people. We find that in paragraph 130 of our judgment. And fourthly, and thirdly, that the Ogiek did not cause the Mao forest depletion, which was an argument attempted to be used against them. Commercial logging did. So the commercial logging taking place there, what was attributable to the depletion of the Mao forest, not the existence or the occupation of the Ogiek persons. Lastly, that the 7 charter violations were established. We found that those charters violation were established, articles 1, 2, 4, 18, 17, 21, and 22. The preservation of the Mao forest cannot justify the lack of recognition of the indigenous or tribal status of the Ogiek and the application of the rights linked to such a status. That's a quotation from our Mary judgment at paragraph 130. Okay. I will also round up, there are just 11 slides. What the court ordered from declaration to remedy. Mary judgment 2017, May 26, 7 violations found established, conservation defense rejected, first indigenous people's case, and first public interest case on the merits. The number of victims, huge, 35. Largest case decided by the court at that time. I think this is overtaken by the Lido case and the other case on urbanism. Kenya ordered to take all appropriate measures within a reasonable time frame. And we have also improved in our judgment by now, by not just saying a reasonable time frame. We give precisely clear timeline. And in this case, we gave them 2 years, if I'm right, yes. So we're very clear about our timelines, and we expected that the respondent state will comply with the timelines given. And if there is any need, remember our protocol also allows for review of our judgment. If there's any need, particularly with notification of regarding implementation, we always do grant extension. But we did not hear from them. Did we hear from them? Maybe we did, but we were not satisfied. Reparation judgment. Reparation judgment for material prejudice. You know, there's material prejudice and there's moral. For the material prejudice, it has to be proven. And having had the submission by the commission, the African Commission, who was before us as the applicant, we were justified. We found it justifiable, justiciable, and justifiable to make this award. The equivalent of 445,000 US dollar for material prejudice. Then for moral prejudice, moral prejudice follows, that is solely at the discretion of the court, because once we find that there is a violation, the court has the discretion on the basis of equity to also award moral prejudice. This does not have to be proven. And in that sense, we found, we made a finding requesting the judgment, the respondent state to make an amount of 700 and the equivalent in dollars, 770,000 US dollars payable to the fund. Recall I said we called for an establishment of the fund, of a fund. Then collective land title. We asked for delimitation and demarcation within 2 years because, you know, they had no title. Then also on the issue of free, prior, and informed consent, recognized as a legal binding obligation on the part of the respondent state. there was need for consultation. We said over and over in that judgment that they should identify, they should not do anything without the involvement, without due consultation with the representative, accredited representatives of the people. And then community development fund, yes, to be established within 12 months, and then publication of both judgment. Why do we always ask for publication? Because we do know that when the judgment is delivered in Arusha, only few people are able to come. But this judgment is binding, and everybody is expected to be aware of the judgment. So we do require the respondent state to publish in their journal, in their law, in their website most time. We request that they make this publication so that the people are enlightened, are also aware of the judgment delivered. Then this is the first African judicial precedent for indigenous land restitution. And this particular case has been discussed in different fora, not just within the continent, in fact, even outside the continent. Compliance decision. Yes, as I said earlier, the court's first ever compliance ruling also formed a historic precedent in the sense that Kenya came before us, and all this while we were just fulfilling our reporting obligation without really determining the extent of compliance, both effectively and efficiently. So, but with a compliance hearing, we were clearly able to hear directly from Kenya and also from the commission as well, the extent of compliance. And Kenya was found in full non-compliance. I recall that I asked the day of the hearing that, what will it cost you to publish the judgment? That is a hanging fruit. And they had nothing to say. But so even the simplest one that we expected they could have done, which is the publication, to create the awareness among the different governments. You know, in government, in implementing the decision, we can understand it could be very challenging because different organs of the government are involved, and we are aware of bureaucracy in government. But when you create the awareness, it becomes easy for everyone to buy into it and begin to prepare themselves to see, to playing their parts in the implementation of the judgment. So that is the reason why we always agitate for publication, create the awareness. So that was also one of the order made, and we also found out that there was no compliance, no payments. The fund was yet to be established, no demarcation, no fund, no publication. Fresh orders, so we had to make fresh orders for immediate payments and urgent land restitution process. We further detailed implementation plan. We further required them to come up with a detailed implementation plan within 6 months. And we also made them to understand after the compliance hearing and by way of our decision that domestic law cannot override international obligations. Because that was also one excuse, one of the defense they put forward. I would say no. Once you are a signatory to a treaty under international law and the Vienna Convention, you have submitted yourself. Especially for us as a court, whose mandate is to interpret and apply the African Charter on Human and People's Rights. Our expectation is that, and I think it's legally binding, is that the 34 state parties that have ratified the charter, the 54 state parties that have ratified the charter, except for Morocco, we are waiting for Morocco, and the 34 that have ratified the protocol, they have submitted the issue of sovereignty because they keep always raise the issue of sovereignty. We are a sovereign nation. We are a sovereign nation. We have our domestic judicial structure. No. This is international law because you have signed, you have ratified the treaty. So you have submitted to an extent. But we do appreciate the doctrine of margin of appreciation. So we know the level that we also deal with as an international court. We recognize that certain things like evidence, yes, we recognize that doctrine of margin of appreciation. We do recognize that. But fundamentally, and by way of international law and all the principles in international law, domestic law cannot override international obligations. I'm happy that our friends from the PROC, they are here. I can see my sister there smiling. South Africa, yes. Where is the big man? Willie. We need to educate. I think there's something missing. There's a missing gap. Our political leadership, they are quick to sign. They sign all these treaties. But when it comes to implementation, something tells me, and this is personal, that they need to know the nitty-gritty and they need to be properly advised. And I want to use an example to illustrate this. 2 minutes, yes. I will give you this example. For example, as I said, a lot of countries are withdrawing from their declaration, and then some have not even recognized the court, their court. It's not our court, it's their court. 34 state parties have ratified the protocol establishing the court out of the 55 of us in the union. And you ask yourself why. And some people have asked, why do we as a court go on sensitization? It's because of the level of ignorance among our political leadership. I'm sorry to say, with all due respect. So there was a situation, we had such sensitization to Niger, and that is how Niger made the declaration. The group that met with the president. And we said to the president, and they said to the president, how come Niger has since ratified the protocol establishing the court, but still at the same time, Niger, you are denying your citizens from having access to the court. And the president said, what? What exactly are you saying? We said, yes, that is the truth. That is the reality on ground. He immediately summoned the Attorney General. And when the Attorney General came, he told the Attorney General, what is preventing us from making this Article 34.6 declaration? And that one said, once we make that declaration now, you see all these people, all these NGOs, all these critics, they will take us to the court. That one said, is that so? He said, no, I do not agree with that. If it means you are doing something wrong. If you are not doing something wrong, why are you afraid to be summoned for the African court? He said, we have our domestic judicial structure to take care of all violations. He said, no. Please, what am I expected to do as a president? I take full responsibility. And then he made the declaration. And you ask me, so since they made the declaration, how many of them have come to Arusha based on an alleged violation of their rights? Not yet. So I really don't know what the apprehension is about. Ghana has since made the declaration, but how many? Because that requirement in Article 35, Article 56 that talks about exhaustion of local remedy is paramount. It's very instructive. So before you come to us, it's expected that you have exhausted the remedy available to you at the domestic level. We are not like the ECOWAS court. We are like the other sister human rights courts. You exhaust local remedy. It's when you are not satisfied, you come to us. Just like every other, like ICC, International, and all that. So I'm rounding up. Yes. That is why I need to keep to my notes. I'm too. It's not easy to ask a judge to talk. Okay. Yes, I'm actually lessons and way forward. I think this is what my brother wants to hear. Lessons and way forward. Key lessons, what the OGE jurisprudence establishes. The OGE jurisprudence consolidates binding principles for states, corporations, and communities across the Africa's extractive sector. One, there are just 6 of them. Indigenous identity is justiciable in Africa. The working group criteria are settled African law. So the law is not gray in any way. The legal framework is firm, is strong. Collective charter rights attached as a matter of obligations on state parties. 2, public interest and conservation are not blank checks. States must demonstrate genuine necessity, proportionality, free, I keep mixing this thing, free, proud, and informed consent, and consultation in short, and benefit sharing. The burden of justification is high and closely scrutinized. 3, disposition is reversible. And I think this is very important. Disposition is reversible. Restitution is the primary remedy. Concessions granted to third parties, and we made this so clear in our judgment, on indigenous ancestral land must be renegotiated or unwound. Renegotiate them. They are not perpetual. 4, Article 21 anchors resource sovereignty. Indigenous people as a people under the Charter hold the right to freely dispose of natural resources. And that is so clear in the Charter. Denial of access is itself a violation. 5, complementarity multiplies accountability. The Commission's gateway function and the court's binding authority are strongest when used together. Neither the Commission nor the courts alone are sufficient to do what we did in the OGE case. So the 2 of us coming together, which is complementarity, will make a difference. 6, implementation is the unfinished frontier. 9 years after the Mary judgment, Kenya has not complied. But Kenya will say they have complied, I hope you know, or they are in the process of complying. The December 2025 compliance decision demonstrates the court will not look away. We will continue to ask questions when we need to, and we also expect answers. The broader African jurisprudence, I think I can skip this. You can just read it, it's there. Yes, because time, I'm concluding now. Conclusion, towards sustainable accountability in the extractive industry. The OGE case is, in equal measure, a triumph and a cautionary tale. A triumph of the African human rights architecture and a cautionary tale about the limits of adjudication without implementation. The institutional complementarity built into the court protocol enabled an indigenous community without direct court access to obtain a merit judgment, a reparation order, and the court's ever compliance ruling. Complementarity in action achieved this. The Commission's quasi-judicial function and the court's judicative function have been deployed in concert to articulate with growing precision how the African Charter constrains state-led extractive and conservation projects affecting indigenous people. The remaining frontier is implementation. The credibility of the African Commission, the African Court, and the AU's commitment to Agenda 2063 depends on whether the OGE finally come home to the Mao Forest under collective title. For extractive industry, contests across Africa, mining, oil, gas, hydrocarbon corridors, and the agribusiness, the OGE jurisprudence is now the African template. The FPIC, proportionality, resource sovereignty, and land restitution are binding obligations. They are no more aspirations. On this note, I say thank you for listening. Merci beaucoup, obrigado, gracia, asante, sana. Karibu sana. Sorry I took some time. I apologize.
Okay, thank you for a very insightful presentation. It took too long, but it's also that critical time. So I'd like to thank the audience for really being patient. It was an interesting case. And I think she really did the justice to the objectives of the session. One, which was to explain the complementarity between the commission and the court, and we saw that their working together actually led to the success of the indigenous community in Kenya. Number two was to really take us through the development and human rights. So I think I wish we had really time to really ask questions, but let's see if there is a burning question among the audience. Please, please, please. Okay.
Question to borrow.
Okay, okay. Thank you for everyone. Thank you to our presenter. Let's just listen to the commissioner. He wants us to stop. Thank you so much.
Thank you very much, Madam Clementine and Honorable Justice Anukam. Thank you. We're very sorry that we brought you at the end of the day. It was a difficult exercise that we gave you, but thank you for holding the attention of the room and for doing justice to the topic. We hope tomorrow that there will be an opportunity for people to pose any questions or comments that they may have on the Ogie case which has been presented. It's been a long day. We resume tomorrow at 9 and we'll start with session 7 tomorrow. I thank you very much. Have a good evening. Thank you.